The inquiry is open. Hopefully everyone can hear me okay. I believe the live stream is working. We can't see it here because the Wi-Fi is not working at the moment, but I believe there is, it is running through other means, and hopefully people watching from other places can see and hear everything okay, but do let me know if there are any issues. First of all, just make sure phones and other devices not in use for this event are switched off or turned to silent, please. There is no fire alarm planned for today, so if an alarm does go off, please assume it's for real and follow the fire escape signs to the outside. My name is Tom Gilbert Waldridge. I am a Chartered Town Planner and I am the inspector appointed by the Secretary of State to hold this inquiry. The inquiry is into an appeal made by the Hignett Family Trust under Section 78 of the Town and Country Planning Act 1990. It relates to the decision of Bath and North East Somerset Council to refuse planning permission for development proposed at parcel 4234 at Coombe Hay Lane, Bath. The development proposed is a hybrid planning application seeking outline planning permission for phases 3 and 4 for up to 290 dwellings, as well as landscaping, drainage, open space, allotments, footpaths and emergency access, with all matters reserved except access from Coombe Hay Lane via the approved Phase 1 Spine Road, with details of internal roads and footpaths reserved. And there is also a detailed planning permission sought for the construction of the Spine Road from Phase 1 to and through Soulis Manor and associated works comprising the demolition of existing dilapidated buildings and tree removal, drainage, landscaping, lighting, boundary treatment, and the erection of 4 bat night roosts to enable construction of the Spine Road with the ecological mitigation on Derrymans and the field known as 30 acres. I shall begin by taking names of those who wish to speak, and so please let me know if you do wish to speak and any preferred titles you wish me to use. If I could first of all ask the appellant's side to introduce themselves, please, and I believe on my right.
Thank you, sir. Good morning. That's me. My name is Paul Tucker, King's Counsel. I appear in this matter together with my learned friend, Ms. Jackson. So I've taken the liberty of putting pen to paper, and you have a full list of our witnesses. And so I'm afraid it's a long one, but I won't read out all of their mini CVs that we've produced. So in due course as formal witnesses, I anticipate calling the following. Antonio Pinto in relation to matters of highways, Simon Cale in relation to matters of landscape, and then, sir, if you skip to the end, you'll see Peter Frampton with regard to planning. So in relation to other areas upon which we may hear from the respective witnesses who provided evidence, sir, so whether by round table or otherwise. So those are Mr. James Stacey, who deals with affordable housing, Dr. Laurent Duverger, who deals with ecology, Lynn Jenkins, who assists in relation to Laurent Duverger's evidence from Kestrel Wildlife Consulting, Richard Smalley, who deals with issues of archaeology and heritage, Jonathan Smith, who deals with heritage matters, Ben Rose, who deals with matters about trees, and then in relation to issues of lighting, Bonnie B, whose various qualifications are at the bottom of page 2. So I hope that's a helpful way of setting it out. Thank you, sir.
Thank you, Mr. Tucker. And if I can ask now the Council to introduce their side, please.
So good morning. I hope I can be heard clearly. So my name is Stephen Morgan. I'm counsel, and I'm instructed by Mr. Simon Elias, who's a senior lawyer with the Place and Legal team at Bath and the North East Somerset Council, so you no doubt have their details on file. So in terms of witnesses, I will be calling 2 witnesses in relation to the formal part of the inquiry, and that will be firstly Miss Anne Priscott, who's the director of Anne Priscott Associates Limited, and she will be dealing with landscape issues. And secondly, sir, Mr. Mark Reynolds, the managing director of Context Planning, dealing with the planning issues, including the overall planning balance. So with regard to the round table session, we have Miss Jane Baldy, who's the Senior Conservation Officer, Bath and North East Somerset Council, and so that's dealing with the heritage issues, of course.
Thank you, Mr. Morgan.
Thank you, sir.
Thank you. And then for the Rule 6 Party, we have Coombe Hay and South Stoke Parish Councils acting together as the Rule 6 Party, and their advocate is Mr. James Neal. Who would you like to introduce yourself and your team, please?
Good morning, sir. Yes, just to confirm, I'm James Neal. I'm the barrister representing the Rule 6 Party, Coombe Hay Parish Council and South Stoke Parish Council. So you would have received 2 proofs of evidence from the Rule 6 Party. The Rule 6 Party intends to call Mr. John Russell, who sits to my left, of Motion Transport Consultants, whose proof you've received, and he'll address you, sir, on highways matters. And although he's not here today, the Rule 6 Party will also wish to call Mr. Tim Waters of Renew Planning, whose proof you should also have received, who will address you on planning issues and the planning balance. To Mr. Russell's left, sir, is, just by way of introduction, is Mr. Malcolm Ostwick, the chair of Coombe Hay Parish Council, who is for today, the client representative of the Rule 6 Party. So just say that to avoid any confusion, with your permission, sir, I won't be attending the sessions on landscape or the later sessions this week. Mr. Ostwick and another representative of the parish council will be here in my place.
Okay.
Okay.
That's fine. Thank you very
much,
Mr.
sir.
Neal. Thank you. Then in terms of other people who wish to speak at the inquiry, I've been notified of a number of individuals, so I'll run through the list that I have, and if there's anybody else, or if anyone's missing, you're not here yet from this list, then please let me know. So I have Councillor Fiona Gawley, who's the Ward Councillor for Bathhaven South, Councillor Joel Hurst, the Ward Councillor for Odd Down, Councillor Ian Hassell, the Chair of Planning Committee, Councillor Matt McCabe, the Cabinet Member for Built Environment, though I appreciate he's not here, and I think his statement is going to be read out by Councillor Hodge. Councillor Mike Clarkson, from Wellow Parish Council, and then Simon Joyce from the Cotswolds Natural Landscapes Board, Ned Garnett from the South of Bath Alliance, Alex Sherman from Bath Preservation Trust, Nigel Long from the CPRE, Jessica Pike, who as a local resident, Robert Hellard, who's a local resident and former member of South Stoke Parish Council, and Jackie Sloan, another local resident. Is anyone not here in that list that I've read out?
Sir, I understand Councillor Ian Halsall has been taken ill and unfortunately is not able to attend.
Okay, I'm sorry to hear that. We can obviously address, if he still wants to address the inquiry at another point, we can maybe arrange that or have a statement read out on his behalf. Thank you. Is there anybody else in the room who wishes to speak who hasn't already indicated? Anybody else? Please let me know. No. Okay. And for those of you who are here to speak, the intention is we will do that once we've heard opening statements from the main parties. That'll probably be after the first break, so probably from about 11:50, 12 o'clock onwards, and certainly before we have the lunch break. When you speak, I will just ask a few sort of questions in terms of your position on the development and whether or not you're happy to answer any questions when we get to your statement. And we'll try and make some arrangements for seating, because I'm conscious that we don't have a spare chair and microphone probably available, but I'm sure we can, during the break, rearrange things slightly to allow interested parties.
So could I just check the two names after Mr. Joyce? Sorry, I didn't take a note. Apologies.
There was Dr. Ned Garnett from SOBA and Alex Sherman from Bath Preservation Trust. And then I assume you got the CPRE, Nigel Long. Yeah, okay. Thank you. Any questions at this stage in terms of interested parties speaking and so on. We will obviously come to you all in due course. And obviously, yes, hopefully hear from everyone today who's present. And if anyone does anyone have any time constraints, I should say? Is everyone free up till lunchtime in terms of any speakers? If that's all okay, then we'll come to you in due course. Thank you. Is anyone here present from the press? Any local press representative? No. Okay. And obviously we are live streaming, and I believe the recording of today will be made available on the Council's YouTube channel. I think tomorrow is also being recorded and then live streamed, and then after that I think we won't be doing any more. But in addition to that, does anybody intend to film or record the event here today? No. Okay. No. Thank you. So then moving on to notifications, I've been provided with copies of the Council's letters of notification of the appeal when it was first lodged and consulted on in terms of the appeal, and then a further letter confirming the date, time and format of the inquiry. And I also have lists of the names of the people that those notifications have gone to. I'm aware that a number of site notices have been displayed around the site and photographs have been provided of that. Thank you. I'm not aware of this is being published. I don't think it.
I think your understanding is correct.
There is no press
Only
notice.
that, no.
No, that's okay. I say it's not an essential rule or requirement, but I just wanted to check I wasn't missing that. Okay, thank you. And then I have copies of representations made in response to the application, and I'm aware that there were over 1,200 representations made at the application stage, plus around 120 consultee representations from various groups and statutory bodies. At the appeal stage, there have been some formal representations received, including from local residents, the Cotswolds National Landscape Board and parish councils. I think there's 6 in total. I believe those have been shared with the parties, the main parties. If that sounds about the right number, then that's fine. If not, we can always look at that in a break.
I see nods from behind me, sir. So
Okay. And the Council and Rule 6 party have seen those representations as well, I believe. And I should say I will have regard to all representations that have been made at both stages when I'm reaching my decision. I've received proofs of evidence from the parties' witnesses, which I have read through. I'm not requiring or expecting large sections of proofs to be read out during evidence in chief, but although please do refer me to specific sections as needed as we go. To confirm, I've received some minor corrections to the proofs of both landscape witnesses for the appellant and the council, which I believe have been added to the core documents library. I believe they're fairly minor changes, so nothing of any substance. So they should be there. And I should say there is, via the council's planning page on their website, a link to a core document library hosted by Framptons, which contains various documents listed in various folders. So if anybody wants to find that, and we'll be using the referencing numbers for any documents we need during this inquiry. There's an overarching statement of common ground between the appellant and the council that was updated, I believe, on the 12th of December last year. And there is an overarching statement of common ground between the appellant and the Rule 6 party that was updated on the 2nd of January this year. There is also 2 statements of common ground between the appellant and the council on landscape and affordable housing, and a transport statement of common ground between the appellant and the Rule 6 party. Are there any further updates to any statements of common ground? Anything, Mr. Tucker or Mr. Morgan or Mr. Neal?
So no updates, but could I just confirm that the core document library has been updated to reflect those numbers? I'm not sure, at least on the list I've seen, our most recent statements of common ground went up. I could be mistaken. It's just
Sorry, which ones, Mr. Neal?
The latest statements of common ground between the Rule 6 party.
The transport one.
Yeah.
I would be able to tell you immediately if I could log on to the internet, which I can't at the moment. I believe it, I don't know if the appellant can assist.
Again, I see nods from behind, so I assume it has, but we'll check when the internet works again.
Okay, thank you, yes. And I should, yes, and obviously that core documents library does contain all the statements of case and proofs of evidence as well for anybody wishing to follow anything either online or via this room. Thank you. That's all I want to say in terms of the kind of documents at this stage, although we'll come back to any additional documents in a moment. What I'll do now is I'll run through the inquiry procedure for the benefit of everybody in the room. So once I've concluded my opening remarks, I will invite the main parties to each make a brief opening statement. The appellant will go first, followed by the council, and then the Rule 6 party. And this will help everyone understand the main arguments and position of each party at the start of the inquiry. As I've already indicated, I will then hear from interested parties who can provide their statements at that point. And following that, probably after the lunch break, we will have I will have some technical queries for the appellant regarding ecology, lighting and flood risk, and interested parties may ask questions at that point as well, should they wish. After that, I will then ask the main parties to present their case and evidence relating to transport, landscape, affordable housing and planning matters, which will be followed by cross-examination and re-examination as needed. We will broadly follow a topic-by-topic based approach with the council or Rule 6 party going first, followed by the appellant. I will generally ask questions during the evidence in chief or before re-examination, and if I could do the usual plea to remind witnesses from the main parties to answer any questions with a yes or no answer where appropriate, and then qualify responses where necessary, which will help make best use of time. A roundtable discussion on heritage and trees is currently scheduled to take place at the end of this week. I've circulated an agenda for this session, which I believe is online, and I've indicated the areas that we will be covering during that session, and I've explained that I think matters relating primarily to the reason for refusal 3 on mixed use, development, comprehensive master planning, and the wording of any condition or obligation regarding the Wansdyke crossing are best addressed by the planning witnesses. I haven't heard any howls of objection from any party. Are we happy with that, looking around the room? Mr. Tucker?
Yes, sir.
Okay, Mr. Morgan?
Yes, sir, thank you.
And Mr. Neil?
Yes, sir.
Okay, so we'll proceed on that basis. And I should also say any reference to travel links, provision of those, again, I think it's best addressed by the transport or planning witness. So the round table will be more about covering technical queries about any scheduled monument works, plus any issues to do with the heritage assets, such as the World Heritage Site, and so on. There will be at least one roundtable discussion on draft conditions and obligations during this inquiry. I should stress that's a standard procedure. It doesn't indicate I've made my mind up on the case, and it won't affect any party's position in terms of the discussion. I've circulated some comments on these draft conditions and obligations. Hopefully that's got through to the parties. And obviously, if there's anything to say at this point, please let me know, but otherwise we can return to this in the week. Mr. Tucker, anything?
Yes, sir. Two things. Firstly, thank you. That's really helpful to have behind the scenes. Secondly, obviously, we're taking your comments and working through those. On the Section 106 obligation, I'm told there is a further working draft which picks up some of the points that have been raised. What I'm mindful that I don't want to do, sir, is just keep bombarding you with draft after draft of the 106. Our anticipation is it will be finalised in the next couple of days. Would it be helpful, sir, to send the up-to-date working draft to your case officer today? Or, sir, are you happy to wait until we've reached a more...
The draft is ready.
Well, sir, certainly what we're hoping for, and I respectfully agree with Mr. Morgan in relation to that, would be to send you a working draft by the end of the week, which I would hope would be, if not final, then certainly virtual final form, and that those behind the scenes know that they're working to that guillotine that you, sir, will ask for the final or virtually final form to be sent by the end of this week, if that will be acceptable.
I'm content with that. Thank you. Any other comments on conditions or obligations? Anything from the Rule 6 party? Mr. Neil?
No, sir.
Okay. thank you. Thank you. So once all the evidence has been heard and discussions have been completed, the inquiry will then conclude with closing submissions from the main parties, and that will go in the reverse order to opening submissions. And as usual, if that can be provided in writing and electronically nearer the time, that would be very helpful. Thank you. I'm not inviting any applications for cost awards, but if anyone intends to make an application, that should be done before the inquiry closes. If I could just check on an update, do any of the parties intend to apply for costs? Mr. Tucker, I know the appellant has previously indicated. What's the latest?
Well, sir, it's as I set out at the case management conference, namely, we haven't a finalised position with respect to that, so I presently have no instructions upon making an application. If that changes, I will let you know, sir. I'm mindful that there was an initial intimation that we would, but so my present situation is I have no instructions to make an application.
Thank you. And if obviously, as soon as you know, if you could let me know, and obviously the other parties.
Absolutely, sir.
Yeah. Thank you, Mr. Tucker. Mr. Morgan, any instruction?
We have no current intention, sir, to apply for costs. Obviously, we'll see what happens, but I don't anticipate it. Thank you.
Okay, thank you. Mr. Neal, anything from the Rule 6?
So our position remains the same as Mr. Morgan. I have no instructions to make a cost application at this stage.
Okay, thank you. As I said, is it, you can't hear me, or? Okay, thank you. It must be the microphones needing to be a little bit closer. Mine is almost up, up my mouth, but I think if everybody else knows them to be a little bit closer to their face, it might be a bit easier to hear. Sorry for that, for those listening. Okay, and I should say in terms of costs, I also have the power to initiate an award of costs regardless of whether an application is made by any party. If that happened, it would follow a written process with the relevant party after the appeal decision has been issued. Moving on, I carried out a pre-inquiry familiarisation visit yesterday afternoon, walking along some of the footpaths and roads surrounding the site, so I have a general idea of the location now. However, I will inquiry. The intention is the version, I think it has the Rule 6 parties points added to it.
Yes is the
version, I think it has the Rule 6 parties points added to it.
Yes is the answer, sir. I have a hard copy of the itinerary which I can hand to you, which is the agreed one, which has been labelled the day itinerary. So if I just hand that to you, and then I've got a couple of other points to make, if I may.
Okay, yes, I'll take that. Could everyone hear Mr. Tucker just then, by the way? Thank you.
The second point is that I understand that Ms Prescott and Mr Cale are working upon a more distant route itinerary, of viewpoints for you to see, sir, and I'm told that that will encompass both locations that we would invite you to go to both during the day and at night.
Right.
But that will be on an unaccompanied basis.
Okay.
And then, sir, the third point to raise is the point that's raised in Mr Frampton's supplementary proof. There was a permissive paths agreement in relation to various paths that run over my client's land. That permissive paths agreement has expired, but the permissive paths remain used and available for use. You have his evidence as to what happens in the appeal dismissed world. But sir, there has been, as Mr Frampton's intimated, a notice served under the Highways Act that those don't comprise public rights of way and the landowner's intentions identified. But the simple point for the site visit is, sir, you are of course welcome to use those permissive paths, as are any other members of the public, for the purpose of seeing the site during this week, if you do so, if you've already done so. Or
I saw you noticed a number of signs up about permissive paths yesterday,
Yes, sir.
and walked on some of them. But thank you. It's useful just to know that they're okay for the site visits.
Yes, they are, sir, by all means.
And I should say, in terms of I'm grateful to the landscape witnesses for looking at the wider viewpoints, and if I could have that probably later this week, just in terms of particularly nighttime visit and just factoring in when I do that. Obviously, if it's left until the Thursday, I may be travelling home that day, so it would be a bit late. So if I could have that this week from the landscape witnesses.
Yeah, certainly I think Mr Cale was intending to try and get that finalised tomorrow, so I'm sure that...
Okay, there's no immediate rush, but And whilst we're on the subject of site visit, I should say, I know the intention is to start and finish at the Sainsbury's car park. I did notice there seems to be a maximum parking time at Sainsbury's of 2 hours. So if we are going to be more than 2 hours on this particular route, then we may have to think of an alternative rendezvous point. But I'm sure, for example, the park and ride, you can pay to park there even if you're not using the bus. So that's an alternative. But I'm not going to worry about that now, but just to sort of flag it whilst I remember. We'll come back to that.
Thank you, sir.
Anything else on the site visit from anyone? I should say the site visit will be strictly for me to see the site and its surroundings. There won't be any discussion on site in terms of any debate about the merits of the case. So we will obviously make more arrangements nearer the time. So just in terms of to conclude on the procedure, which I appreciate was quite a long run through, but just to say, I will obviously lead the inquiry and guide the proceedings, and I'll invite particular people to speak at particular times. And this obviously is a formal event, so please show courtesy and respect for whoever is speaking, and refrain from any interruptions or expressions of support or disagreement with whoever is speaking. And I'll be very grateful if that could be followed. Any comments on the inquiry procedure from anyone? No. Okay, so we'll just run through a few more things before we move on to opening statements. So the inquiry was scheduled to sit for up to 12 days. However, based on the timing estimates, I think we should be completed within 8 days. A programme has been circulated setting out the timings for each day. There's version 2, and I apologise, I think it was sent out with version 1 still showing at the top, but it's the version that has some red text on day 1 and 4. And so the intention this week is we would aim to adjourn by early Friday afternoon, having heard all of the evidence relating to transport and landscape matters, as well as heritage and trees. And then next week we would continue with planning and affordable housing evidence, any further discussions on conditions and obligations, and obviously the site visit. And then the intention is for the final day to take place online in 2 weeks' time on Tuesday, the 11th of February, and that would involve any final conditions and obligation discussions and the closing submissions. And I trust the council are able to circulate relevant teams meeting details for that, and to anybody else who wishes to observe. But we can come to that nearer the time. Are the parties happy with the programme as it's set out? Mr. Tucker, anything?
Yes, sir. I think it's probably generous looking at the evidence and whereabouts the areas of dispute are at the moment. So yes, sir.
But in terms of starting planning evidence next week, are you happy with that? I know previously indicated it might be this week, but I think the original programme between the three council were for this week. But I think.
Yes, sir. I understand that, and so I'm very grateful that one of my witnesses has a personal matter on Friday afternoon, which necessitates his absence. So I'm grateful that the programme has taken that into account.
I think we have enough time. I hope we have enough time.
I agree.
To not have to sit late on a Friday, which I'm sure most people will appreciate.
Yes,
anything from other parties? Sorry, Mr. Morgan. First of all, any comments?
Yeah.
Right. Okay. One of these days, I think in an inquiry, I'm going to go in and insist we all test these out before we start, and I apologise that I didn't do that. Okay, so I think it may also be that I have to turn my microphone off. That might help as well. Mr.
Yeah. Thank you, sir. Hopefully I can be heard, not too close. So yes, I think firstly, we will obviously, on this side, accommodate Mr. Cale as much as we can. Try and make sure he's completed in time, understand his position. So with regard to the timetable, yeah, I agree with my learned friend, it might be a little generous, but we'll see, because you never know. Council are often over-optimistic, as you know. But in terms of starting the planning next week, yes, I think that would be sensible to make sure wherever we are at the end of this week, we start afresh with the planning next week. Thank you.
Thank you, Mr. Morgan. Mr. Neil, any comments on the programme from the Rule 6 party?
No, sir. No further comments from us.
I think, again, the microphone probably really will have to be...
We're reading you loud and clear now.
Yeah, I think maybe the microphone's to your right, and then you can be looking at me and talking at the same time into the microphone. Okay. Thank you. any other comments on the programme? Just to say that there will be 4 sessions each day, 2 before lunch and 2 after, normally lasting no more than about 90 minutes each session. And then there will be short breaks between sessions in the morning and afternoon, and then a longer break for lunch. And we'll aim to finish each day around 4:45, 5 o'clock at the latest. I'm not aware that there's a sort of issue of sitting up to that point in terms of the venue closing early or anything. And after today, the intention is for everyone to start at 9:30 if everyone is happy with that. I've indicated that previously. So from tomorrow onwards, we will be starting at 9:30. And I think we only have this room for today. So I could just ask the council where we are from tomorrow onwards, please.
We are tomorrow, and I think the rest of this week, in the Caps of our room, so, which is on the same floor as this, and it's actually down, go out of this room, turn right, and it's just down the corridor at the end. You turn right then left, but it's well signed. It is a much smaller room, but we hope it'll be actually a little bit more user-friendly, quite frankly, and also sufficient to accommodate everybody comfortably.
And presumably the live stream for tomorrow can take place from that room. I've got a nod from, yeah, that's okay.
So it is, and can I just mention this, which might assist people? We will need to empty this room at the end of today's session, but we can leave things in the Caps of our room overnight tonight if people want to move things down.
Okay, thank you. And you reminded me that that's also the direction of anyone who needs the toilet facilities. They are in that direction, I think, out the door towards that room. Yeah.
They're all in the same direction. Yeah.
Yeah. Okay. Thank you. So we'll keep the timetable under review as the inquiry progresses. If we could move on now to just clarify plans which form a formal part of the proposal. Obviously, there are a lot of documents, but we'll just briefly cover the ones which are formal plans. These are, I think, in the main covered on the decision notice, and I'll use the core document reference number to help. So in terms of the detailed planning permission, there is, I think it's A12, which shows the Spine Road geometry and visibility, and A10, which shows the street lighting strategy. This is all through the phase 2 area. Then there is G15, which is the landscape general arrangement plan. And then the N15, which is the detailed landscape sections. And obviously these are the various revision numbers, but they're all listed as in core documents. So that's what I'm working on. I trust everyone is happy with that in terms of the detailed permission. If not, no additional plans for that element.
Those sound right, so I'll double check in due course, but yes, sir.
Okay, thank you. And then anything from the other 2 parties on the detailed? No. Okay, and then from the outline permission, there are a number of core document references. So there is N22, which is the application red line plan. Then N23, which is the location plan that also shows the blue line of land ownership. Then there is R12, which is, I'm going off the decision notice here, R12, which is the land use parameter plan, revision D. R13, which is the access and movement parameter plan, and that's revision C, I believe. Then R14, which is the green infrastructure parameter plan, revision D. R15, the building heights parameters plan, which is revision E. A lighting parameter plan, document R16, which is revision D. And a drainage parameter plan, R17, which is revision C. In the conditions, there's also reference to R10, which is the master plan drawing, the comprehensive master plan drawing. That wasn't, Mr. Morgan, that wasn't listed in the council's decision notice. I just wanted to understand why the council's now put that forward in the plans condition. I think I noted your comments there on that, on the conditions.
which I was reading yesterday. Could we deal with that in the condition session? I mean,
Okay.
I take the point it wasn't a formal plan, so we'll take on board your point, I think.
Okay. Mr. Morgan, Mr. Tucker, sorry, any comments on that?
Yes, sir. I suspect it probably arises from the consultation response of the Urban and Design and Landscape Officer, who intimated that he thought, I think it's a he, thought that there ought to be a conditioning of the master plan, given the requirement in the policy with regard to master planning. And we've certainly acceded to that request. So I think the answer is to be found in that consultation response, and that may be the motivation, I don't know. But that's something, again, we can perhaps check outside of inquiry.
Okay. Mr. Neil, anything to add?
Not at this stage, sir, no.
Thank you. Thank you for the microphone move. I think that helps. Yes, obviously I'm sure, no doubt, come to the master plan drawing during evidence, and I suppose it would just be helpful to have a sort of understanding as to the status of that plan. So I don't know if that's something before we hear from the landscape witnesses, perhaps in particular, it might be helpful to have a note or something on those lines.
Yes, sir. We'll seek to agree that note with the Council and the Rule 6 party. Certainly from our perspective, we have no particular objection to it being added as a plan for determination at this stage, notwithstanding it wasn't on the decision notice.
Okay. But yeah, if I could ask, so I think it'll be before, well, probably by tomorrow, ideally, I suppose, if that's, or yes, if we get onto landscape evidence tomorrow, that might be helpful to have that clarification. Obviously, it is a part of the documents library. It's, I'm not saying it's not can't be looked at, but it's just the formal status of that plan that would be helpful. Thank you. I don't think there are any other formal plans. In terms of documents, I've been made aware of a couple of extra documents, which I'll turn to in a second. But obviously, I should say this is the point to let me know if any additional documents are intended to be submitted. I'm not inviting them, but now's the time to let me know. I'm aware, first of all, that the Rule 6 party wanted to submit 2 further documents in the form of a technical note from their transport witness and an extract from a guidance material on the RKD software. And these are in response, I believe, to the appellant transport rebuttal. So, Mr. Neil, do you just want to briefly explain what they are, please?
Yes, sir. As you've already highlighted, there are two documents. If I could just take the motion technical note first, 22nd of January 2025. Without getting into too much detail, that provides some images taken from the drone footage that was secured by the Rule 6 party, and it also contains some extracts from the Google Maps typical traffic function. The reason for that is set out. The reason why the Rule 6 party would like to reduce that is it responds to comments made at paragraph 2.33 of the highways rebuttal evidence of the appellant, Mr. Pinto. The second document, as you've already indicated, sir, is an extract from the appellant's own software, or the software that the appellant used for modelling, and it's an extract from that software company's guide, its user guide. As I understand it, so as we indicated, there is no, we said we'd engage with the appellant and the local planning authority. As I understand it, there's no objection to those documents being admitted as a core document in this inquiry. Because there's no objection, I'm not sure I need to address you further at this stage. So
I'll just double check with the other two parties on their position with those documents. But thank you for that outline. Mr. Morgan, any objection from the council?
So no objection from us, no.
Okay, thank you. Mr. Tucker, any objection?
So on the RKD document, no objection or comment to make. Happy for you to accept that without demur. On the technical note, so you will be aware from looking at the highway evidence that there's an issue as to what the drone survey relied upon by Alan Bale's consultancy provided in March of last year actually shows and so what we appear to have is a very short timescale assessment in the technical note of, I think, a couple of seconds out of 3 hours of a drone survey showing very, very slow moving vehicles, not quite stationary, but showing very, very slow moving vehicles on the network. Insofar as that's what it shows, no objection to your receiving the technical note. What I'm slightly cautious about is any suggestion that somehow this is an exemplar of a vast proportion of those 3 hours showing something similar. And if that point's made, but not substantiated, then I will object to that. But in terms of receipt of showing the timescale that's been referred to in that technical note, happy with that. And you'll note, sir, that there's no explanation within the technical note as to why it's been produced, which is why I make that rather cautious point. So I'm not objecting to the note, but I do lay down a marker if a point is made that goes wider than the note.
Okay, thank you, Mr. Tucker. Mr. Neil, anything in response?
No, sir, the weight to be attached to the note and what the images shows can be addressed in evidence with Mr. Russell, but I note the foretaste of what is to be put to Mr. Russell.
Thank you, everyone. So, yes, I'm obviously happy for those two documents to be added to, well, I think what we'll start doing from this point forward is to create an inquiry documents list, and we can either continue the numbering, or I think it might be clearer or cleaner if we say, if we use an ID prefix, so ID1 and ID2 can be the two documents, the motion technical note and the Arcady extract. Is there anything else, Mr. Neil, from the Rule 6 party that you're, apart from your opening submissions, obviously, anything else you wish to table now?
No, sir.
No. Okay, thank you. Mr. Morgan, anything from the council?
No, thank you, sir. Thank you.
Okay, and Mr. Tucker, anything from the appellants?
So one document, I think, which is Appendix 4 of Mr. Frampton's proof, he spotted has an incorrect notation on it. So the correct notation, and it's a reference to the conservation area rather than the AONB. There's a substitute plan which is on its way, sir, hasn't yet arrived. When it arrives, sir, we'll make sure it's handed out to all the parties. I can't imagine it makes a difference for today. But, sir, that, I think, is the only document that we need to put in this inquiry, in addition to the ones you've got.
Well, we'll obviously have a look at that when it comes through, and obviously if the other two parties, main parties, have a concern about that, then we'll deal with it then. But thank you.
Thank you, sir. And obviously we'll update it online as well.
Yes, thank you. Thank you. And obviously, as I say, we'll continue using the numbering system, the ID numbering system, for any further inquiry documents as we go. Anything else on documents anyone wants to submit? If not, then I will just set out, before we finish my opening remarks, the main issues that this inquiry is likely to focus on. So first of all, the effects of the proposed development on the Cotswolds area of outstanding natural beauty, or now known as National Landscape. Secondly, the effect of the proposed development on the significance and setting of the City of Bath and the Great Spa Towns of Europe World Heritage Site, and the Wansdyke Scheduled Monument, the South Stoke Conservation Area, and the non-designated heritage asset known as Soulis Manor. Thirdly, the effect of the proposed development on placemaking principles with specific regard to pedestrian cycle links, mixed-use development, and the comprehensive master plan. Fourthly, the effect of the proposed development on trees, and then the effect of the proposed development on traffic is the fifth main issue. And finally, the sixth main issue is the overall planning balance, having regard to the development plan and any proposed benefits. Any comments on those main issues? Mr. Tucker?
Still agree, sir.
Okay. Mr. Morgan, happy with those?
Happy, thank you very much.
And Mr. Neil, happy with those main issues?
Yes, sir.
Okay, thank you. Other matters raised by interested parties may need to be covered at some point, or almost certainly will be covered at some point during the inquiry and in my decision as necessary. So that concludes my opening remarks. Are there any other queries about the procedure or any other matters before we start? And has anybody joined us later on who wishes to speak, who hasn't already indicated? No. Okay. Well, thank you. So that concludes everything in terms of my opening remarks. So we'll now turn to opening statements, and if I could ask Mr. Tucker to deliver the appellants, please.
Thank you, sir. Ms Jackson's just going to circulate copies. I think we estimated 15 minutes, so it will be every minute of that, I fear, because I've got a significant number of points that I need to cover.
Thank you, and we'll put this down as inquiry document 4 then, I think. So appellants. And I'll take it there are copies going to the other main parties, and this could be uploaded obviously onto the council's or the Frampton's website, please.
Yes, it will be, sir. Thank you.
Thank you. Okay, so when you're ready, Mr. Tucker, please begin.
Thank you, sir. Sir, you'll note on the first page that we have quoted the terms of the planning application, which you've already read out, but I note, sir, it was submitted in May of 2022 in a hybrid form. Paragraph 2, I'm not reading it out unless you wish me to do so, sir. Had things proceeded in the manner anticipated by government and relevant statutory provisions, this application should have been determined and granted by autumn of 2022. New homes on the site should now be in the process of being sold to their future occupants. Instead, we find ourselves in Q1 of 2025 in the position where the council stand by the allocation and stand by the principle of residential development on the site, but after refusing permission have adopted the position that the scheme should be smaller, and where the Rule 6 party think the principle of residential development on the site is misconceived, albeit for traffic reasons. On any view, this is not how the system should operate. This isn't a case where there isn't a 5-year land supply, so the plan's delivery has failed completely, but this is a case where there's an expectation that the system would operate properly. Instead, the application took 2 years to be determined and refused contrary to officers' recommendations. Reasons for refusal have come and have gone, and yet we now have the council telling us that there's too much development on the site based upon the sort of forensic archaeology into plan making that the courts have long since deprecated. And we have the Rule 6 party inviting you, sir, to reject the views of not just the appellant on highways, but the views of the local highway authority, arrived at after an exhaustive process of scrutiny and recently reiterated. It will be recalled that in November 2023, the application was deferred from determination by the council, with the appellant having been requested to provide additional information covering various matters, which it did. Then the application was reported back to committee in April 2024, when despite the council's own planning officer robustly recommending that permission should be granted, subject to obligations and conditions, the committee determined to refuse the application, giving 4 reasons for refusal, and I set those out, sir, in summary form. Fast forward to the inquiry today, the council's distanced itself from 2 out of 4 of the reasons for refusal. Reasons 2 and 4 have been withdrawn essentially altogether, and the council also agrees that providing that there's an appropriately phrased Grampian-style condition imposed in respect of a requirement to submit an application for a scheduled monument consent for the shared use path between the Wansdyke and Cranmore Place, and for the approved works to be undertaken before first occupation, it doesn't seek to rely upon the first part of the 3rd reason for refusal. So the residual case being run by the council appears to be, and again, not reading those out, sir, first reason for refusal stands, and we've got half of reasons for refusal 3 relating to mixed use issues. And whilst my client is not pursuing an award of costs in respect of the withdrawal of 1 and most of the other reasons for refusal, there have clearly been significant change to the council's stance in respect of the committee's reasoning and determination is concerned. What had started off as a refusal supported by a heavy list of 4 reasons is now 1 and a bit reasons for refusal, and an acceptance by its evidence that the appeal site should be developed for major development, albeit less than proposed, despite being located in the AONB, meaning that the first reason for refusal is now one of a matter of degree, not principle. And as for the residue of the 3rd reason for refusal, the invitation to only look at the appeal site and not its context when judging whether the development will result in a sustainable mixture of uses is downright odd, especially given the proximity of the proposed new housing to shops, leisure, sporting facilities, education and healthcare facilities, and even employment. And it will of course escape no one's attention that the council accepted the recommendation of highway officers and has never sought to argue that the appeal proposals would give rise to a severe impact upon the local highway network. And even the Rule 6 parties doesn't actually appear to be directed towards the proposition that it would do so, but rather to argue that it hasn't been proven that it wouldn't do. an argument rejected by officers and members which does not withstand scrutiny. And despite the Council's withdrawal of the second reason for refusal on heritage and part of the third on the SAM and the issue in relation to trees, the specialist consultants have nonetheless prepared written statements which are of course before you to assist your determination of the appeal, and the authors of all those documents are of course available in the room to provide an answer to any questions later on. Context. The proposal at hand with its significant offer of affordable housing is opposed by the Council in the context of there being the most acute housing crisis in living memory. And so I quote what the Secretary of State said when she first came into office, and I only read out the words in bold. She said, "Our work is urgent, and in few areas is that urgency starker than housing." So the suggestion that the authority can demonstrate a 5-year land supply does not mean that the crisis does not apply to this part of England. Having a 5-year land supply does not mean that allocated sites are no longer needed to come forward, nor does it mean that where sites are released from the Greenbelt that they shouldn't be developed efficiently and properly. With respect, national policy extends to Bath too. And that, sir, is without stressing Mr. Stacey's evidence, which is that there is an immediate, acute need for this authority to deliver more housing, which includes, obviously, delivering and optimising delivery on allocated sites. And it's in that context, sir, that we invite you to determine the appeal. We say, sir, there are a number of benefits to the scheme. One of which, sir, is the provision of new homes in that context. Second is 40% affordable housing. The third of which are the economic benefits that arise during construction and operation. The fourth is the creation of a network of new and enhanced pedestrian and cycle paths across the allocation. Next is the production of the minimum of 10.22% habitat units and 10.34 hedgerow units in terms of biodiversity net gain. Next is a contribution towards increasing capacity at the primary health care at the local surgery. Next is on and off-site sustainable transport measures, and a hefty contribution to that, sir, we'll discuss in the 106 session. The next, sir, are the heritage benefits arising from the provision of formalising the crossing of the Wansdyke, thereby avoiding further erosion of it and removing safety hazards by reason of the unmade surface on a steep incline and the exposure of trip routes resulting in safety issues. So turning to our position on the first reason for refusal. Our case is founded upon reading the policy properly and in context. When one does so, we say, reaching a planning judgment, that the appeal scheme is compliant with paragraph 11C of the NPPF. We'll arrange a fine system on our side for anybody on our side that happens to happen to. Mr. Pinto is the first victim. Apologies for that, sir. By contrast, the Council's interpretation that where even one of the placemaking principles is not met, then the reference to around 300 dwellings figure magically becomes a cap, defies the language of the policy, which simply doesn't say that. And so you recall Mr. Frampton gives the example of the fact a school isn't being requested anymore. Rather, that appears to be an ex post facto justification seeking to bolster the questionable conclusions reached by members. All of the evidence points to the fact that the words around 300 was only ever intended to be an indicative provisional capacity, subject to the more detailed work one would expect at the application stage. National policy is unequivocal. Not only is there a policy injunction to use land efficiently, but there's an expectation that if land is not being used efficiently, the permission should be refused, not language used lightly by the Secretary of State. So having agreed that this is a site which can accommodate major development, it is wrong-headed for the Council to somehow seek to argue that it's for us to prove how anything over than 300 units over the whole allocation can be satisfactorily accommodated, and not even make passing reference to the policy obligation which has been at the heart of national policy for at least a decade. The Council's characterisation that this is a maximisation of development is also misguided and appears to have been misinformed by its landscape witness, who's engaged in an impermissible forensic archaeology, whilst missing out half of the evidence she should have referred to and argued that the southern part of the appeal site isn't really allocated for housing. As for the AONB, it's common ground the appeal site can and should accommodate major development, which inferentially means that exceptional circumstances have already been established by the allocation of the site. Indeed, whilst new wording was introduced in 2019, the underlying substance of national policy for the control of major developments in the AONB has not materially changed since the site was allocated. and most certainly not since the adoption of the local plan update in January 2023. What has changed is the statutory duty upon public authorities by their actions to conserve and enhance national landscapes, upon which the Department for Food and Rural Affairs have recently published guidance which Mr Frampton sets out in his supplementary proof. Yes, the scheme involves major development, but it does so mindful of the same need for sensitivity in terms of its impact upon the rest of the AONB and in terms of enhancement. By way of example, it involves re-permitting the public to use the now lapsed former permissive routes within the structural landscape and public open space. And as for the test of exceptionality which the Rule 6 party appears to contend isn't met, our situation is firstly dealing with the need for the development, including in terms of national considerations. We say the allocation remains needed and the development meets the amended duty in the statute as well as further policy objectives. We particularly rely upon Mr Stacey's evidence in setting out the start terms, the acute need for affordable housing in this district, and in the light of his evidence it's hard to see how it can be credibly argued that the proposed 40% affordable housing on site isn't needed. Dealing with the cost and scope for development outside the designated area for meeting it, the appellant will in due course demonstrate there's no realistic alternative way of meeting the need for housing, and will refer to the local plan inspector's view on that as well. And then any detrimental effects on the environment, the landscape and recreational opportunities and the extent to which that can be moderated, Mr Cale will address that, explaining how relevant landscape effects have been limited and how opportunities for enhancement have been taken in respect of recreational opportunities. Reason for refusal number 2, the Rule 6 party, despite the Council's withdrawal of this reason for refusal, nevertheless appears to be pursuing it, albeit it intends to call no oral evidence that can be scrutinised at the inquiry to challenge the assessment of harm referenced within the planner's evidence. In this regard, we rely upon the written evidence of Mr Smith, his assessment of the impact of the significance of the historic environment, both in terms of designated heritage assets and non-designated assets. His evidence demonstrates there will be no impact on the South Stoke Conservation Area, and insofar as some harm may arise to the significance of the Wansdyke Scheduled Ancient Monument resulting from the proposed shared use path, the Wansdyke is currently being used in that way and is currently being eroded, particularly on the north side, through the informal use of it by the public. The effect of the proposals will be to formalise this route. Yes, a level of harm arises which should be given great weight, but it's strongly submitted that it's outweighed by the public benefits of the development, not least the heritage benefit to the Scheduled Ancient Monument itself, in directly addressing future damage through erosion, which would otherwise be caused by the continued public use of the route from the Wansdyke towards Cranmore Place if no intervention occurred. Overall, the position of the Council on this reason for refusal, unlike that of the Rule 6 party, is sensible and sustainable. Reason for refusal 3. Historic England, of course, will in due course reach a view as to whether there's a benefit of the Wansdyke that will itself outweigh the harm, given great weight to it as a designated asset. On the evidence before you, we say there's the clearest indication that there is likelihood that the SMC, Scheduled Monument Consent, will be granted, and the outstanding issues seem to relate to the construction detailing on the width of the crossing, not the principle of the link. On a balance of probabilities, the appeal should proceed on the assumption the link will be provided should permission be granted. That being said, were the position otherwise, there would still be satisfactory alternative options for journeys by cycle to local facilities. The proposal would establish a sustainable pattern of development in the event a cycle crossing of the Wansdyke were not available. The issue should never have been part of a reason for refusal on our evidence. And as to the remaining part of the reason for refusal retained by the Council, the lack of mixed-use development of the site, this reason we say is misconceived and fails to undertake a proper reading of the policy. You'll note, sir, that NPPF promotes a sustainable pattern of development, and neither NPPF nor Policy B3A requires each and every planning application to comprise mixed-use development. Instead, it requires the allocation to be residential mixed-use development, a requirement for the allocation that this development clearly complies with. And what then really matters is whether the proposal will result in a sustainable community with ready access to services and facilities by use of travel other than the private car. The briefest perusal of a map reveals the site's proximity to employment, education, retail, sports and leisure, as well as being close to major transport routes with frequent buses. Even confining one's attention to the appeal site itself, the proposal is not confined to residential development, providing significantly greater number of amenity, green space and natural green space sought by the green space strategy, as well as the extensive opportunities for outdoor footpaths, etc. There is no basis to suggest the proposals will result in a homogeneous dormitory development. Indeed, one might wonder at the sense of the point when the council's evidence would seem to suggest the site with half the houses and a small shop would be acceptable. Reason for refusal 4. As the Rule 6 parties' reliance on this withdrawal reason for refusal, we reply on the written statement to Mr. Rose in respect of trees, in respect of the inevitable tree loss within the grounds of Sullis Manor. The appellant emphasised that the Rule 6 party, whilst asserting there's no evidence to suggest the proposed alignment of the link road is the least impactful, then fails to put forward an alternative alignment for the link road which could be acceptable in highway terms, resulting in lessening tree loss. Traffic, dealing with it very briefly, and I've got one additional point to make. So the council's position in its capacity as local highway authority is that it accepts that the submitted information provide a comprehensive assessment of the traffic and transportation impacts. The council's never advanced an objection to the development on traffic and transportation grounds other than in relation to the uncertainty of the delivery of the crossing of the Wansdyke by cycling. Yes, the Rule 6 party relies upon traffic issues to oppose the proposal. Its statement of case, interestingly, refers to there being a severe and unacceptable traffic impact, yet its evidence actually points to a procedural criticism of the process by which the assessment's been undertaken. The appellant will rely upon Mr. Pinto's evidence in his consideration of the development on the highway network, and his position shows the Rule 6 party's position is untenable. And so can I just add, and I fear test your pen, can I remind you, sir, of something that you don't need reminding of? These are not formal court proceedings. There is no burden of proof. And if it's contended, as it seems to be, that the Rule 6 party are running a not proven case as to whether or not ACOM's review of what I'm told are 14 days worth of CCTV evidence on behalf of the council, which grounds the local highway authority's response and grounds the transport assessment, that is a deeply misconceived position to adopt. But we shall see. In conclusion, sir, this is a good scheme which ought to have been consented long ago. In view of the above analysis, the weighing of the significant benefits and given the suitable mitigation of the development impacts, you will of course in due course be respectfully invited to allow this appeal. So unless I can assist you further, those are our submissions in opening.
Thank you, Mr. Tucker.
Thank you, sir.
Thank you, sir. If we can now turn to the council's opening statement, please, Mr. Morgan. That's absolutely fine. Yep, not a problem. Thank you, Mr. Morgan, for circulating the opening statement, which we'll mark up as ID 5 for the list. And when you're ready, please begin, Mr. Morgan.
Thank you. I hope I can be heard okay. Please indicate if I can't. So although the proposals were supported by the officers and not objected to by Natural England, the Council is not seeking to go behind or undermine the allocation under Core Strategy Policy B3A, as the appellant suggests. And I give you references in footnotes, sir, but I won't go to them, say, possibly in one case. So it is simply seeking to ensure that the development is consistent with that policy's requirements, which are themselves consistent with national policy. At stake is an important and cherished resource, The appeal site is in a particularly sensitive location with respect to the landscape setting and its location on the edge of a World Heritage City. This is an iconic landscape, and views from around it, and in particular from the south, reveal some of its special qualities, as Miss Prescott has detailed in her evidence. This importance and value are also testified to by the Cotswolds National Landscape Conservation Board in their representations, the Rule 6 parish councils, and indeed many others, as you know. So this statement will now summarise the Council's position in respect of the issues that arise, consistent with its retained reasons for refusal, including in respect of the planning balance. So turning first, sir, to main issue 1, that's the effect on the national landscape. So policy B3A states at the outset that the requirements set out in the placemaking principles of that policy need to be met to enable the development allocated. And I set the policy out there, so I don't think I need to read it. Although the appellant has been, both at the time of the examination of the core strategy and since, seeking a much higher figure than 300, this has not been accepted by any inspector or the council. And indeed, the core strategy inspector supported the council's assessment underpinning the 300 dwellings as being reasonable. The strict approach to development in a national landscape is clearly set out in the National Planning Policy Framework at paragraphs 189 and 190. And the courts have recognised that the real sense of the NPPF giving of great weight to conserving and enhancing natural beauty in national landscapes is, and I quote from the footnote, you'll see the reference there, the reference to the Ticehurst case, which is in the core documents now. So, and that quote is, an expectation is given by the NPPF that the decision will be in favour of the protection of the landscape and scenic beauty of what was then an area of outstanding natural beauty, or against harm to that interest. So that great weight is, of course, capable of being overcome, but the effect of giving great weight to what might otherwise in any given case be assessed as a relatively modest degree of harm might be sufficient as a matter of planning judgment to amount to a reason for refusal when, absent that policy, that might not be the case. And again, I give you the reference for that submission in the legal authorities. Not only does the framework require that great weight be given to conserving and enhancing landscape and scenic beauty, in national landscapes it is advised that the scale and extent of development should be limited. Further, permission should be refused for major development other than in exceptional circumstances and where it can be demonstrated that the development is in the public interest, including by reference to the criteria of the 3 criteria in paragraph 190. So there is no doubt that this development is a major development, and the site is, of course, within the national landscape, even if its landscape qualities may be lesser themselves than the area around it, as recognised by the core strategy inspector. The total number of dwellings proposed for phases 3 and 4 through this appeal, together with the 171 already approved and being completed on phase 1, would be up to 461. The appellant accepts that the 461 is not around 300, and that's in the main statement of common ground. There is also the potential, of course, for further dwellings as part of phase 2 Sulis Manor. It is agreed that the figure of 300 is not a cap, but the allocation is nonetheless for around 300. That means, as I understand it, approximately 300. And that was tested, of course, at the core strategy examination on that basis. Therefore, we say the appellant cannot rely upon, as it seeks to, the exceptional circumstances test having already been satisfied as part of the allocation. And given the impacts identified by Miss Prescott, the proposals are in any event in conflict with placemaking principles 1 and 5. Placemaking principle 5 includes the requirements of avoiding or minimising detrimental impacts on the Cotswolds national landscape, the character of the Cambrook Valley and the Sulis Manor Plateau, and the medium and long distance views such as Upper Twinhoe and Bagridge Hill. In addition, development must protect the tree belt on the southern edge of the site and enhance this with additional planting to ensure visual screening of the site from views to the south. Further, the exceptional circumstances test is now to be considered in the current circumstances. The Council at the time of adopting the core strategy was also unable to demonstrate a 5-year housing land supply, and this is currently not the case, as you already heard. Further, since that original allocation, there are 4 important considerations that have arisen, including changes to the framework and the PPG, the strengthening of the statutory duty applicable to considering planning applications in a national landscape, and, as from December of last year, of course, the new DEFRA guidance on the application of that duty under Section 85 of the Countryside and Rights of Way Act 2000. These all add force to the local planning authority's position on this issue. So as Ms Prescott details, and we will explore in evidence, the proposal will cause landscape and visual harm, and in particular intrude into the skyline, even more so than for the Phase 1 development. The harm could be substantially reduced by reducing the number of dwellings in Phases 3 and 4 to deliver an overall quantum, combined with Phase 1, closer to around the 300, consistent with placemaking principle 1. So accordingly, the evidence on this issue will demonstrate that the proposals conflict with local plan policies B3A and NE2, as well as the framework, the PPG, and the new DEFRA guidance on the strengthened duty under Section 85 of the CRO Act. So I turn now to main issue 3, so that's the placemaking principles issue. So this main issue reflects reason for refusal 3, but as is known, and as my learned friend has referred to, the Council is relying on the mixed-use elements of this. In terms of the pedestrian cycle link as required by placemaking principles 7 of policy B3A, the Council accepts that this can be addressed by a Grampian condition, the precise wording of which can be debated during evidence on the conditions session, as you already touched upon, sir. As reflected in the main statement of common ground, the only difference with the appellant on this, as I understand it, is whether the scheduled monument consent should be obtained prior to the commencement of development, as we have contended, or prior to the first occupation, as the appellant considers. And I think that needs to be considered in the up-to-date evidence that there's been site visit, I think, with HE, and we can deal with that, sir, in due course. But both parties agree that if the SMC is granted, the work should be completed prior to the first occupation. So I move then to the mixed-use issue. With regard to the mixed-use issue, the allocation under the policy is as set out in PP1 for residential-led mixed-use development. As Mr. Reynolds explains, that requirement for a mixed-use development accords with the wider development plan approach and is consistent with the approach in the framework. Providing a mix of uses in new development can help enrich the character and qualities of places in accordance with good design principles. The appeal proposals are not mixed use. The non-residential allotments are supporting infrastructure for the residential use, nor did Phase 1 include any mixed-use element. The comprehensive master plan provided by the appellant makes no provision for a mix of uses, and the Council does not accept that the requirement under placemaking principle 1 can be satisfied by existing uses within the site and its immediate surroundings. Those uses were well known and understood when policy B3A was adopted, nor does the absence of a specific other use negate this requirement. In fact, it gives a degree of flexibility to the developer, as Mr. Reynolds points out. It is acknowledged that the proposals will improve accessibility to services to the north, but as Mr. Reynolds sets out, there are, for good reasons, limitations to the usability of the route. The quantum of development, well in excess of the figure in the allocation policy, makes it even more necessary for a development of this size to include a mix of uses. We say, without these, the proposals should be rejected. And that leads me, sir, to the final point I just want to summarise the Council's position on, and that's the planning balance. So there is no doubt that there is an acute national housing crisis and an acute need for affordable housing within the local authorities area. Equally, there is no doubt that the proposals would deliver significant benefits, particularly in terms of housing and affordable housing. However, this is an allocated site with a quantum of development underpinning that policy, allocation policy B3A. The about 300 is not a figure plucked out of the sky. it was carefully considered and balanced by the Council and the Core Strategy Inspector, including in particular in terms of the impact on the national landscape. As the PPG advises, the framework now, from as I understand it, July 2018, makes clear that the scale and extent of development in national landscapes should be limited. The far-reaching implications of that are then reflected by the PPG, which continues that MPPF policies protecting national landscapes may mean that it is not possible to meet objectively assessed need for development in full through the plan-making process. So notwithstanding the undeniable added emphasis on meeting housing need as reflected in the framework and as referred to by Mr. Tucker, understandably, it is of significance that there has been no watering down of the importance of protecting national landscapes. Indeed, that importance has undoubtedly been strengthened since the site was originally allocated. In terms of the overall planning balance, the evidence of the harm to the national landscape has to be considered with the less than substantial harm, along with the less than substantial harm to important heritage assets under main issue 2, as seen from Ms. Boulder's evidence and as will be discussed at the roundtable session at the end of this week. As has been made clear, the local planning authority is not suggesting that the harm to the heritage assets outweighs the public benefits that would arise and has, of course, withdrawn reason for refusal too. Nonetheless, it does weigh in the planning balance against the proposals. There is also the harm rising from the lack of additional uses in the proposals so as to provide a mixed-use development as required by Placemaking Principle 1, which I've addressed above. And so the tilted balance under paragraph 11 of the framework does not apply as the proposals do not accord with the agreed to be up-to-date development plan and in particular policies B3A, E2, DE1 and DE2. Given the importance of these policies, particularly with regard to the impact on the national landscape, the proposals conflict with the development plan as a whole. In any event, the policies in the framework relating to the national landscape themselves provide, in the circumstances, a strong reason for refusing the development, and the benefits in the circumstances do not outweigh the harm that would result. So accordingly, with respect, the local planning authority will seek to demonstrate through the evidence why all this should lead to the appeal proposals being rejected. So unless there's anything you want me to deal with, those are my opening statement submissions.
That's very good. Thank you, Mr. Morgan, for those.
Thank you, sir.
And then finally, but no means least, we'll turn to the Rule 6 party. Mr. Neal, I assume you have a statement to circulate in opening. Thank you. Thank you. We'll obviously add this to the library as inquiry document 6. And Mr. Neal, when you're ready, please begin.
Thank you, sir. Can I just check that I can be heard by the everyone in the inquiry? I think people can hear me.
As the microphone is in front of your mouth, I think that's okay.
So these are the opening submissions by the Rule 6 party, South Stoke Parish Council and Coombe Hay Parish Councils, who I'll refer to in the rest of these submissions just as the parish councils. These opening submissions do not rehearse all the concerns the parish councils have with the scheme, nor all the evidence. Rather, in the interest of brevity, they'll focus on the key issues in dispute between the parish councils and the appellant, which will be pursued in evidence in this appeal. Before doing so, the parish councils wish to make their position clear regarding the extent of its or their concerns with the appeal scheme and how those relate to its position in this appeal as a Rule 6 party. The breadth of the concerns of the parish councils with the scheme have been set out in the Rule 6 party's statement of case and in the parish council's written representations objecting to the appeal scheme. And I've given you the reference there, sir, in my submissions. I won't read those out. While some of their concerns are also concerns pursued by the council in this appeal, particularly landscape and AONB impacts, many were not accepted by Bain's officers when recommending that permission should be granted, and do not form part of the reasons for refusal identified by members of the Planning Committee. Primarily for funding reasons, the Parish Council's not been able to pursue all those additional points, i.e. those not pursued by Bain's, in evidence before this inquiry as a Rule 6 party. Instead, they have focused their limited resources on adducing evidence on planning and highways matters. The reason for that are those are the two key areas where the Parish Councils considers that Bain's in particular has conceded too readily in certain respects to the appellant's position. In the Rule 6 Party Statement of Common Ground, dated 2nd of January 2025, which I'll refer to as the January 25 Statement of Common Ground, it's been agreed that where such additional points arise, the Parish Councils rely on its previous written representations. Therefore, they are not addressed in any further detail in these submissions. Those, however, include concerns over drainage, trees, and the general sustainability of the scheme. However, the Council would just like to stress to the Inspector that the fact that they are not actively pursuing all those additional points before this appeal does not mean that those points are any less important, nor should it be taken to mean that the Parish Councils have resiled from those points or withdrawn them as points of objection. A key fundamental point made by the Parish Councils, which they wish to stress at this stage, is one shared by a multitude of objectors to this scheme. This proposal would clearly entail a clear departure from the local plan in terms of the total amount of housing that the scheme would comprise when taken together with the 171 dwellings already under construction in Phase 1, i.e. a total of 461 dwellings. This far exceeds the number of dwellings envisaged when the plan was examined and adopted. Around 300 dwellings are set out in Policy B3A. That was not an arbitrary figure. It was included for a reason after a careful examination by the Inspector of the evidence put forward in support of the allocation. It is also common ground, it seems, that this policy is not out of date. The frustration, therefore, that is evident in the considerable number of objections to the scheme, with a proposal that clearly conflicts with that policy and with the development plan as a whole, with insufficient justification, is entirely understandable. The specific additional issues pursued by the Parish Council's Rule 6 party. So I've set out there, so at paragraph 9 of my submissions, the discrete additional issues raised by the Parish Councils and its statements in case, which will still be pursued before this inquiry. And those are as follows. The highways impacts of the scheme, and in particular the adequacy of the modelling carried out by the appellant's transport consultants, Tetra Tech. I've called that the highways issue, for want of a better term. Whether or not there's a comprehensive master plan that complies with Placemaking Principle 2 in Policy B3A. That's the comprehensive master plan issue. And then there's the issue of whether the public benefits of the proposal outweigh the less than substantial harm to the City of Bath World Heritage Site and Great Spa Towns of Europe World Heritage Site and the Soulis Down non-designated heritage assets. Now, just turning briefly to the highways issue, that will be addressed in the evidence of Mr. Russell of motion. His proof of evidence, I've given you the court document references in my opening at AM1. It primarily relates to the question of whether or not the appellant's transport assessment adequately modelled the baseline traffic conditions in the highways network around the scheme, particularly the odd down park and ride junction and the red line junction. As the Inspector, as you have already noted, the Statement of Common Ground on highways matters agreed between the two experts is brief. It does, however, highlight the key issue between the respective parties' experts, which is in essence a technical, but nevertheless, in my submission, critical issue of disagreement between those witnesses regarding the accuracy and appropriateness of the baseline junction modelling, which underpins the appellant's TA, Core Document 52, A52, and its two addenda, G22 and Z22, and therefore whether or not traffic impacts have been correctly predicted. And as I said, this relates in particular to the assessment of baseline the key junctions of Old Down Roundabout and Red Lion Junction, and the Red Lion Junction. The Parish Council's position is the modelling that's been carried out is flawed for at least two primary reasons. First, the type of modelling carried out, namely the modelling of standalone junctions rather than use of a network-wide model, was inappropriate. Secondly, the way the model was calibrated, and then particularly the way it was checked against actual existing conditions at the junctions, I should say junctions, not junction, is unclear. It will be obvious to anyone even remotely familiar with these junctions, in particular, that they already suffer from severe congestion. Why, therefore, a contrary assumption is made within the appellant's model is an issue that will need to be explored in detail with the T Highways experts. But the parish councils at this stage emphasise that the heavy reliance on the fact that the modelling, and in particular the use of a standalone junction model rather than a network-wide model, was agreed by the local highways authority, merely begs the question as to whether or not the authority was right to do so. Baines Highways insisted on a different type of model in 2017. It also concluded in 2018, when assessing the Phase 1 application, that development of the scale sought in the illustrative master plan submitted at that stage by the appellant, which included development now sought for these phases, would have a severe impact. Its change of position between Phase 1 and this application is something that will need to be explored at this inquiry. But in summary, if the modelling is flawed, then the parish councils consider that this inquiry has insufficient information to satisfy itself that there's compliance with local plans policy ST1 and ST7 and MPPF paragraph 115D, 116 and 118. Comprehensive master plan issue. Policy B3A of the local plan, which allocates this site as a strategic site, sets a number of key requirements that development at Old Down Bar should meet in the form of placemaking principles. These include the need for a preparation of a comprehensive master plan through public consultation and to be agreed by the council, reflecting best practices as embodied by design or successor guidance, ensuring that it is well integrated with neighbouring areas. The appellant has, of course, submitted several iterations of its own master plan in support of its application, the last one being revision 8, dated 16th of August 23. But the mere submission of a plan prepared by a specific developer does not meet this requirement. Mr. Waters, whose proof is AM2, will explain in his evidence that he does not consider that the requirement in policy B3A requiring a comprehensive master plan has been met, and the reason why the appellant's approach does not make sense in planning terms, and why it ought to have been a further reason for refusal. But put simply, the appellant's case, namely that the requirement can be met simply by the submission as a master plan as part of a specific application by a specific developer, is premised on a flawed interpretation of this requirement of the policy. The remaining main issues in dispute. As to the remaining main issues in dispute identified in the inspector's post-CMC note, i.e. the effect of the development on the AONB, the effect on significance and setting of the World Heritage Site, compliance with the placemaking principles with regard to the pedestrian cycle link and mixed-use development and the overall planning balance, the parish councils are in broad alignment with Baines. In terms of the question of compliance with development as a whole, the parish councils entirely agree with Baines that the proposal does not comply for all the reasons set out in Mr. Reynolds' evidence. They, of course, go further and identified more policy breaches than relied on by the council for the reasons explained above. But in particular, the parish councils fully agree with Baines in its identification of the following multiple breaches of policy B3A and its placemaking principles. Placemaking principle 1 is not met because the proposal vastly exceeds the around 300 dwelling figure identified in that principle. PP1 is also not met because the proposal fails to deliver a mixed-use development, which was clearly envisaged in PP1. The policy clearly envisaged a residential-led mixed-use scheme. Reliance on ancillary provisions such as open space and allotments should be required in any event for residential developments on this scale is not a meaningful attempt to deliver a mix of uses. PP3 is also not met due to the adequate provision of green infrastructure, and PP5 is not met because the development would fail to avoid or minimise detrimental impacts on the AONB, character of the Cambric Valley and Sunas Manor Plateau, and the setting of South Stoke. Furthermore, in terms of both the exceptional in terms of the exceptional circumstances test, the parish councils adopt the same general position as Baines regarding the lack of exceptional circumstances justifying development in the AONB. In terms of the benefits the scheme would bring, the parish councils are also fully aligned with Baines and agree that substantial weight should be attached to provision of housing, including affordable housing, and this is agreed in section 19 of the main statement of common ground. But in summary, for the purposes of both the exceptional circumstances test and indeed the overall planning balance, the parish councils maintain the undoubted benefits of the scheme in terms of delivery of housing do not outweigh the harm this proposal will bring in terms of landscape harm, highways impacts, harm to the heritage assets, and the harm arising from the failure to accord with the placemaking principles in policy B3A. For these reasons and those set out in its written representations, the parish council would respectfully invite the inspector to dismiss the appeal. Thank you, sir.
Thank you, Mr. Neal. Can I just ask one point of clarification? In paragraph 6, when you refer to additional matters that are covered in the written representations rather than in evidence at this inquiry, and the final sentence says includes concerns over drainage, trees, and the sustainability of the scheme. I just wonder what that last reference is referring to.
Yes, you'll see from the objections in South Stoke's objection in particular. I could have the reference. I think it's CDAA 100. There's general concerns over the adequacy of the cycle links, for example, in terms of lighting and how effective they'll actually be in delivering a sustainable transport measures linking the site with its particularly to the north. That's the
So thank you. So it's a sustainable transport point. That's helpful. Thank you. Thank you, Mr. Neal, for those opening statements. Okay, so that brings us just to nearly 11:35, and that concludes the opening statements of the three main parties. We'll take an adjournment now, and when we come back, we will hear from interested parties. I propose that we have a slightly longer break for this first break until 12 o'clock, just to allow enough time for everyone to stretch their legs, etc. And also, if we can perhaps give some thought to where the speakers might speak from, whether or not that table that currently houses water jugs and can be repurposed as a table for speakers with a microphone provided, that would be helpful. Otherwise, we may have to ask a few people to rejig around the room. Or we have the table up here. A very obvious table next to me. Yes, that's fine too. Yes, I forgot that table was even there. Okay, well, if there's any room rearrangement needed, then let's do so. But otherwise, yeah, that's fine. Okay, are there any points before we adjourn? Mr. Tucker.
Yes, sir. So nobody's made a request for any audio-visual material, sir. I'm mindful that tomorrow certainly you will be hearing from... So I'm not sure. I'll try again. I couldn't see my red light on. So I'm mindful nobody's asked for any audio-visual material, sir. And I'm mindful tomorrow we will be calling witnesses on this side. So I wonder if perhaps we can give the nod to the chaps to my left and behind me that we can perhaps dismantle the scenery, because I don't think it's intended for the Teams call or anything of that nature.
I don't think that problem will arise because we will be in a different room and we won't be putting that up.
Okay, yeah, so
it's the short answer.
Good, that's not a problem.
That's fine, yes. Yes, after today we won't be in here, so no. That's fine. Thank you. Anything else from anybody? Any other procedural points from the appellant or
Not
Council?
from our side, sir. Thank you.
Or anything from the Rule 6 or anybody else in the room? No. Okay. Well, thank you all. When we return, we'll probably run through the speakers in the order I read them out. So that was Councillor Fiona Gawley first, if that's appropriate. But obviously, if we have to take speakers in a different order, I'm obviously fine with that, but just let me know when we resume. Okay, thank you all. We'll we'll adjourn until 12 o'clock. Thank you. Is resumed. Just a couple of things to say. I had a quick look at the YouTube link. That, despite the Wi-Fi problems, it appears to have been working okay. I've not been told otherwise. I noticed the video was still running during the break, but no audio, so that's okay in terms of obviously picking up any conversation. But just be aware that the video is playing during the break, just so you know. And then just a reminder in terms of the microphones, and I apologise for this, the first session, but obviously a reminder to anyone who's speaking to make sure that you speak into the microphone, and also remember to speak slowly and clearly as well, so that everyone in the room and online can hear. Thank you. In terms of the running order, I think we may want to slightly rejig things. So I'm happy if people have commitments and need to be away earlier than others to take that in order. I'm also aware that the CPRE representative isn't here, and I'm not entirely sure whether he was definitely coming or not, but I've been made aware that Mr. Nigel Long, I think it isn't here. But if he isn't, then we'll obviously, we'll move on. In terms of the first person who wishes to speak, I did say Fiona Gourley first, but is there somebody else who'd rather go first? So yeah, if you'd like to come to the front, I think we will make use of these microphones, and then we'll do introductions and so on. Thank you. If you want to maybe just check the microphone, see if that works.
Hello? Can everyone hear me? Yeah.
That's okay. So if I could just ask you to introduce yourself, first of all, please.
Yes, hello everybody. I'm Councillor Lucy Hodge. I'm Vice Chair of the Planning Committee, and I'm here today to read a statement on behalf of Matt McCabe, who is the Cabinet Member for Planning and Housing, and he unfortunately can't attend, but he has his father's funeral today.
Thank you. Thank you for reading it out. I would normally ask each person who speaks whether they're happy to answer questions, but I appreciate if you're reading out somebody else's statement, you may prefer not to answer questions on it from either myself or from the opposing party.
Yeah, I think probably best.
If you just want to read it out,
Yes,
and then we'll go from there. Okay. Thank you. Then, Councillor Hodge, if you would like to begin.
Okay. Welcome to Bath and North East Somerset. My apologies for not being with you today. As the Cabinet Member for Planning and Housing, I hope to say a few words at the beginning of this process. I should declare that as a parish councillor and as chair of Englishcombe Parish Council, I campaigned against this development and for an eastern exit if it were to go ahead due to the obvious road traffic impact on our village of loading more vehicles onto the park and ride roundabout. However, as a Cabinet Member, I will confine my comments to the process, specifically the wording in the original core strategy. For me, the obvious question is, what was in the mind of your previous colleague when he ruled that 300 units at this site should not be a limit, and accepted a change to this wording which embedded around 300 into the core strategy, so long as all other placemaking policies are met? What was his thinking? Because he didn't say around 400 or around 600. He specifically accepted a change to state that it would be around 300. The current applicant will argue that it is not the overall number that is important here, rather it is the meeting all other placemaking policies. They will argue that the important number is the density figure. However, if you apply that logic to all 5 phases on this site, then we could end up with around 800 properties within the development boundary without any community facilities. This would clearly be an unsustainable development. It is absolutely the case that if the core strategy had allocated this site for around 800 properties, or even around 500, it would have at least required facilities, such as the new school. Now, I accept that the council failed to secure a master plan for the whole site, and we are now dealing with the consequences, that is, piecemeal development. But it comes back to the thinking of your former colleague. How much weight did he put to the statement of around 300? That is a figure that was put out to consultation with the local community. That is the figure that the council voted to accept as part of the democratic input into the planning process. And that's important to us, clearly, as it means that we all accept that around 130 houses are yet to be built and should be built, but the current application takes the total to almost 500, and that's a significant uplift with no additional facilities. I would argue that 250 to 350 is around 300, which brings me back to the thinking of your former colleague. How important is the wording around 300? If it is important, how defensible is a figure that is closer to 400, or in this case, closer to 500? But your colleague did not say around 400 or 500, and in one sense he was very specific. Whatever you feel around might mean, it is around 300. I am clear in my mind that your colleague in no way thought that the number of houses to be delivered on this site should be unlimited, so long as all placemaking policies are met. That seems very clear to me, yet that seems to be what the applicant is saying. In making your consideration, I would ask, should you be minded to agree with the applicant, what happens to the landowners for phase 2 or phase 5? If you conclude that around 300 carries no weight and that a total of 470 units from this applicant, phase 1, 3 and 4, does not need further facilities to be a sustainable community, and phase 2 suddenly comes forward with 50 units, taking the total to 520, who provides a new school? Because that is what we would have secured if this site had been allocated for 500 units. But you can't ask someone who's providing only 50 houses to build a new school. I hope I have managed to set out my concerns around what the core strategy says and how the expectations of what it says have been interpreted by different parties. I await your conclusions with interest. Many thanks. Councillor Matt McCabe.
Thank you, Councillor Hodge, for reading out those comments from Councillor McCabe. Thank you. Then, if the next speaker would like to come forward, please, I'll take it in whichever order people prefer. So we'll do the introductions as before. So, yes, I've just obviously tried the microphone. I hope it should be fine. And just introduce your name, and if you could just say, your name and your role, and if you're happy to answer any questions on your evidence.
Yeah, so I'm Councillor Joel Hurst. I'm a ward member for Odddown, which is the neighbouring ward where the traffic's coming out into. I'm very happy to take questions.
Thank you. And I think you provided a copy of your statement by email.
Have.
Yes, I do have a copy, but please obviously go ahead and read it out, and then if there's any questions, we'll let you know.
Perfect. Thank you.
Thank you.
Okay, so I'm Joel Hurst, councillor for the neighbouring ward in Odddown, on the Bath side of the development. The appeal is of huge importance. The wrong decision will cast a historic shadow over the social cohesion and traffic management to our area. Previously, the presentation to the Baines Planning Committee, I feel, overstated the benefits and understated the harms of the proposed development. The failed application would truly be harmful to residents' much-loved open space. My comments for today, I want to focus on 3 points: affordable housing. The rejected application needs appropriate infrastructure and mixed use to be sustainable, and I don't think it has either. The space is highly important to the people of the south side of Bath. Building on the AONB requires exceptional circumstances, which I believe were not demonstrated. And third, I want to talk about the combined harm of the application, in particular the traffic. So in terms of Odddown ward, we have a reasonable amount of social housing within a 1.5 mile radius of the rejected development. There's Cranmore Place, Ridge Green Close, The Green, Corston View, the Odddown Estate. Challenges and pressures already exist for people in social housing. GP services are at capacity. There's limited social infrastructure, limited community spaces, limited nursery provision, and a library bus which comes for 2 hours every 14 days. Oversubscribed secondary school, to just name a few of the challenges. The on-foot distance from the rejected phase 3 and 4 application to the park and ride or a main bus stop would be at least 15 minutes for a fit person, and then at least a further 20-minute journey each way to town, hospital, or wherever people are going on to. From there, there's there's probably at least a 15-minute walk to the nearest local shop. My community feels that dumping people in need of social housing on the furthest edge of the city, isolated from overstretched existing amenities, is short-sighted. The development is not sustainable and will bake in car dependency for those who can least afford a car. In terms of then moving on to the area of outstanding natural beauty, you will hear about the AONB planning regulations later, I'm sure, in the next few days. In particular, this application, it has not been demonstrated that the exceptional circumstances exist to justify a further 290 homes. People need accessible green open space, connections to nature, spaces for their well-being. People's Sulis Meadows, Odd Down, Coombe Down, and much further have enjoyed this space and value it. Never in recent planning applications have people responded to an application in so many numbers expressing their concerns about the loss of this important green space. So I really want their views to be heard and a reflection on what are the exceptional circumstances to build on this AONB. In terms of the combined harm of the application, there is much that we could focus on: trees, bats, skylarks, AONB, but I particularly want to talk about traffic. The traffic lived experience of residents in Odd Down and much further afield in Coombe Down, South Down and beyond needs to be heard. You will hear from the traffic consultants, you will hear about the various modelling that has been done, but I want you to pay attention to the voice of the residents who have commented in large numbers in the application. So there's numerous comments in the documentation on the planning portal. The traffic is already not safe because of the queues. As me personally, a commuter from Odd Down to Midsummer Norton, I daily observe people going around the park and ride lane on the A367 to jump the queue, causing gridlock around that roundabout. The Old Foss Road and A367 junction, accidents are already happening right by St Gregory's School. It was 7 years ago we had an unprecedented attendance at a public meeting in Odd Down to discuss traffic congestion. The traffic flow south of Bath City, either north-south or east-west, ends up at the pinch points in Odd Down of where the Froome Road meets the A367 or the Midford Road. With ongoing growth in student numbers, growth in housing south of Bath, significant infills in places like Mulberry Park, day by day, hour by hour, congestion gets worse and is blighting residents' lives. So in summary, this development does not have public support. This is not the right place, and exceptional circumstances have not been shown to build on the AONB. Why are there no community hubs for toddlers, the youth, the isolated? Why is there no community shop? Why are we willing to dump our vulnerable residents on the edge of town without adequate facilities? The lived experience on the impact of the traffic needs to be heard. And so I kind of respectfully ask that the Planning Committee's rejection is upheld. Thank you very much.
Thank you, Councillor Hurst. I'll just ask Mr Tucker if you have any questions for Councillor Hurst.
I don't, sir. Thank you.
Thank you. I don't have any questions either. I will just say that your statement, we'll add that to the inquiry library, so it's there for obviously anyone to see what was said today. And I don't think that necessarily got through to the appellant, so I will ask that to be forwarded, please, for that.
Yes, sir. I was seeking to follow on. Just make sure I've got the correct number. Core document AA116, which is a joint statement from Councillor Hurst, although it's misreferred to as Durst for some reason, I'm not sure, and Councillor Hodges. That's the most up-to-date, the one that's on the core document list. So, sir, I would welcome sight of the additional document.
My case officer has it as email, so I will make sure they get circulated to the parties, and we'll put that down as ID 7. But thank you, Councillor Hurst, for your time. Thank you. Who's next? Okay, thank you very much. Thank you. So, yes, if you could, again, introduce yourself, your background, and whether you're happy to answer any questions.
My name is Fiona Gawley, and I am the Ward Councillor for Bathhaven South, and I am happy to answer questions.
Thank you, Councillor. And I think we have had your statement sent through, and I believe that has been copied. No, it probably hasn't been. I'm very sorry about this. It doesn't appear to have been copied to the appellant. Again, my oversight on that. We will obviously make sure that it gets circulated around in due course. Yeah.
I can take notes of any point which arises which is different from the points made already, so thank you.
Yeah, okay. Thank you. Councillor Gawley, when you're ready, please begin.
Okay, yes. I speak on behalf of the residents as a Ward Councillor for Bathhaven South, which is the 13 parishes south of Bath. These include Southstoke, Coombe Hay, and other parishes which objected to this application, and include Soulis Down. The overdevelopment of Soulis Down and its impact on the environment, surrounding communities and traffic has been a major concern raised by residents with my predecessors and myself over many years. Since the 1980s, the HFT have repeatedly attempted to build all over Southstoke Plateau, almost regardless of Bain's housing need, planning policies, or the prevailing local plan. Previous iterations for up to 800 homes, an enlarged business park, and roads right across the plateau have been rejected. All these attempts have been fought vigorously by local councils and residents. We want to protect this area of accessible flat land on the south of Bath, its rural nature and its heritage. It's cherished by thousands of people who value the countryside and wildlife. The network of paths has been well used for decades or longer, predating HFT's labelling some of them as permissive. The announcement that HFT will close their permissive paths if they lose this appeal has shocked the local community. Is barbed wire and keep out signs really the legacy that the Hignett family want to leave? What is notable about the appellant's piecemeal approach is the lack of master planning and absence of meaningful consultation or engagement with the local community. Since an exhibition well over a decade ago, there have been few changes apart from removing a primary school. There's been little acknowledgement of residents' concerns, attempts to improve the plans or mitigate the impacts. This has been a missed opportunity to make a really good development. The most recent application has received over 1,500 objections, including 6 local parish councils and nearby ward councillors, and some 150 people attended April's planning committee, at which the application was soundly rejected. By contrast, only around 20 people wrote supportive comments, and I've had virtually none from my residents. The residents of Soulis Down Phase 1 and 3 and 4, if it's granted, will become my residents, so I am rightly concerned for them too. Phase 1 residents have already told me about value-engineered homes, skimpy finishes, inadequate water pressure and drainage problems, no allotments, and poor access to the park and ride and Odd Down. If the water pressure isn't sufficient for 170 houses, how can it be enough for another 290? Phase 1 homes have individual soakaways because they are too close together. They all rely on one big hole in Derriman's Field, which is above Fuller's Earth and risks potential flooding and slippage into the Coombe Hay Valley. There are no such plans for phases 3 and 4, which are even closer together, so where will all the water go? The lack of allotments in phase 1 is an example of poor master planning. The proposed site has moved several times between phases 1, 3 and 4. We now have the ludicrous situation with 2 current planning applications for phase 1 allotments in 2 different places and 2 different parishes. Several years after building started, and 3 years since the first residents moved in, there's still no direct access to the park and ride. The appellant has only recently secured scheduled ancient monument permission for a proper walkway along the Wansteig. So there's still only a muddy scrumble over the wall to the Odddown Park and Ride and shops, the Odddown shops and schools. The issue for phases 3 and 4 that access to schools and shops will be longer and more difficult, whether by bike or foot. So for how long will future residents be similarly stranded amidst the fields? Over the last decade, Baines has been unable to enforce all its requirements for affordable homes and community facilities promised on large housing developments. These tend to be reduced or disappear between outline and full planning permission, following viability processes or if the site is sold on. So the promise of 40% affordable homes, the main reason posited for accepting this overdevelopment, could be regarded with a pinch of salt. And if the overriding benefit is affordable homes for people with lower incomes, they will need good access to public transport. But Soulis Down is not designed to take a bus route. The Cross Keys bus stop one way, the Park and Ride the other, and Sainsbury's across the fields will be a good 20 minutes walk via unlit paths. So people, and a steep push for bike, wheelchairs or buggies over the Wansteig. So people on lower incomes could be forced into car dependency willy-nilly. Many of my villages have no alternative but to drive to work, education or shopping because of poor or non-existent rural bus services. Multiple planning parish councils and residents have told me how bad queuing along the main roads, poor driver behaviour and rat running through villages is now. It takes very little, such as an accident or roadworks, to create gridlock with severe impact on emergency vehicles, buses and cars alike. Many people are very worried about how much worse it will become if 290 cars from 290 or more homes is added at this key node in the network. My concern is that phases 3 and 4 will end up as a badly built, overcrowded, car-dependent dormitory estate and not a sustainable community. There's no mixed use, and the only communal facilities are a playground for kids and some allotments. There's no community hall for toddler group, youth activities, or coffee mornings. The residents will have to leave the site for work, schools, shopping, and a social life. Odddown, the nearest community, is a socially and economically disadvantaged area with stretched community facilities on reduced budgets. But they won't get direct funding from Soulis Down. Southstoke and Coombe are tiny villages with limited amenities, only connected to Soulis Down by unlit tracks and rural lanes. We know that 130 houses remain to be built from the around 300 allocated by the previous inspector. But Odddown Football Ground and Soulis Manor are also on the allocation and could be developed in the future. So we have no idea how many houses could potentially be built on top of the 290 proposed here. Local residents and surrounding communities feel very anxious about how we will all cope with more traffic, the strain on local facilities, and the destruction of the Cotswold landscape and local heritage. Giving permission to this overdevelopment, which breaks the local plan and doubles the homes allowed, would be a very bad outcome for both current and future residents in my ward and the wider area. Thank you.
Thank you, Councillor Gawley. Any comments, or questions rather, Mr. Tucker?
So you'll appreciate that my clients profoundly disagree with some of the statements made there, particularly the comments with regard to the appellant itself and its past conduct. I don't intend to take those up by questioning because I don't suspect that's helpful. So what I intend to do is deal with the substance of the points that have been raised rather than the advocacy through the evidence of my witnesses. Thank you, sir.
Thank you. I'll just ask one question of clarification. I think I may have seen this yesterday. You referred in the phase 1 development doesn't currently have direct access to the park and ride. I saw a pedestrian crossing that was not in use, just in the entrance.
That's correct, because the rest of the path hasn't been built because, as I understand it, there was insufficient funding to complete that. But my colleagues in planning might be able to answer that.
But maybe something to pick up later on, but that's the crossing point that you're referring to. Okay, understood. Okay, thank you. No other questions, so thank you for your time, Councillor Gawley. Hi there. So if you could, just make a short introduction of who you are and your role, and if you're happy to answer any questions. Thank you.
Thank you very much, sir. I didn't expect to speak this morning. You will probably notice that I came in late, and I do apologise for that. It was because I was stuck for half an hour in this said traffic congestion that we're debating today. And coming from the Tunley point, the Tunley turn, just below the Park and Ride, through to Bear Flat took half an hour. So that, that gives you a measure of the problem quite in practical terms. I should explain that I'm Councillor Jackson. I represent Westfield, which is right on the edge of civilization, on the Mendip border with Mendip. And in fact, I usually attend planning inspectors' inquiries for planning applications in Mendip because the border runs along the edge of my ward and we're very much impacted by anything going on the other side of Midsummer Norton or further down the A367. I should declare an interest, I think, before I start. Believe it or not, my younger son is a qualified planner and he works for AECOM, but he has never discussed this application with the Bristol office. He works in Toronto on suburban train lines, and I have never discussed it with him either. There being more important matters in my world, if I might dare say so. But I think it should be noted, I have a son who worked on the transport. Oh, sorry, I do beg your pardon. I think it should be noted that I do have a son who works for AECOM, who worked as consultants for the applicant. And the other thing I must apologise for is that I have not got this as a typed out statement because I wasn't expecting to speak this morning. I'm filling in for the chair of the planning committee, Councillor Hansel, who's unwell. I have been, though, on the planning committee for Bath and North East Somerset Council for 18 years, and I have seen pretty well all the applications that relate to this site come through. And also I'm part of the Local Development Forum, so the whole question of the development of the local plan, its update, the new local plan, and so on have been through my inbox, as it were. And you might indeed think that it's a bit strange, this is another important point, that I, who represent the Labour group in planning matters and was the Labour chair of the scrutiny panel for housing and development at one point, should be involved with an area which is predominantly liberal or conservative. But it's really important, I think, to make the point that this is non-political. There has been, of course, mention of Ms. Rayner, who I've met several times and talked to new government emerging policy on housing and so on. But here we operate in a non-political way and don't score on the planning committee, score political points against each other. Oh dear, I can't read my own handwriting now. As I said, I promised, sir, I would make this clear. I think one of the most important things to say, though, is that although we are non-party political, we all consider it extremely important to listen to residents. And you've already been told just how many residents objected. I was on the committee when we had an enormous turnout for hearing this particular application that we're debating now, and I was very impressed with how the residents how well they were informed. Another point, I consider that a councillor has to not only listen to residents and to parish councils, and I'm on Westfield Parish Council, but also our officers. And I think it's really important for you and everybody else to understand that we have a pretty good relationship, I think, with our officers, and the highest regard for them, especially the senior ones who are so experienced. And I'm always very upset anyway when one of them leaves because they contribute so much. But we have the right to disagree. It's very finely balanced. It was very finely balanced in the Planning Committee debate, which was one of the longest we've had. Maybe it was a good practice for the Bath Rugby Club application, which is coming in shortly. But anyway, it was very long. We listened to everybody. I am convinced the process was right and fair. We made a site visit, and that is really important because I have to admit that walking around the site, looking at it for all angles, looking at the trees, at the Sulis Manor, looking at the AONB views, and of course I'm a church historian, I love the ones like the whole idea of this useless dyke that didn't keep the Vikings out. That modified my views considerably. So I think it's unfair to say that the process was flawed because in my experience, as I said, of 18 years, it was not. I could, of course, follow the previous speakers and talk about what is known in the jargon as the rabbinic squeeze. I am a church historian, but also a New Testament scholar, and you can analyze one word in the Gospels to infinity, and that was what used to be done in scholarship. And I don't like, I just can't do it on planning policy. It's the intention, it's the effect, it's the general understanding that I think is probably most important. But back to the reasons why I and the committee felt so very uncomfortable about the whole thing. And I think it can be summed up, though, in 2 words: residential amenity. That when this site is built, it will, first of all, impact on the residents living around it, and secondly, on those who buy houses here, who, I'm afraid, with Bath prices, are not going to be the sort of people who buy houses in Westfield. In fact, we've got quite a migration of Bath residents moving out to the Somer Valley because they cannot afford the prices in Bath. And affordable is considered to be 80% of the going market rate. Don't know why it's 80%. In Birmingham, it's only 50%. But the fact is that even what is deemed affordable will be too expensive for a nurse at St Martin's Hospital, which is on more or less an adjacent site, and the nearest professional workplace probably. They won't be able to afford to live here. And this is, of course, the other reason why we will have a traffic problem, because people will have to commute to find better paid jobs in Bristol and Bath. And actually it is a recognised fact from all the work the council has done that something like 60% of residents commute to Bristol, to London, because we have a good rail link and so on, and do not work locally within 5 miles of their residence. And this is most unfortunate at a time of climate emergency. So just to round off, I think the officers have put forward the right reasons for objecting to the applicant's appeal. I think the basis on which we made the decision was as sound as you could expect rationally from cross-party selection. We have all 4 parties on the planning committee. Obviously the administration is Lib Dem. There is myself for Labour, Councillor Hughes for the Independents, and 2 councillors for the Conservative Party, and we are all agreed on this one. I myself believe strongly in what's called the Blears formula. Hazel Blears doesn't get the credit she should have for the policy she developed at the close of the Blair administration, that every house should be accompanied by the creation of a job. And this is what this application is missing. There is no as has already been said, there will be no social facilities, and I've seen what that does up in Midsummer Norton at the White Post. There will be no way for anybody to develop a business proposition. There'll be no premises, and the back bedroom is really not the ideal place to run a business from. And this is why I we can argue for a long time about, or the other point is, we can argue for a long time about how many angels dance on the head of a pin, as was the Middle Ages theological conundrum. This is going to be too dense, too many houses are in one relatively small area. And that's the final reason why I would ask you, sir, to reject this appeal.
Thank you, Councillor Jackson. Any questions, Mr. Tucker?
No questions, sir, but I do want to deal with one apparent misapprehension. Sir, we are proposing, in relation to the affordable housing mix, a policy-compliant affordable housing mix, which my understanding is 75% social rented. But that's a matter Mr. Stacey can deal with. I think the councillor was under the misapprehension that part of MPPF allows discounted market homes in terms of affordable housing where it's pitched at 80% of the market rate. That's not our case. We're not doing that. We're proposing the policy compliant mix for affordable housing. But that's really just correcting a misapprehension. Other than that, sir, I'll deal with points in evidence.
Okay. Thank you. And no questions from... well, I think...
Well, I'm sorry, I apologise if I got the facts wrong, but I was assuming it was 80% of the value of the property that will be the deciding factor in determining how much affordable housing would be.
Okay, okay. Well, I think it's a point to pick up. Unless there's anything else to say.
No, I'll ask Mr. Stacey to explain. I'm sure that
okay.
The councillor will be more than welcome to listen to him when he gives evidence next week.
Yeah. Okay. Thank you, Councillor Jackson. Sorry, I was expecting somebody else to be walking up. I'm happy to take whoever wants to come up next. On my list, I had Councillor Mike Clarkson from Wellow Parish Council. If Councillor Clarkson wishes to come up next. Thank you. Thank you. And as with other speakers, if you could just introduce yourself and your role, and if you're happy to answer any questions.
Yes. My name is Michael Clarkson. I am a Wellow Parish Councillor and Chairman of the Wellow Community Bus Group, and I'm happy to take any questions. I'm speaking as a Wellow Parish Councillor and Chairman of the Wellow Community Bus Group, a local charity providing minibus transport into Bath for Wellow school children, commuters, and shoppers from our village 3 miles south of Bath with 550 parishioners. We drive up to the Odd Down Park and Ride and into Bath and back 4 times a day. And as the only bus service from Wellow, we're concerned that our timetabled operations will be severely compromised by the considerable increase in traffic were the proposed phases 3 and 4 to go ahead. The prospect of additional 290 houses added to the 171 currently nearing completion raises the prospect of hundreds of additional vehicles exiting the site from the single access road, which has been given priority onto Coombe Lane, further delaying our minibus service and adding to the existing congestion at the Odd Down Park and Ride roundabout and the Red Lion roundabout. We have already had to adjust our timetable to allow 5 extra minutes to our morning services at 7:35 a.m. and 8:25 a.m. due to the rush hour traffic congestion at Odd Down and Red Lion. And we're concerned that large numbers of additional vehicles from the Soulis Down development would further exacerbate congestion and journey times. The queuing times for our minibus at the roundabouts vary, but 5 to 6 minutes currently is normal, and obviously we're concerned that that will increase. Should the development go ahead, we would strongly support the need for an additional exit for vehicles to the east of the site onto Midford Road in order to reduce the congestion at Coombe Lane and the Odd Down roundabout. and to provide a better route for vehicles from the site heading south to access nearby towns such as Frome, Trowbridge, Warminster and Bradford-on-Avon. We therefore welcome Bath and North East Somerset Council's decision to reject the planning applications for phases 3 and 4 and hope very much that the inspector will reject the appeal. Thank you.
Thank you. Councillor Clarkson, any questions, Mr. Tucker?
No, thank you, sir.
Councillor Clarkson, if I could just ask you before you leave, just the route that the bus takes from Wellow to Bath, is it via Coombe Lane or is it via the main so you don't use the microphone again?
No, the route we take is up Bath Hill from the centre of Wellow, past the Coombe junction, up Coombe Lane, and then onto the new junction from Soulis Down. Yeah, so directly north up from Wellow.
And I saw that yesterday, so there's now a kind of a T junction there where coming up the lane you'd have to give way to traffic coming out of Soulis Down, the new housing. Was that what you're referring to, the priority?
Yeah, basically we used to have our own way straight up to the T junction, and now the priority has been given to traffic exiting the site, and we have to wait for traffic exiting the site before we can get onto into Bath.
And then you go down to the roundabout.
Then we go down to the
yeah.
T junction and then to the various roundabouts.
Okay, yeah, that's helpful. Thank you. Just to understand that route. Thank you for your time.
Thank you.
Okay, thank you. So the next speaker on my list is Simon Joyce from the Cotswolds National Landscape Board, if he wishes to come up next. And obviously, I've already introduced you, but if you would like to just introduce yourself again,
yeah,
and just let me know if you're happy to answer any questions.
Yeah, I'm Simon Joyce, representing the Cotswold National Landscape Board, and yes, I'm happy to answer any questions. Good morning, sir. My name is Simon Joyce, and since November 2021, I've been employed by the Cotswold National Landscape Board as a planning officer, and it's in this capacity that I'm here representing the board today. My principal role is to provide the board's responses to development management consultations across the 15 local authorities that overlap with the Cotswolds National Landscape Board, Cotswold National Landscape. It was in this capacity that I authored the board's written responses to the application and representations to this appeal. The Cotswolds National Landscape Board has two statutory purposes. Firstly, to conserve and enhance the natural beauty of the Cotswolds National Landscape, and secondly, to increase the understanding and enjoyment of its special qualities. The board supports the council's refusal of this application. I've read the council's evidence in respect of planning and landscape matters and considered that it reflects the board's assessment of the proposal. Therefore, the board does not seek to provide any additional evidence to the appeal and would rely upon that submitted by the council. However, the board does wish to briefly comment upon matters relating to national planning policy and statute regarding protected landscapes. The board understands that it is common ground between the appellant and council that in terms of the requirements of paragraphs 189 and 190 of the National Planning Policy Framework, this proposal represents major development within the Cotswolds National Landscape. We concur with this assessment. Paragraph 189 of the framework is clear that great weight should be given to the conservation and enhancement of the landscape and scenic beauty of the national landscape. It's also clear that both the scale and extent of development within such areas should be limited. The Council finds that the development would be contrary to local plan policies NE2 and B3A and the advice contained within the MPPF. The Board supports the Council's view that the appeal proposal would neither conserve nor enhance the natural beauty of the national landscape, and that the application is not consistent with the requirement that the scale and extent of development within the national landscape would be limited. Paragraph 190 of the framework states that planning permission should be refused for major development other than in exceptional circumstances and where it can be demonstrated that the development is in the public interest. Paragraph 190 also requires an assessment, firstly, of the need for the development, secondly, of the cost of and scope for developing outside the designated area or meeting the need for it in some other way, and thirdly, a further assessment of any detrimental effect on the environment, the landscape and recreational opportunities and the extent to which they can be moderated. We agree with the Council's view that this proposal does not fulfil these tests. The exceptional circumstances required to justify this major development in the national landscape have not been demonstrated, and it would not be in the public interest to allow this appeal. The statutory purpose of national landscape designation is the conservation and enhancement of its natural beauty, and the Board respectfully wishes to highlight the Protected Landscapes Duty, whereby Section 85 of the Countryside and Rights of Way Act 2000 has been amended by Section 245 of the Levelling Up and Regeneration Act 2023. In amending the duty, relevant authorities must now seek to further the statutory purposes of protected landscapes. This replaces the previous duty on relevant authorities to have regard to their statutory purposes, and it is a strengthened duty as well as being an active rather than a passive one. The Board considers that furthering the purpose of designation means that the natural beauty of the national landscape in this location would be left in a better state than its pre-development baseline condition. The Council has identified that this proposal would give rise to a level of harm which would be irreconcilable with the duty, and therefore we support the Council's view that the proposal would not further the purpose of designation. Accordingly, we consider this to be a further reason as to why the appeal should be dismissed. Thank you for the opportunity to address the inquiry today.
Thank you, Mr. Joyce. Mr. Tucker, any questions?
I do, sir, and the majority of these points I'll deal with through my witness's evidence, but I do have just a couple of points to ask Mr. Joyce, if I may. Really questions of clarification, if I may.
Yes.
Mr. Joyce, good afternoon. Can I just be clear what you've agreed to, first of all, because I don't want to mischaracterise it in closing. So the position of the board is to ally themselves with the council that this is a site appropriate for up to 150 new homes. Is that the position?
That's correct.
Right. That comprises major developments in the AONB, yes?
That's correct.
So, to be clear, therefore, I can characterise your position as concurring that this is an appropriate site for major development in the AONB, notwithstanding the change in terms of the duty, yes?
That's correct.
Thank you. Your concern relates to the addition over and above the 150 described by the Council's landscape witness.
Correct.
Thank you very much. I can put the points about the detail of that to her, but I just wanted to be clear that you were no longer contending that there should be a review of the plan to essentially go behind the allocation. That's not your position, is it?
No, the board's never made that.
Thank you very much, Mr. Joyce. That's very helpful indeed.
Thank you.
Thank you, Mr. Joyce. I don't have any questions for you, so thank you for your time today.
Thank you.
Thank you. And then next on my list is Ned Garnett from the South of Bath Alliance, if he'd like to come up. Thank you. And as before, if you could introduce yourself and if you're happy to take questions.
My name's Ned Garnett. I'm speaking on behalf of South of Bath Alliance, and I'd happily take questions. I should also point out I'm a Southstoke Parish Councillor, but now I'm speaking on behalf of the South of Bath Alliance, SOBER, as an interested party, not the Parish Council as a Rule 6 participant. SOBER aims to represent the views of all the communities in the South of Bath who will be affected by this proposed development. We have around 900 followers, and we also do work in relation to just basically analysing the paperwork that it comes out, as it comes out, and sharing that information to enable our followers to be aware of the many changes that there have been to this application. The allocation of the Southstoke Plateau in 2013 local plan was very controversial. Most of the allocation was originally in the Green Belt, and it was and still is in the Cotswold area of outstanding natural beauty. There are major concerns within the adjacent communities about traffic congestion and the impact that these additional houses will have on local services, roads, and the Cotswold national landscape. The current adopted local plan was written to be read and understood by local people. When we read there will be a comprehensive master plan, we assume it will be comprehensive. It will cover the entire allocation, not just the part owned by the appellant. It will be a plan. It will be agreed at the beginning and set out what will happen in the future. And yet there is no agreed plan, and it seems to change every time we get a new batch of documents. We're now on version H. We currently have the ridiculous situation where we have 2 live proposals with the allotments for phase 1 in different places on the master plan. Policy B3A requires the comprehensive master plan be prepared through public consultation and agreed by the council. We assume there would be some meaningful engagement between the developers and the local community. What we got for this application was a questionnaire with 6 very limited and leading yes/no questions and 2 comment boxes. There were no questions about housing, housing numbers, landscape or traffic. The response was overwhelmingly negative and made 0 difference to the plans that were subsequently submitted. Following this particular round of consultation, the case officer said in a letter to the appellant in March 2022, "Given that these proposals are likely to be locally controversial, I suggest that further engagement and consultation with the local community will be beneficial to any subsequent submission." There has been none. Although most of our followers would rather that there was no further development on the plateau, we accept that this is an allocation of the local plan and that it is likely there will be some further houses there. Our arguments are not about development, they're about excessive development. As Councillor Gawley has pointed out, it's no secret that the appellant wants to build across the entire plateau and is constantly pushing to up the housing numbers. During the scoping exercise in 2020 for the environmental impact assessment, Baines asked that alternate scale, mass and quantum of development be considered. This has not been done. When the recent LPPU was consulted on in 2021, Frampton's applied to change the wording of B3A to around 450. This was considered by Baines and rejected as evidence shows that this would be too harmful. The appellant ignored this and went ahead and submitted an application for 300 more houses, reduced subsequently to 290, that would bring the allocation to the even higher figure of 461. 511 if you include phase 2. This is not around 300. As part of this inquiry, Baines have produced a landscape proof of evidence. This demonstrates that it may be possible to include a further 130 to 150 dwellings on the site and still comply with the placemaking principles in Policy B3A, but not for 290 more houses. And finally, traffic. We'll hear a lot more about traffic later. We've heard a lot about traffic already. We'll hear more later today and tomorrow. There are serious issues with congestion in the south of Bath that many people experienced this morning that this proposal will add to. It's a cul-de-sac development with a single entry and exit point for motor vehicles onto the Park and Ride roundabout, which is a notorious bottleneck. The appellant claims from their traffic modelling that the current maximum queue delay is 15.53 seconds. The 0.53 seconds is a bit of a clue here. This isn't an actual observation, but the result of a computer model. They have produced over 2,000 pages of transport reports for this application, and there is not a single actual measurement of a real queue anywhere in there. The only actual measurements of delays are in the Alan Bales report commissioned by Southstoke Parish Council and funded by donations from parishioners. This found a maximum queuing time, not of 15.53 seconds, but of over 12 minutes. You only have to read the comments on the Baines website from the community and the comments you've heard today to see that this type of congestion is a daily experience. If you can't model the current queues, how can you actually predict the impact that this development will have? You just simply can't. And this development will be heavily car dependent given the poor public transport and with all local services having to be accessed off-site. We respectfully ask that the planning inspector upholds the near unanimous decision of the Baines Planning Committee and rejects this appeal. Thank you.
Thank you. Sorry, is it Dr. Garnett or Mr. Garnett? Dr. Garnett, yeah, thank you. Sorry, thank you, Dr. Garnett. Mr. Tucker, any questions for Dr. Garnett?
Same position, so I'll deal with this through my evidence, including correcting the position of Baines at the placemaking examination in public, but I've got no questions for the witness.
I don't either, but thank you for your time, Dr. Garnett. Thank you. And then next, I think it's Alex Sherman from the Bath Preservation Trust, please. So if you could just set out your role at the BPT and if you're happy to answer questions.
Good afternoon. Thank you. My name is Alex Sherman. I'm the Chief Executive of Bath Preservation Trust, and I'm very happy to answer questions. Thank you. This development does not yet uphold the spirit, the policies, or the principles of the placemaking plan or the designation of the World Heritage Site and AONB. The core strategy and placemaking plan is not only a policy, but it is a social contract, and the community rely on the statements of Baines Council as having been made in good faith on their behalf. The plan states that around 300 houses may be built at Sulisdown, and BPT and the community broadly agree with this statement. The inspector used the term 300 or so, implying a maximum number close to 300, but a total of 461 does not match the spirit nor language used in that inspector's report. The harm to heritage and landscape is major. The AONB is a national landscape, Bath a double inscribed World Heritage Site. There is, I would agree, a proportionate harm to heritage and landscape which is acceptable if 300 homes in total are built. But a 50% increase to this is unacceptable in both its harm to heritage and also acts against the good faith of the community. It is a breach of that social contract. Previous council options appraisals dismissed development at the site due to the significant harm to landscape and heritage, and in 2009 the language was strong, referring to high impact. Since that time, the heritage significance of Bath has increased, not diminished, with a second World Heritage Site designation. So the notion that heritage and landscape is somehow less important now than in 2009 is both nonsensical and inconsistent. So the balance, the planning balance, is fine and delicately poised. Harm to heritage may be outweighed where public benefit is provided. This development provides 40% affordable housing, but this is a long way short of the 77% affordable housing stated as required in the latest local plan evidence base. So it does not provide the public benefit needed for Bath. If the public benefit is good, but not good enough, harm to heritage and landscape in this sensitive area is not outweighed. And the unaffordable housing is also very unaffordable. The average household income in Bath is around £55,000, so the starting price of £450,000 for a two-bedroom flat is unachievable for most local people. Someone on the new national living wage, though, working full-time, will take home £1,705 each month. So to be affordable, rental prices would need to be 33% of take-home pay, or £567, which is not achievable within the current policy and it's not what is being proposed. Added to that, with no facilities, this is not placemaking, but the risk of a failure of planning, a dormitory, isolated estate without community infrastructure. Suggesting a multi-use path is a solution, but crossing a field in a dark, unlit, exposed location is only one solution, but it's in isolation, this as an approach is disingenuous. Sulis Manor is a significant non-designated heritage asset within the parcel of land, including the house and design gardens. If it was a listed building, a Grade 2 listed building, it would be made more significant because of the reason and the origin of how it was commissioned. It would be upgraded to a 2-star listed building. So I would argue that the significance attributed to this non-designated heritage asset has been significantly understated. And with an increased number of houses, the impact of that non-designated heritage asset becomes more significant, losing the legibility of the house and location because of severe impairment and deterioration. Across Sulis Plateau, there is evidence of Roman and Iron Age occupation made possible by the Fossway, now the A367. The proposals cause significant harm, destroying any further archaeology and the form and design of the site. As has been reported in one of the accompanying reports, there are 53 attributes underpinning the 6 outstanding universal values of the Bath World Heritage Site. But the impact has been understated as this development contravenes 6 of those, not 2, as suggested in other reports. And this is evidenced by a significant piece which sits within the World Heritage Site setting SPD in map 10, which shows that this site is materially important to a Roman historical site, therefore impacting the first outstanding universal value of World Heritage, which has not previously been reported elsewhere. These attributes were prepared by Baines Council and submitted by the UK government as the state party to UNESCO in 2014. They are a commitment by the government to uphold the values of World Heritage. So to conclude, the proposals do not uphold the good faith of the community. They do not fully address the need for affordable housing, as stated. It will cause irretrievable loss of an area of protected national landscape and cause significant irretrievable loss relating to 1 in 9 of the 53 attributes of outstanding universal value of the City of Bath World Heritage Site. And the way to improve public benefit would be a smaller development within the spirit and stated numbers within the placemaking plan, community infrastructure, and greater affordability. Delivering on promises increases public benefit to outweigh the harm to heritage and uphold the council's social contract with the community it serves. This concludes our statement.
Thank you, Mr. Sherman. Any questions, Mr. Tucker?
Again, sir, much we disagree with, but I'll deal with it through my witness's evidence. Thank you.
Just a couple of points of clarification. You mentioned the second World Heritage designation. I mean, we will have a Heritage Roundtable later this week, but just in case you're not here later on. Is the second one the European Spa Towns designation?
It is. That was added in 2021. And
right.
I will be present for that roundtable on Friday.
Okay, that's fine. So is it contiguous with the same boundaries? Is it the same?
It's in effect, yes. My understanding is that it's contiguous within the same boundaries because the land, particularly relating to the landscape setting, the therapeutic landscape, which is referred to in that second designation.
Okay, fine. Well, we can obviously pick it up. And then the other point you mentioned about Surdus Manor, if it was listed to be grade 2 star, I mean, again, we can probably pick this up at the round table, but just I'm curious to why you say it would go in at 2 star, not 2, for example.
So the Surdus Manor was commissioned by a person called Thomas Sturge Cotterill, who was a notable architect active from about 1890 through to 1950 when he, at his death. Sturge Cotterill was mayor of Bath at one point, an alderman, and committed his life to the conservation and recognition of the importance of Georgian heritage and architecture. And the work that he undertook from 1890 through to 1950 was a significant contributor to the attribution of the World Heritage status of the City of Bath. So if we were to be talking, if that asset was designated as a grade 2 listed building, it would be made more significant to become a grade 2 star listed building. And my organisation looks after a building which had exactly that uplift to its listed designation because of the people who inhabited it.
So it's the local associations with somebody important to Bath's history, essentially.
And his reason for commissioning the building at that site, yes.
Okay, thank you, that's helpful. And just one final point, if it's possible to have a copy of your statements, same for anybody else who's read out a statement, if you wanted to email that via the case officer.
Yes, of course. I've been away from the office for the last week, so I've been unable to do so, but happy to circulate.
Thank you very much.
Thank you
for your time. Thank you. Then, so I believe Nigel Long from the CPRE isn't here, and it may be a mistake on my part to think he was coming. So unless anyone has an update on Mr. Long or CPRE, we'll move on. So next on my list is Jessica Pike. Ms. Pike is here and wishes to speak. Has she had to? Was she here earlier or? Oh, okay. Does anybody know whether she still intends to speak or not? Okay. I mean, obviously, if for whatever reason she's not able to make the session right now, we can see whether we can accommodate Ms. Pike at another point this week. If anyone has any ability to contact her, that would be helpful. But otherwise, we'll have to move on. So, penultimate person on my list was Robert Hellard, who's asked to speak. Mr. Hellard, are you here? Yeah. Thank you. Thank you. And if you could just introduce yourself and if you're happy to take any questions.
So my name is Robert Hellard. I'm a local resident. Until recently, I had lived in the heart of Southstoke for nearly 50 years, but have now moved to live in the adjoining parish of Hinton Charterhouse. I was elected onto Southstoke Parish Council in 1987 and remained a member for 30 years, until 2017. For much of that time, I held the posts of chairman or vice chairman. I represented the parish council at the examination in public of the current local plan in 2014. In preparation for that, I attended several meetings and consultations with senior members of Bain's planning policy team, who were the specialists preparing the new draft local plan. Whilst they were proposing that part of the farmland at Sullistown should be removed from the Greenbelt to meet unmet housing needs, they were quite clear that the achievable capacity of that area was around 300 dwellings. This number was assessed as the maximum that could be accommodated without causing unacceptable harm to the AONB, the conservation village of Southstoke, the World Heritage City, and the highway network. The inquiry inspector reached the conclusion that they were correct, and the current local plan, with the site-specific policy B3A, was subsequently approved by the government and adopted by Bains. It was absolutely clear then that the capacity of this new land allocation was expected to yield around 300 units, not the 460 currently proposed, a 50% increase, or 70% if you include land allocated at Sullis Manor and the football club. In 2018 and 2022, the NPPF was revised and increased the protections to be afforded to the AONB. If the rules that are now current were in existence in 2013, it seems highly unlikely that the balance of the possible benefits would then have outweighed the obvious harm to the AONB. This land could not then have been allocated for development, and the scale of development should not be increased now. The appellant has also claimed that the level of employment opportunity at Manor Farm Buildings, could be significantly increased. This area remains in the Greenbelt, so any further development on this site, for which access is along a small track and Southstoke Lane, will be subject to the limitations of Greenbelt policies, as well as those of the AONB. The EIP inspector made particular reference in his final report to the importance of retaining the rural nature of this narrow access to the conservation village of Southstoke. The current local plan, together with the NPPF, defines the limits that were set upon development of this land and requires it to be used to create a sustainable and viable community. The appellant has sought to overdevelop the site without any provision for community facilities. If allowed, it will become just a car-dependent housing estate. The capacity of the available facilities in Southstoke Village could not possibly cope with such a vast population increase. Bain's Planning Committee was right to reject this proposal. Sir, I ask you now to uphold the committee's carefully debated democratic decision and to dismiss this appeal.
Thank you, Mr. Hallard. Any questions, Mr. Tucker?
Same position, sir. Thank you.
Thank you. And just to double check, Mr. Hallard, the Manor Farm, is that the same as the, I think it's referred to on some plans as the business village, Sullistown Business Village? It's on the bottom right-hand corner of the land.
It is. It's immediately adjacent to the boundary of the conservation village, the
Yes.
conservation area of South Stoke.
I think I walked past that yesterday when as I was walking down into South Stoke. I went
Yeah.
past. There's a collection of buildings at that point. That's
Yes,
where you
it's
were
the
referring
old farm buildings at
I
the top
see.
of the land.
Okay, thank you. That's helpful.
Thank you.
Thank you for your time. Thank you. And then I think the final person on my list, and thank you for your patience, is Jackie Sloan. Jackie Sloan here. Thank you. When you're ready, if you could just introduce yourself and if you're happy to take any questions.
Thank you. My name's Jackie and I am a Bath mum, among other things, but for the moment I'm speaking as mum. I live with my family at Foxcote, which is a mile from Peasdown St John. We have, my husband and I, 4 children spread amongst 3 schools, St Julian's Primary School in Wellow, Prior Park School in Combe Down and Kingswood up at Lansdowne. I've been doing our school run for about 15 years, so I feel I have some experience on rush hour in these areas. The first thing is that the A367 between Dunkerton and the Odd Down Park and Ride is a no-go zone after 7:30 or 7:40 for us. More often than not, if we do have to do that route, you get stuck in a chain of crawling traffic that starts around just above Dunkerton and creeps up to the Park and Ride, bottlenecking at the roundabout. I'd say it can take about 10 plus minutes to get through there generally, and it's worse now that there's so many cars trying to get into town, including those cars from the New Sulis down. Travelling on down the Wellsway into town or travelling along North Road to Combe Down is also impossibly slow around 8 a.m. We've learnt from bitter experience that we simply cannot get our children to their schools in time if forced up these main routes. As an alternative, generally, we, like many others, try and find a way through the lanes. We either travel through Combe Hay and South Stoke up to the Cross Keys and then on to North Road, which at least cuts out the Odd Down Park and Ride bottleneck, or we go via Twinhoe, Midford and along Tucking Hill Lane and then up through to Combe Down that way, passing Combe Down Primary School and Combe Down Nursery. The lanes are obviously single track, mostly single tracks with passing places, and they are now busy. There is a lot of adept reversing required to allow cars to pass, and you have to be prepared to tuck yourself into thorny bushes, etc. And it doesn't come without risk. Only last Friday, my daughter, who is now attempting to drive herself to school, came across a tree that had fallen across Tucking Mill Lane in last week's storm. She was at the head of about 15 to 20 cars, all now stuck. Every car had to reverse out of Tucking Mill Lane, not easy on a single track. One car did the inevitable and crashed into a fixed bollard outside somebody's house, breaking it and denting his car. The police had to get involved. When these lanes pass schools like Combe Down Primary School and Combe Down Nursery, you're still on small roads, and I'm afraid cars have to weave their way past parents dropping their children, still obliged on occasion to reverse or even mount pavements to get past. Sometimes the traffic is lighter and you can steadily get through, but that is rare. More often than not, there is a burst water pipe, like the one currently blocking North Road at the top of Ralph Allen Drive above Prior Park at the moment, or there's increased numbers of cars trying to find their way into Bath from the southeast without being able to pass the currently closed A36, or there's a fallen mill on Tucking Mill Lane, or there's roadworks, or it's bin lorry day, or heavy rain pushing people into their cars. According to the Met Office, Bath has about 130 to 160 rain days every year. There's a lot of people in cars. I don't quite understand how the applicants have concluded that the traffic is not a problem in this area. I can tell you from my experience driving at rush hour, the traffic around the Odd Down Park and Ride, down the Wellsway and along North Road to Combe Down is terrible. And as a consequence of developments already at Sulis Down and Marlbury Park, it is most definitely getting worse. Can I slightly cheekily suggest that on Thursday when you meet at Sainsbury's car park, you aim for about 8 o'clock and see if you can get a flavour of it yourself. You almost certainly will.
Thank you, Ms. Lund, did you want, sorry, are you happy to answer questions if there are any?
Yes.
There may not be, but
Please
Mr.
do.
Tucker, any questions?
I didn't have a question, but I missed something when you were speaking. It's entirely my fault. You described approaching the park and ride roundabout, and it's a chain. You're within a chain of, I think, crawling traffic.
Yeah.
Was that what you said? Yes. Sorry. I just want to make sure my notes were correct. Thank you. Thank you very much indeed. But I have no questions, sir. Thank you.
Thank you. And thank you. That was very helpful to run through. In terms of the site visit, I will. I note the point about seeing it at rush hour, and I'll see what can be done about that. But thank you for your time. Thank you. Is there anybody else wishing to speak who hasn't already said that they would speak? If not, thank you for everyone's time today in terms of your comments. And as I indicated, if anybody wants to share their statement via the case officer, that would be helpful. But not, yeah, I'm not insisting on it. But if you are willing to share what you read out, that would be helpful. Thank you. That then brings us, I think, probably to our lunch break and any procedural points before we adjourn. Mr. Tucker?
Just one, sir, really relating to the Bath Preservation Trust presentation. I note from their website that in 2017 they made a request to add Sullis Manor to the national list, so to become a listed building, which was not accepted by Historic England. I don't know, sir, if it would be helpful for you to have sight of Historic England's response in that regard, mindful of what's just been said. And I don't suggest that we are wanting to put it in. I just really ask whether or not it will be helpful to you to have it.
Okay. Obviously, that's not something that's in the evidence already then? No. Okay. Certainly before Friday might be useful, but Mr. Sherman, did you want to come back on that, sir? Or?
And so I only mention it because it wasn't mentioned during the presentation.
I understand. Thank you, Mr. Sherman.
Thank you, and it's an absolutely taken point. I wasn't suggesting that non-designated heritage asset should be attributed as a Grade 2 listed building. What I was saying is that the significance of the building is attributed less because of its design, but more so, or in addition, because of the person who commissioned its original design and location.
Okay, but in terms of, would it be helpful for me to see that list description from the Historic England? Or?
I'd be very happy to share any of the detail that's on our website and the response that we received.
Okay, I think I'm certainly happy to see the Historic England report on the assessment. Sorry, not the description, the assessments for listing. Obviously, that would be helpful. So if that could be shared, and Mr. Chairman, if you're there, obviously on Friday for the roundtable, we can pick that up further. Okay, thank you.
Thank you, sir, and thanks.
Anything else, Mr. Tucker, before we adjourn?
No, sir, thank you. Nothing from us.
Thank you. Anything from the Council, Mr. Morgan, before we adjourn? And Mr. Neil, anything from your side?
No, sir.
Or anybody else?
So I don't know if there's a question about the layout of the room, given what we're going to do after lunch, whether or not you want to alter that.
The next session after lunch will be a question and answer session with the appellant's witnesses on ecology, lighting and flood risk. So it might be helpful if each witness, or each expert rather, not witnesses strictly speaking, is at the table to do that. Are they all here this afternoon, Mr. Tucker?
Ready and eager, sir. My suggestion was perhaps to put them on this table, but I'm sure quite happy to have them there.
Yeah, I mean, yeah, whichever works more. Yeah, we've had people up here this morning. It's been okay. So
yes,
yeah,
sir.
We'll maybe continue with that. Perhaps that might be easiest.
Yes, sir.
Thank you. And then after that, we hopefully will hear the start of Mr. Russell's evidence in chief, Mr. Neil. I think that's the plan, and hopefully that's
yes,
doable. Yeah. Thank you. Okay, so time-wise, we're a little bit over where we should be. So let's shall we reconvene at 2:15? So just under an hour's lunch break. Thank you. Okay, so thank you, everyone. We'll reconvene and adjourn until 2:15. Thank you.
Thank you, sir. And sir, it's an apology. So despite having a list of thousands on our appearances list, I managed to miss off, or we managed to miss off, Francesca Hunt, who's dealing with flood risk, drainage, etc. So sir, what I'll do is formally introduce each of the 4 people you see to the right of Miss Jackson, my junior, on the right, the table in turn. And so we'll make sure tomorrow morning we add a replacement list of appearances which has Miss Hunt's name and details on, if I may, if that's acceptable.
That's fine. Thank you for that point.
So apologies to you and to her for doing that, sir.
Okay, no worries. Anything from the council, Mr. Morgan? Or Mr. Neil, any procedural points from the Rule 6?
No, sir.
Okay, thank you. So we'll take each topic in turn. I was proposing we do ecology first, followed by lighting, and then flood risk and drainage, if that sounds reasonable. And obviously, hopefully everyone has access to a microphone and has it close to them so they can be heard as we go along. But if we start first of all with ecology, I don't know if you want to just introduce your 2, I think it's 2 experts here.
Yes, but by all means, sir. So I have 2 people speaking on ecology. On the extreme right of the table is Dr. Laurent Duverger, and 2 persons down to his left is Ms. Jenkins. Dr. Duverger has a PhD, a BSc with honours as a chartered environmentalist, member of the Chartered Institute of Ecology and Environmental Management, etc., also with Kestrel Wildlife Consultants, and he has his colleague with him who has a BSc honours degree, an MSc, a chartered ecologist, and will be able to assist him with regard to any answers to questions you may have, sir.
Thank you. And obviously, if, in addition to any questions that I may have, if there are any questions from interested parties, please do indicate. And obviously, if you need a microphone, we can make sure one is provided. But if I could maybe just kick things off with the sort of habitats regulation assessment, so perhaps start at that point. So I've been obviously looking at the various information that's been provided, including the information to inform a habitats regulations assessment, which I think is core document U1 and other supporting. And as I understand it, Dr. Duverger and Ms. Jenkins, the consideration is that the proposal would have a likely significant effect on the special area of conservation due to impacts on the bat population. I don't think that's a disputed point, and therefore appropriate assessments is necessary. Is that a kind of very brief summary?
Yes, that's correct.
And obviously the habitat regulation assessment document has, the document U1 has various information in there. And obviously as part of appropriate assessment, there's obviously a need to consider all the mitigation measures. And I just wondered, I think they are set out, I think in U3, is that the source of where, I think there's a table in...
Yes,
has a green.
You've got a detailed table, I think it's labelled Table 10 in U3.
It may be, yes, that may be the...
sets out all the mitigation measures, and they're also reiterated in the proof of evidence in Section 8.
Yeah. So just to understand, so maybe just briefly, the mitigation measures for the bat population includes lighting and replacement bat roosting areas, bat barns. Anything else you want to draw my attention to in terms of what else is being proposed?
Yes, so if I just run through briefly, the 2 key features of the site are the southern tree belt, because that's used by greater and lesser horseshoe bats that are commuting to and from their foraging grounds. And most importantly, within Sulis Manor ground, there are some very dilapidated outbuildings, but they are used by roosting horseshoe bats. The horseshoes are associated with the nearby SAC. So we've put a whole range of mitigation measures in place. There are 2 new bat barns. Well, they've been up now 2, coming 3 years. One on the western side of the plateau, one on the eastern side of the plateau. The western one is already in use by lesser horseshoes. The eastern has been occupied by a wasp's nest, which has now been removed, and hopefully the horseshoes will find it fairly soon. So those are direct mitigation for the loss of the outbuildings in Sulis Manor.
And then in terms of, I mean, we may obviously cover lighting later on, but lighting is obviously an important, it appears to me as an important part of the mitigation.
Yeah. So horseshoe bats don't like light. They're deterred by it. So we've set some very tight criteria, particularly along the southern tree belt. So there will be no light spill onto the southern tree belt. It'll be very limited, and I'd hand over to Bonnie to give you the exact measurements. So it basically will maintain a very dark corridor along the southern boundary of the site, which all the evidence suggests will continue to be used by bats. And just for comparison, that has certainly happened on the Phase 1 development because we're getting good bat numbers continuing to fly through that tree belt.
Is that based on, is that updated survey, I think, is it included in your proof? There's an updated survey work on bats from last year?
Yes, so the work we presented from 2024 includes surveys along the southern edge of Phase 1 and on both sides of the western bat barn in Derrymans, both along the southern plantation of Derrymans and along the eastern plantation north of the bat barn.
Thank you, that's helpful. Obviously, we will have conversations looking at the details of conditions and obligations to secure this, but are all the mitigation measures securable, if that's the right word, in terms of, they can be set out in conditions and obligations?
Yes, they are. I think one thing Lynn hasn't mentioned is that there is also obviously proposal in this planning application to add an additional 4 night roosts for horseshoe bats, which would, at the moment, they're planned to go along the eastern edge of Sulis Manor in Well Ground, in the field known as Well Ground. Now, the exact location and position, etc., isn't determined yet, but that's the proposal.
Which field was that again? Sorry.
Beg your pardon?
Which field? Sorry.
Which field? Oh, the fields immediately east of Sulis Manor. Is that Well Ground? I think it is.
Within the Phase 3 development? Yeah, within that area. Okay. Thank you. And then there's also presumably necessity for a license from Natural England if there's any bat disturbance. Any reason to or any reason why that it wouldn't be granted, or any?
Well, there's no reason why it should not be granted, given that we've put the mitigation in ahead of time, and we're obviously monitoring the current eastern and western bat barns. Because sometimes it can take a number of years before these barns are used by bats. We're very lucky that the western bat barn was used, I think it was the late summer of 2023, and then right through last year. And then obviously eastern bat barn, we've had problems with wasps, but we're addressing that. So hopefully by the time we come to apply for a license, we will have shown that there are alternative routes for them to go to when the outbuildings at Sulis Manor need to be taken down effectively.
Okay. Thank you. Are there any questions from the audience about bats from anyone? I think that's Dr. Garnett at the back. Yes. Do you want to ask? It's a question. Yes, you could come, or you can, or sit by a microphone there, whichever is easiest. So questions on bats for the two experts, please.
Okay, thanks. I've been looking at the 2024 survey and trying to do some comparisons with the 2021 survey. You comment in the 2024 survey that bats in general and horseshoes in particular made very little use of the central link along the northern tree belt to get across the site, the northern tree belt. And If you look at the walk transect there, I think I'm right in saying no horseshoe bats were recorded there
No.
in 2024.
You're correct, yeah.
That's
there
right.
weren't any observations of horseshoes there.
If you look at the 2021 survey,
Yeah.
they were using the northern tree belt.
Yes, there were
4
some
greater
observations.
horseshoes and 9 lesser horseshoes.
Sorry,
were
I
recorded.
missed the answer.
Sorry. Yes, there were some, in 2021, there were some observations of horseshoe bats along
Yeah.
the...
So in terms of the 2021 survey, there were 4 greater horseshoes and 9 lesser horseshoe bats recorded.
Okay.
I appreciate that you've made a lot of emphasis that the northern tree belt's a lot less significant than the southern tree belt. I'd point out that over the same area in the walk transects, 4 greater horseshoe bats were also recorded. More lesser horseshoes, but actually the same number of greater horseshoe bats. So between 2021 and 2024, the horseshoe bats have disappeared from the northern tree belt. Or they're no longer recorded.
On a walk transect, but not on the static loggers.
Yeah.
If you look at the static logger information, there is still a bit of horseshoe activity along the central tree belt.
But there wasn't a static logger there in 2021, was there?
I'd have to go back and double check.
I have checked. There
right.
wasn't a static logger there in 2021. I just sort of... It seems to me fairly clear that the reason the horseshoe bats numbers have gone, I mean, Natural England described this particular tree belt as being a commuter route back in their 2020, I think it was 2022, it might have been 2021, a commuting route for bats. In October 2022, the eastern end of that tree belt was completely removed, effectively cutting off that as a potential corridor for bats to move along. I just want to make the point that actually, as a result of that activity, bats have been lost from the northern tree belt.
Dr. Cudd, is that a question rather than a statement? Is that a question?
Do you think it's a reasonable assumption?
It's a possibility, but it's not necessarily completely correct in that you can get bats flying along the eastern side of what is phase 4.
Yep.
And then rejoining the northern tree belt at the top corner of what is Little Broad Close.
It's just you haven't actually recorded any?
Not during walk transects.
No. And are there any static loggers other than the one right over on the western side of the northern tree belt?
There is one at the top end of a junction where the stone wall goes between Well Ground and Little Broad Close, reaches the northern tree belt. There's a static logger there. There's a static logger at the northwestern corner of Well Ground, so where it's next to Sulis Meadow.
I think that's static logger 7, is it?
Number 7.
Yes.
Yeah, and then...
And that's shown quite a considerable drop in horseshoe bat numbers between 2021 and 2024.
Yeah, that has got less activity.
Yes.
But on, the thing to my mind, the thing to bear in mind is that the outbuildings at Sulis Manor are also they're not breaking down, but they're getting into a state of disrepair. So it could be that there is less activity at Sulis Manor outbuildings anyway, which means that bats are less likely to come up to that part of the plateau.
The other question is, as I say, I've been trying to do a comparison, and of the static loggers, only 3 were in the same position over that period, I think. I've got the figure here.
Quite possibly, but then the land that we were surveying changed because the phase 1 was already done, so we've got different positions of loggers, yeah.
Yeah. One of the things you highlight is the increase in bats in Derriman's Field.
Yeah.
Which you say is a significant increase from 2021. I'm right in saying in 2021 there was only 1 logger in Derriman's Field, whereas in 2024 that was logger 1, whereas in 2024 there were 2 loggers, logger 23 and 25.
Yes, the 25 was the logger that was in position for both, yes.
Yeah. No, it wasn't. There was 1 was in the corner, and then you had 2 in...
So you had 1, 23 and 25?
23 was halfway up the side of Derriman's Field on the east side, and 25 was on the southern tree belt.
Southern tree belt, and then there was a logger
Yeah.
up to position 1 as well,
How
which
do
is
you
next to the back barn.
I mean, I certainly accept logger 25 had got quite a high number of bat recordings, but the other logger, logger 23, had roughly the same number as logger 1. So it seems quite a jump to presume that the numbers have increased when one of the loggers is pretty much the same, and you only had one logger in the 2021 survey.
Well, the numbers, when you look at the total number of passes, they certainly have increased. So I don't think there's any doubt about that in Derrymans, when you look at the total number between the loggers that monitor Derrymans between the years.
But of course they've increased. There's 2 loggers as opposed to 1. Sorry, this isn't really a question, but I'm trying to, maybe I'm getting too technical here, but it just seems to me, I mean, I don't know the answer, it just feels to me quite a leap of a conclusion that things are significantly better in Derrymans when you're not doing a like-for-like comparison between the 2 years.
Well, the reason you're not getting exactly like-for-like comparison is that as part of a field and part of a site has been developed, the layout of land that needed to be monitored has changed.
Yeah.
So, we're not, we've been monitoring the site since 2013, probably, something like that. And logger positions have changed to accommodate what we were trying to log, what we were trying to find out.
Yeah.
So
Okay.
there will be some discrepancies.
Yeah.
It's not exactly the same as the original surveys.
But on the Derrymans side, so the logger data, I think, but the walk transects for Derrymans in 2021, and again, this comparison, you saw 5 lesser horseshoes and 1 greater horseshoe. In 2024, you saw no lesser horseshoes and 1 greater horseshoe. So actually, if you went on the walk transect data, the numbers have dropped.
You would have said it's worse, yes.
Yes.
And the issue that what people don't understand with walk transect is it gives you a qualitative data assessment, but obviously you're surveying on different sites, different nights, different weather conditions, different prey conditions, so the bat activity is going to be different.
Yes, I accept that.
So which is why you try and do more quantitative assessments with the static loggers.
Yeah. And can I just confirm, finally, sorry, and I'll leave you in peace, the bat barns, you say there's nothing been in the eastern bat barn. The western bat barn, you say lesser horseshoes are using it. Is there actually evidence for more than 1 lesser horseshoe using it?
Not at the moment,
Okay,
no.
thank you.
So every time we've been in there, there's
Yeah.
been 1 greater horseshoe.
So 1 lesser horseshoe
Which is
using that
identical
barn.
to, more or less identical to the outbuildings at Sulis Meadow.
Yeah. Okay.
Not at Sulis Meadow.
Thank you.
Thank you, Dr. Gunn. I mean, you're welcome to stay where you are if you like. Or I don't know if anybody else has any questions on bats from anyone. Because I was going to cover some other ecology points.
okay.
So if you had questions on those,
Well,
you can...
just for the 2 other areas I'd like to ask questions about are skylarks and biodiversity net gain calculations. Thank you.
Other questions on bats from anyone at this stage? Yes, Councillor Jackson.
Where horseshoe bats, particularly greater horseshoe bats, are concerned, because the fields were originally arable fields, and that is a habitat type which is very much avoided by greater horseshoe bats in terms of foraging. Replacing it with gardens, etc., is not a great loss. Is on a change for change basis from a greater horseshoe point of view. They don't use arable habitats for foraging. They are present in all those areas. I don't know exactly which directions they go. We haven't radio tracked them, so I couldn't tell you. But we presume that the ones coming on site are from the Odd Down stone mines.
And if we turn to the skylarks, could you just explain where they are exactly on the site, or where they have been? The nesting sites at the moment are within the fields where phase 3 and phase 4 would go?
Yeah, so currently with phase 3 and phase 4, we have had, in the early part of the season, we had one territory in Greater Broadclose, so roughly between the northern tree belt and the Wansdyke to start off with. Then we also had at the same time 2 territories which were trying to be established in well ground, so that's the field immediately east of Sulis Manor. As the season progressed, the territories that remained ended up being 2 in Great Broadclose only, with odd individual observations of birds in 30 acres and Little Broadclose and well ground. But they were just single observations, so we couldn't quantify whether they were territories or not. And the only skylark territory that lasted the service season was on the eastern side of Great Broadclose. So outside the red line boundary, but in the field immediately north of that.
And then the compensation habitat, where will that be provided? Where's that going?
So at the moment we're looking at 2 fields in the valley to the south, Great and Long Tynings.
Where was that?
Sorry?
Sorry, where was the location again?
Sorry, it's immediately southwest of the site. Let me just find.
Did you say Tynings?
Great and Long Tynings. Great Tynings and Long Tynings.
Is that off-site completely?
Yes.
Okay. I have seen in the Section 106 agreement there's some reference to Tynings land, but I haven't yet seen a map. I assume there will be one.
Oh, okay. It should have been in our presentation.
Unless I've missed it on something. But yeah, if you could point me towards it, that would be helpful.
Okay, just a second. Just a second.
Whilst that's been done, sir, yes, it will be a map on the 106 when it's obviously
the land ownership,
which will identify that. So yeah.
Thank you.
Where has it gone? I thought it was it. Okay, Lynn will look for the map and we'll give you.
Thank you. Yeah, it's the Tynings land. That's the compensatory habitat.
Yes, it is.
Okay. And again, any licenses required for this from Natural England to disturb these nesting sites?
Well, no, sorry. Go.
No, there's no licensing required. Any vegetation clearance needs to happen outside the nesting season.
Okay.
And there is no protected species license covering skylarks.
In fact, are there license requirements for any other species other than the bats? On this site?
No.
Okay. Okay, Dr. Garnett, you have some questions on skylarks?
If I may.
Yes, go ahead.
So, in terms of I'm right in thinking that the fields that are being offered in mitigation, it's either great tining or long tining.
No, it's both.
It's both, is it? Because certainly earlier it was going to be one or the other.
As far as I know, it's both fields. And
Right.
that's been confirmed today, I think. Yes.
Yes.
Yes, it is both. Okay,
Yeah.
thank you. Currently, I'm not aware of any records of skylarks breeding there. Is that correct?
Well, we had not breeding,
Not
but
breeding.
we had,
You had
displaying skylarks.
displaying and singing.
We had displaying skylarks in 2024. Yes.
Those fields are, I think I'm right in saying, surrounded by trees, aren't they?
I would say thick hedgerows. Yeah, they've got hedgerows on some sides. But
And there's
not
been
surrounded by
additional tree parts.
Sorry, Dr. Garnett, I think if you could let
Sorry.
let the consultant finish what they're saying before your next
I'm very
question.
sorry, sir. I'm
Just
not-
otherwise
I'm
we
not-
can't
I'm not
always
used to
hear
this
what he said.
environment.
I appreciate that you've
Okay,
got
thank you.
questions to ask.
So
Thank you.
the
Dr.
tining fields are 3 large fields, 2 of which are being proposed for mitigation. And on the southern side, on the southwest side, they've got They adjoin a woodland, and there is one thick tree-lined hedge that comes into the site on the eastern side.
Yeah.
Yeah.
But the ground conditions are reasonable for skylark nesting. Or
They
certainly
are
this last
reasonable
year.
conditions. The management at the moment is not favourable to skylarks establishing there.
Is the plan to make them arable fields? Is that the plan?
I don't know what the plan, what the agricultural management plan is, but the measures we would take would include measures to make it favourable for skylarks for nesting through skylark plots or different managements. For example, last year we had grass crops that was then, once cut, was grazed heavily by young stock, so that wouldn't be suitable for the establishment of ground nesting birds.
I mean, my understanding of skylark plots is they are designed for use in arable fields. They don't tend to get used in...
Sorry?
My understanding of skylark plots is they get used in arable fields and not in pasture.
Yeah, they can be used in arable fields, or fields can be left to go fallow, which then can hold quite a good number of skylarks, as we've seen before.
You quote the Donald Morris study, the SAFI study, on sustainable arable farming for improved environment. That was about, the examples that they show in that study are all about increasing the number of skylarks where skylarks are already breeding by increasing the breeding success, particularly allowing a second brood because of the effect of the arable growing up.
Indeed, but it's the methodology we were looking at was whether there's a capability of incorporating plots within arable treatments to actually encourage skylarks to nest, which obviously it can be done through their study. Being a scientific study, I'm sure they had whatever protocol they decided to start testing, but it's not a prescription for all the other land that we may need to try and use this system.
But is there evidence of skylark fields, of plots in non-arable fields, resulting in an increase in the number of skylarks?
The only evidence we have actually comes from the plateau. In 2022, before phase one was actually starting to be developed, the two arable fields west of Sulis Manor were left to go fallow, and they were riddled with skylarks in no time at all.
Okay.
So effectively, they easily took advantage because they were already there and that the ground conditions were right. They easily took advantage of that. Yeah. And then obviously those were lost as phase one developed. So we know that provided the ground conditions are right for skylarks, they can exploit them quite easily.
But they're not currently. I mean, I'm just slightly surprised because I do walk past those fields. They seem quite reasonable in terms of ground conditions, but they don't have breeding skylarks.
They're not currently, but I don't think the current agricultural management lends itself to skylarks using them. Yeah. So I'm sure that should planning permission be granted, we would look at a system that would encourage the skylarks.
Can I just have one last question on skylarks?
By all means, yeah.
Thank you. The area of great tinings and long tinings is relatively small compared with the size of the plateau, is it not?
Well, the plateau as a whole, yes, but if you look at great and long tinings together, make 11 point something acres.
I think it's 11.1 hectares.
Yeah, hectares, that's it, yeah, which is not too dissimilar to the two fields currently being for Well Close and Little Broad Close being put,
But you accept that because of and I mean, I think it's in various earlier reports, you're going to lose skylarks from the entire plateau because nowhere on the plateau is going to be more than 100 metres from a house.
Well, I don't want to accept that in the sense that the skylarks were using the two fields west of Sulis Manor, even though they were very close to Sulis Meadow, the Sulis Meadow age, when those ground conditions were correct. So I think, provided the ground conditions are correct, we could still have skylarks on the plateau in Great Broad Close and 30 acres particularly, especially if we reduce the amount of interference and disturbance they get from dog walkers and etc., which currently use the field.
But that is a change to what was said in, I think, one of the earlier reports from...
Well, we take the view that we might lose them, but we can also try and... So that's the reason for mitigation, but there's no reason why we can't... If 30 acres and Great Broad Close remain in some form of land management, that we can't manage it and try and retain skylarks there as well.
Okay, thank you.
Thank you. The question of biodiversity net gain, I think the proposal is putting forward a biodiversity net gain of just, is it 10 point something % for habitats and hedgerows? That's the figure being put forward.
It's in that order, but bearing in mind that you can't do a BNG calculation on an outline application until you've got the absolute detail.
And that's being secured through, in terms of hedgerows, presumably is that additional hedgerow planting to secure that hedgerow increase?
Yes.
And in terms of the habitats, what's contributing to the extra 10%, or the 10% gain rather?
A large proportion of that will come from restoring Derryman's Field to other neutral grassland.
So yes, the Derryman site is the...
Yes.
Okay, thank you. Dr. Garnett, you said you had some questions on BNG. Would you like to pose them?
Thank you for your indulgence. So I had just some questions in relation to the way the BNG was calculated. I mean, my understanding is, obviously you don't calc species, that would be impossible really. It's you look at the habitat area, the habitat type, the habitat quality, and whether it's of strategic significance. And I've looked at the spreadsheets, and you put all the numbers in, and you hit a button, and you get a result. I mean,
broadly, that's how it works.
I appreciate
yes.
This has been lots of testing and lots of stuff within. I'm just interested that skylarks are mentioned in the local plan under Placemaking Principle 5 as safeguard skylark interest through adequate mitigation or off-site compensation. And as we've discussed already, the arable fields are the fields where the skylarks breed. So I looked at the spreadsheet and was surprised to see that where it said, is this of any strategic significance? Does it appear in a strategy? That's my understanding of reading the guidance notes. There are 3 options you can put there. The area is not in a local strategy or no local strategy. The location is ecologically desirable but not in local strategy, or it's formally identified in the local strategy. I think it's fair to say skylarks are formally identified in the local strategy.
But not in the conservation side of local strategy, so they're not in SNCI and they are not part of the new LNRS that will come into force.
But that isn't what the guidance said, is it? I mean, my reading to the guidance, it says isn't a local plan or local strategy.
Okay, I'll accept that it would give it a slightly higher rating.
I mean, it actually, because of the area, I mean, you appreciate most of the area is arable land. If you set it to what I would feel is the correct value, we can debate that, it would go from your 10.22% for the habitats down to 2.79%, so it would no longer meet the compliance with the policy.
I think the important point here is that even if we really calculated the PNG calculation, which we will have to do when we know the final layout, there is still scope between Derryman's Field and 30 acres to make up any shortfall on the habitat units.
Okay.
Can I just intervene? So you will be aware, Dr. Gully might not be aware, that there is a condition which requires the minimum that's been put forward. So even if at the time that the metric was put in, at the time that the details of the scheme came forward, and that metric changed in terms of what's anticipated at this stage, we would be obliged to meet the minimum that we put before the inquiry today. So I'm also slightly hesitant about having figures put to my my expert, which she won't have seen or had notice of. So I invite you to just have a little bit of caution in relation to what's just been put.
Okay.
I mean, can I just make the point? All these things that I've said just now have been in objections that I've submitted on behalf of SOBA. And if you want to look at my critique of the biodiversity net gain calculation. I'd be very happy to discuss it with you outside this meeting. It's core document AA66.
Yes, I'm familiar with it.
Okay, thank you. So you are, yeah, right. So I'm not putting new figures to you.
Okay. Anything else you want to add in response on the, or did you want to move on to another question, Dr. Garnett?
No, I suppose the other more general relation to the I mean, as I say, if you've read that particular thing, you'll realise. I mean, I think the limitations, you know, it's very clear. The biodiversity net gain calculations need to be viewed, and I'm sure you do, with a common sense view of saying, does this look sensible? Now, one of the area limitations to biodiversity net gain is in terms of the biodiversity loss, it only looks at the footprint of the development. That's correct, isn't it?
Yes, within red line boundary.
Yeah. So obviously the biodiversity impact of this particular thing could well spread beyond. We've talked about the impact of the new development on the neighbouring fields. We've talked about the impact of the light on the bats. Now, I know they don't look at individual species, but I would just put a plea when you're looking at biodiversity net gain. Can we look at it in the whole, in terms of not just focus on the footprint of the development?
In short, no, because the BNG metric is very tightly set within red line boundary. And I think it's important that we don't confuse the species issues with the habitat issues, because the protected species that are on the site, be they skylarks or in particular bats, and indeed the reptiles, they are dealt with through a different mechanism and through a different legal mechanism, and that does not overlap in any way with the biodiversity net gain calculation. And they have been accounted for fully in the mitigation measures that have been put forward.
I would just point out that the user guide, and it's just reiterating a point I've made already, says the metric and its output should therefore be interpreted alongside ecological expertise and common sense as an element of the evidence that informs plans and decisions. The metric is not a total solution to biodiversity decisions. I accept what you say about rare species and there being other things around that, but I would have thought it was common sense that if species are going to be lost beyond the footprint, that ought to be considered in terms of the gain or loss of biodiversity.
The main species that will be lost beyond the footprint are skylarks, and we have already accounted for all the breeding pairs across Sulis Down Plateau, and that can be accommodated in the 11.1 hectares allocated down in the valley. So there's no shortfall there on skylarks.
Okay. What is, we don't, obviously clearly because it hasn't been done yet, and unfortunately, there has been time to do it, but it hasn't been done. What is the comeback that Baines would have with the developer if 5 years from now there aren't skylarks in Great Tynings, or there are insufficient according to the agreement in the S106 agreement? It's just a more general question about what the comeback from if this is not successful.
The site will be monitored and will determine success or otherwise then.
And I'm sure, but what happens if it fails?
Probably an alteration in the management regime of those fields. That would be the most sensible solution.
Okay. Thank you. I'm done.
Thank you, Dr. Garnett. Any other questions on ecology from anyone? Councillor Gourley, sorry. Do you want a microphone, or can everyone hear the councillor? Okay, sorry to... Well, you can come use this one, yeah.
I hope this is the right moment to ask. Derrimans has been mentioned several times. I'm just wondering how many uses one field can be put to, because currently it holds a very large soakaway from phase one. It holds 2 sections of trees, quite substantial tree belts, which have been replaced for the trees that I assume have been lost. It is apparently going to be replacement calcareous grassland albeit is already covered in grassland. So maybe there's a difference in types of grassland, but there's certainly a lot of grass there. And it's also going to be hopefully holding the allotments for phase 1 and actually looking at the site with the fences that have been put around it. There could potentially be other allotments there. It seems to be quite a large area has been fenced off. If this is meant to be the main mitigation zone for phase 1 and potentially phases 3 and 4, as I say, I'm just wondering how many uses one field can be put to.
Thank you. Any response?
It's a perfectly valid point, but we have done some careful calculations. So you're quite right to say there is a pending planning application for the allotments, which has got its own area allocated through the BNG calculation. The mitigation for phase 1 are fenced off plantations, and the remaining area, which I don't know the figure off the top of my head, is going to be split between other neutral grassland and calcareous grassland. What the construction of the soakaway has actually done is create some very good conditions for the recreation of calcareous grassland, because it's lowered the nutrient levels and it's turned the subsoil up. So with careful reseeding, we can create true calcareous grassland. The remainder of the field will require some more selective treatment, because you're quite right that there is quite an interesting flora there currently, although it doesn't fall into any classic grassland type, but it could definitely be significantly improved by the appropriate management. But the figures are all worked out very precisely and mapped as well.
Subsidiary point, this remains in Greenbelt, and if there are allotments allowed there, and for them to be of any use, it will need to have deer fencing around it, as we know from the South Stoke allotments.
That's okay, fine, thank you. Any response on the need for fencing?
The current planning proposal does have fencing around it. I don't know how high that fencing is. But equally, it's not under consideration here.
Okay, thank you, Councillor. Any other questions for the ecology consultants? I just had a couple of very, sort of residual points. I'm not sure if I have a copy of Natural England's supplementary advice on the SAC. It's referred to, I think, at the end of the HRA information document, the core document U1. But I'm not sure. I may have seen the citation and conservation objectives, but if it's in the evidence already, or if a copy could be provided, that would be helpful.
We'll provide a copy.
Thank you. And then the other one was I've seen obviously references to the site of nature conservation importance, which I believe is a local designation. Is that correct?
That's right, because Derriman's Field is part of the South Stoke and Fuller's Earth complex.
And that, I don't think I've seen a map of that designated area. Is there anything in the evidence, or again, is that something that can be provided?
We have a map of the site. What we don't have is the citation, and that really falls to Bath and North East Somerset, because I have requested it of them. But I'm not sure if it's readily accessible.
Okay. I mean, primarily, is it designated for the geology, or for what's the reason for its designation?
Habitat, other neutral grassland, deciduous woodland are the two primary ones, and part of the escarpment woodland is ancient woodland. It was designated by the Bristol Records Centre some 25 years ago.
Right.
And it's basically a county level importance site.
Okay. And is it all outside of the red line boundary, or apart from Derriman's?
Yes, all outside the red line boundary.
In fact, Derriman's may be in the blue line. I may be misquoting Derriman's, but no, it is in the red line boundary, isn't it? And so it covers the area along to the south of the site, essentially.
Yes, when you do the site visit, you'll probably walk along a track on the southern edge of the site, That track is fenced on the southern boundary, and as you basically fall off over the fence, you go straight into the designated site.
Okay.
And it's all steep woodland on that particular stretch.
Okay. So parts of the bat foraging zone as well, presumably. Yeah. Okay. Would it be possible to have a copy of the map just so I can visualise it in a spatial sense? That would be helpful to have that provided. Thank you. Otherwise, no other questions, so thank you both for your time this afternoon. We're happy to move straight on to the next consultant on lighting.
Yes, by all means, sir. I mean, the other, so just in terms of loose ends, just that I've got the loose ends. So it's the Natural England advice, supplementary advice on the SAC, the map of the local designation, but you don't need to see the designation citation itself.
Unless that's considered necessary, I'm happy just to see a map.
Thank you, sir. And I'm minded to suggest that we should get the Tynings Fields map to you sooner than later, if that's acceptable.
Yes, because I think it would be helpful just again to understand where that is and how it relates to the development site.
Yes, sir. And it might be sensible to go and have a look, given the points being made
that,
about the surrounding vegetation. Yes, sir.
Yeah. Okay.
Thank you, sir.
Thank you. So then, yes, do you want to introduce your lighting consultant?
Thank you, sir. She's already had a brief mention with her first name, but so at the bottom of the list of appearances, the lighting consultant is Bonnie B, who may wish to pick up on the point that's just been made about there's the darker zone at the south end of the site. She has a Bachelor of Arts degree in Design, first-class Bachelor of Engineering, Building Service Engineering, postgraduate degree and Master of Science in Light and Lighting with distinction. She's a Chartered Electrical Engineer and Lighting Specialist, a member of the Chartered Institute of Building Services and Engineering, the Society of Light and Lighting, and the Institute of Lighting Professionals, and is a Director of Lighting B Limited, and no doubt has enormous subs in the light of that particular list. She sits immediately to the
next
left
to Ms. Jenkins.
Yes.
Yeah, thank you. Hello, Ms. B. And helpful just as an overview, and people may have questions on lighting as well, just in sort of very sort of simple terms and in summary, how the lighting strategy would work across the site in terms of both public spaces and private dwellings and so on. If you could just maybe give a précis of that would be helpful. Thank you.
Sure. So
I think you might need to move that mic a little bit nearer that.
The lighting strategy, so it's just to explain the context, we did 2 assessments or reports. One is the typical lighting assessment and strategy that would address external lighting, and we did a supplementary report to address any artificial light spill that may affect ecological receptors. In terms of the strategy throughout the site, in terms of street lighting, we intend to have the least amount of street lighting we can. We've discussed that with the council so that the normal requirements for street lighting will be slightly reduced, taking into account of the AONB location. Private lighting will be minimised, and there'll be lighting to each dwelling, front and rear entrances, which will be downward directional in accordance with best practice for an E1 zone. And other private lighting will be limited throughout the site.
Other private lighting being for beyond the dwelling?
Only it will be to private drives which may have low-level bollards, but it's intended that it will be limited.
I think there is obviously one of the parameter plans sets out the lighting strategy, the sort of framework of that.
Yes, so that sets out the limits of the levels of illuminance onto the tree belt and the buffers that we've set.
So the tree belt has it, so there'll be a buffer to the tree belt as well as the tree belt?
The tree belt, the levels of illuminance that are set at the tree belt, which is specifically for the ecological receptors, is 0.2 lux horizontally and 0.4 lux vertically.
And what does that mean in terms of how would that appear on the ground, as it were, in terms of those lux levels?
It's what is considered complete darkness within the ILP BCT guidance. Moonlight is about 0.35 lux at full moon, so it is pretty much completely dark. The reason those limits were set in the latest guidance was a realistic limit that can be measured in lighting software. It's likely 0 lux would be actually measured on site.
And is there any other areas in the development where there would be lighting restrictions? I'm just thinking obviously the northern tree belt we've heard about already, and some of the footpaths. Is there?
Yep, so there's also going to be a limit set along the western boundary to Sulis Manor, and also there's a 1 lux limit set to the northern and eastern boundaries.
To be clear, is that the dotted blue line shown
Yes,
on the?
it is.
Okay, or the hat, yeah. Okay. And just in terms of private dwellings, how do you control people in the future replacing lights on their properties once obviously they've moved in? They, in theory, could decide they want very bright security lighting on their front garden or driveway. How would that be controlled, and should it be?
A detailed lighting strategy would be provided showing the lighting that's been allowed, and this would be part of the lighting condition. So certain elevations would have no lighting, and no additional lighting would be allowed, which is within the condition. So this could then be enforced.
Essentially, if someone did put up very bright lights, yes, that they could be asked to take them down.
Will be, yeah.
Okay. And so, obviously, in terms of the national landscape, you made reference to that. How much have you taken into account any policies for the national landscape in terms of dark skies and so on?
So I've got some notes on this, if you don't mind me going through those comments. So with relation to the receptor quoted as extensive dark sky areas, in my opinion and based on current guidance, there's no distinction or difference in the resultant impacts in terms of dark sky impacts or impacts onto an E1 environmental zone when considering the number of dwellings. Although
so just to pause there, so that's comparing the existing situation with the proposed?
No, so within the evidence of the landscape evidence, there's a difference between the number of dwellings. So medium magnitude has been applied if it was 290 dwellings, resulting in a significant impact. But if it was low magnitude for 150 dwellings, this results in no significant impact.
Just so 290 dwellings as proposed here would have a significant impact. Was that?
This is the evidence from Anne Prescott. So it differentiates between the number of dwellings, and depending on the number of dwellings, says either the impact will be significant or not significant.
Right. And so your view is there a difference between 290 and 150?
Yeah, there is a difference with the guidance that's currently available to distinguish between the number of dwellings having an impact on E1 environmental zones, because the parameters set out for E1 environmental zones refer to limiting the effects of sky glow, and those limits are put in place by limiting the upward light output of luminaires that are installed, and also limiting luminous intensity, which is similar to glare.
And so essentially the fewer dwellings you have, the lower the impact.
The impact is the same because those parameters are met for an E1 zone.
So whether it's 150 or 290, you're saying it's the same?
It's the same, yeah.
Okay, thank you. Anything else you want to add? Sorry, I did interrupt.
That's okay.
So I appreciate you may be familiar with what an E1 zone is, but I'm mindful that others in the room may not be familiar with what an E1 zone is. I don't know if it might be useful for Ms. B to explain that. I'm just
by all means, yeah.
So the CIE guidance and other lighting guidance to do with obtrusive light and light pollution designate areas from an E0 to an E4 environmental zone. E1 is dark sky protected. E1 tends to be AONB landscapes and dark landscapes, and then that goes up to an E2 for rural areas, E3 suburban, and E4 urban.
So, yes, so E1 is what's been assessed here in terms of the dark sky for the AONB.
Yes.
Yeah, okay. Thank you. Anything else you wanted to say on that?
I've got some notes related to that, if I can continue to go through those.
Go on then. I may stop you again if there's a point I need to clarify.
Sure.
Go on.
So when considering sky brightness, I think it should be recognised that the site and areas of AONB to the south and east cannot really be classed as intrinsically dark or extensively dark. Although the site is assumed to be classed as an E1 environmental zone, mainly due to its AONB designation rather than the sky brightness within the area, its overall nature or the baseline conditions, which are actually representative of an area within an E2 zone rather than an E1. Sulis Manor Phase 2 to the west, Sulis Down Business Park to the south, and South Stoke to the east are representative of rural locations within Environmental Zone E2 with low district brightness, although they are also located within the AONB boundary. The E1 zone AONB area has been afforded no protection by its location or the surrounding zone designations to protect it and keep it dark. It is expected and it's typical that environmental zonations grade down, moving between zones incrementally with a considerable distance between the zones. These are not intended to be designations on a local or small scale, but on a larger scale due to the nature of light pollution. This is highlighted by the CIE guidelines for minimizing sky glow. The guidance suggests that there should be a 10-kilometre distance between the borderline of an E3 zone to an E1 zone, typically with an E2 zone between, although the application site immediately butts an E3 suburban environmental zone to the north. The light pollution mapping, Appendix C, Cotswolds AONB night lights, which has been referred to in Anne Prescott's evidence, shows that the site is currently not intrinsically dark, with only the fourth darkest colour band shown. This is more clearly shown by the light pollution and dark skies night blight mapping provided by CPRE, which the former would have been derived from, and is referenced within our report and statement, which shows the site is already being impacted in terms of light pollution and sky glow. This mapping shows that although the application site within the AONB boundary is not a particularly dark site, as it is shown as the fourth brightest colour band, which affects the night sky impacting on the area to the south, reflecting the baseline conditions on the plateau. The CPRE light pollution and dark skies mapping indicates that the application site, together with the remainder of the plateau, already suffers from light pollution, which is uncharacteristic of a typically undeveloped AONB environmental zone E1 location. However, the lighting strategy outlines parameters to minimize further contributions to this baseline light pollution through applying the lighting requirements for an environmental zone E1. Bath and North East Somerset Council street lighting team have indicated that they will take into consideration the location of the site and reduce the requirements for street lighting so that the lighting can be graded down based on the road type with tertiary roads left unlit. The southern tree belt 30 metres and additional buffer zone 14 metres with no artificial lighting will act as a buffer to help prevent further light pollution to the darker areas to the south as required by policy B3A. The proposed lighting will be specified in accordance with best practice and the limitations of an E1 zone. All lighting will be controlled to be downward directional with 0% upward light ratio. All lighting will utilise LED light sources with warm white colour temperatures. Private lighting will be limited with only lights to front and rear of the dwellings being provided, and these will be controlled on short PIR timers. Street lighting will be controlled via a dimming strategy, dimming to 10% from 11 till 6 in the morning. It is acknowledged within the B3A policy that land was being removed from the Greenbelt and allocated for residential development, so a level of change was expected to the light generated from the site. Thank you.
Thank you, Ms. B. Conscious that that's covered possibly some points that the council has put forward in evidence, and I don't know, Mr. Morgan, if you would like sight of what's been submitted. I would certainly possibly find it useful to have a written copy of what Ms. B's just read out, but in terms of your response, anything to say?
Yeah, it goes a bit deeper than that, because some of what was said, and I need to just check Miss Prescott's evidence, which I'm trying to. I know she makes a general point about the lighting. I understand that, and her point, I suppose, was more houses, more lighting. But this is effectively a rebuttal of that, and I'm a bit disappointed I haven't seen that before, but we are where we are. So I would like to reserve our position on that. I may not need to say much, and I would like to see the documents on which it was based, just so I can check I'm not missing something. I'm not trying to make a big thing out of lighting, but it was referred to, and I would have hoped any rebuttal would have been made aware to us on that particular point. And I don't think, unless I apologise if I missed it, I don't think I've seen that.
Mr. Tucker, anything in response?
Yeah, it's maybe a point we can talk about outside of inquiry if necessary, but most of what's just been said is actually in the lighting report. But in any event, my understanding is it's common ground between us that this should be lit, if consented, as if it's an E1 area, not as if it's an E3 or E2 area. So I understand that to be common ground. Certainly I'd suggested that Ms B put her thoughts to writing, because you were bound to ask the question that you were asked. Perhaps she's been a little more extensive than I was perhaps expecting, but these things happen.
No, it's not a criticism of what's been read out. I think it's just, I'm just mindful that it covers things we may talk about later in the inquiry, and in particular the council may wish to see what's been said and consider any response.
Yeah, of course. I mean, our case is and remains, and it's no surprise or mistake. I think this is an E1 lit area. And the limits that have been identified in relation to the lighting to the southern tree belt for ecological reasons are before you in evidence. What the consequence of those are, the landscape evidence, certainly I was intending to put to the witness based upon information that's already before you. So I'm quite happy that, I don't know whether my learned friend's asking for the notes that Miss B's just read out or not, but certainly I don't see any reason why that couldn't be made available if necessary, if that's helpful.
I think I would also appreciate seeing, because there's quite a lot of information to sort of jot down, so a copy of what Ms B read out would be helpful to circulate around to the parties, including me.
But sir, the simple point is that the lux levels relates to the southern tree belt, relates to the ecological information, which is before you. The lighting to E1 level rather than E3 level is also before you, and as I understand it, is common ground between us. Those were points that I was intending anyway, in any event, to put to Ms Prescott. But maybe she's got more notice of it now.
Well, true. But yes, thank you. We'll see that note, and if there needs to be any further discussion or further clarification of points, then we can cross that bridge.
I'll ask Ms B to put that into a coherent note rather than necessarily notes that she scribbled down for her own purposes. Thank you, sir.
Thank you. Any other questions on lighting from anybody? Dr. Garnett, and shall we go Dr. Garnett first and then Mr. Hellard? Yeah, sorry. Or other way around, if Mr. Hellard wants to come up and ask his question. Oh.
So, two short points about lighting. My understanding is that multi-use paths should be lit to accord with national guidance. The path that's proposed across Great Broad Close is specifically defined as unlit, which I presume is to demonstrate that it will not represent built development, which is forbidden under policy B3A across that field. But if that path in particular is unlit, it will be unusable other than by cyclists with bright lights or walkers carrying a torch, but it will therefore reduce the sustainability of the site, the access certainly for mothers and children and people walking alone in the dark in the winter months. I wonder how those two issues are proposed to be balanced by the appellant. So the multi-use path on the one hand needs to be lit to be usable. On the other hand, if it is lit, it will be construed to be built development.
Thank you, Mr. Hellard. Anything?
I think that's really a question for Mr. Pinto rather than Ms B, because our proposal is not to light the path. And Mr. Pinto is my transportation witness who will be coming on tomorrow.
But that is correct in terms of the lighting strategy shows no lighting along that path. Is that right, Ms B?
Yeah, it's correct. It's proposed to be unlit.
And presumably that's been accepted by, has that been discussed with anyone in terms of that requirement from a sort of user point of view. Anything with the council, any discussions that have been had on that?
I haven't specifically had any discussions on that, but I believe it has been agreed. Normally, paths are discussed as in their use and timings of use as to whether they'll be lit and whether they're going to be adopted. So there's a lot of factors that are normally taken into account with that.
Okay, well, anything else you wanted to say on lighting? Or obviously we can come back to that point if... Yeah.
Sorry, I forgot to switch it back on again. On Thursday or thereabouts, you're intending to do a site visit? Next week. Normally those are done during daylight hours, but it seems to me that with phase one already largely built out, that it would be quite important to see the effect of the light loom from there, and whether you might consider in your site visit actually going after dark.
Has been made earlier this morning. Apparently, I'm being invited to go and look at it at some point in the dark. I'm not quite sure from where yet, but I will do that. So yes, that point is very much noted. Thank you. Thank you, Mr. Howard. Dr. Garnett, do you have any questions?
Just one question. B3A Placemaking Principle 5 says it has the requirement to have no artificial street lighting adjacent to the tree belts. Do you accept that phase one doesn't meet that requirement?
It isn't directly adjacent, so it kind of depends how you define that, but there is a buffer set between the two.
The buffer is the width of the road?
The exact extent of the buffer, I'm not sure to quote right now on phase one, but there is a buffer set between the road and the tree belt.
It certainly isn't 14 metres.
Say that again?
It certainly isn't 14 metres, is it?
No, it's different because there was a different requirement for phase one. Phase one only needed to achieve 1 lux at the edge of the tree belt.
Are we talking about the southern edge of phase one, Dr. Garnett?
We're looking at, yes, we are. Yes, we're looking at the southern edge of phase one. If you look at the lighting parameter plan, it's very clear that there is very little buffer. I would say no buffer.
To the tree belt, is that what you're saying? There's no buffer to the tree belt?
Yeah.
Okay.
There definitely was a buffer. It may not be as big as the buffer we're proposing on this development, but for phase one there was a buffer and the calculations were undertaken, but the requirements were different. They were a higher level of 1 lux rather than 0.4 and 0.2 lux, which we're now working to in accordance with the latest guidance.
Any other questions on lighting from anyone? If not, then thank you, Ms. B, for your time this afternoon. And then, are we happy to go on to flood risk now? I've lost track of the time. What time are we at? We've been going for about an hour, but I'd be happy to carry on with flood risk.
Yes, by all means.
Are there many questions on flood risk, I should say? Dr. Garnett. Anybody else with questions on flood risk? Because I may not have many questions of my own, so we want to carry on if we're happy to.
Yeah, but by all means, if Ms. Hunt is happy to.
Yeah,
yes,
okay.
She seems to be happy.
Introduce, yeah.
And sir, the next person speaking is Francesca Hunt, who holds a Bachelor of Science with Honours degree in Geography, and so as I said, I'll make sure this is in writing with you for tomorrow morning. A Master's degree in Environmental Waste Management, a Chartered Member of the Institute of Water and Environmental Management, and a member of the British Hydrological Society. She's also an Associate Director at Tetra Tech and Head of Flood Risk and Modelling. Is that right, Ms. Hunt?
Thank you. Hello, Ms. Hunt. So there is like with everybody this afternoon, there is a statement in the appendices to Mr. Frampton's proof, I believe, which sets out flood risk matters. And I'm aware that it's not a particular risk from flooding from any source. So that's what the flood risk assessments are showing. I think surface water and groundwater are shown as a low risk rather than none. I just want to understand why it says low risk rather than no risk.
I think the very low risk is because you will always get, for surface water, when it rains, there is always a risk of some overland flow, but the site is highly permeable, so most of the water will infiltrate into the ground, but there is obviously a very low risk in an extreme event of a flow path following the topography.
And in terms of groundwater, is that the similar point?
Similar because of the permeable geology underneath.
There's always a potential risk of both.
Yeah, we can't say that it will never happen.
And I think that the drainage strategy, I think I've read that it would match the existing greenfield runoff rate. Is that correct? It's not looking to better it, or I know sometimes with some sites you see figures that say it would be better than the existing runoff rate. Is it just matching it?
Yeah, that's correct. It's been the strategy's been designed to mimic and match the current greenfield runoff rate, noting that there's not a lot of runoff from the site because it is highly permeable.
I assume if the soil was, or the geology was more impermeable, so clay soil, then you might have a higher runoff rate already, and therefore you would be trying to reduce that.
Yeah, correct.
So I think infiltration is the in the hierarchy of drainage. That's the sort of that's the top one that's being looked at here, because it's possible, and that's presumably because of the geology allows infiltration.
Yeah, the geology allows infiltration, and infiltration testing's been done on site to confirm that is possible.
In sort of simple terms, how would that work? Is it via soakaways or anything else?
Yeah, so it'll be a series of soakaways across the site to capture the water, store it, and allow it to infiltrate naturally back into the ground.
Something that's already, is that a similar strategy to phase one? I heard this morning about, I don't know if you were here at that point, but some concerns about some of the drainage from phase one. I don't know if that's a similar approach. And
I believe it is a similar approach.
I think there was some mention made of sort of concerns about how that was. I think individual properties have soakaways. I think that's what was said this morning. Is that?
The current strategy is to have a mix of soakaways across the site. So with some at source at private properties, along roads, and just and other larger sort of features as well.
In terms of where they drain to. Where would the soakaway drain to?
Because they're designed to infiltrate, they drain to the ground.
So not discharging to any watercourse or anything
no.
Like that?
So they'll be they're sized accordingly to store a set amount of water that occurs in a storm, and then they are allowed to discharge and infiltrate back to the ground.
I may be anticipating a question from Dr. Garner, but I have read about concerns from interested parties about the underlying geology and the risk of subsidence and land instability. So I don't know if there's any. Is that something that the appellant has looked at, and if so, do you have any comments on that?
It's not necessarily my area of expertise, the underlying geotechnics involved in that. But I don't believe there was any concerns when it was investigated.
Dr. Garner, is that something you wanted to raise?
Well, I want to raise, but there are concerns, and the concerns are indicated because there's this slope stability zone along the southern edge. The initial flooding things from Tetra Tech had large swales along the southern edge, and Wessex Water said this wasn't suitable because of the underlying geology, which is full as earth, which is liable to be, I think, thixotropic is the phrase. It can become fluid and flow. And the escarpment on the southern boundary is identified in the ground report produced by Tetra Tech as being a high landslide risk. So that is why, my understanding is that is why it's been proposed that these ought to be on a plot-by-plot basis rather than individual large swales. Soakaways, yeah.
Yep, so that on a plot-by-plot basis, the idea is they mimic the current conditions on site, and you distribute the infiltration across the site to try and replicate what's happening as currently.
Please go on.
Phase 1 is referred to, and I think Mr. Frampton in his proof of evidence said surface water from the development will be managed in accordance with details to be approved by the LPA in a similar form to Phase 1. And what is proposed is similar to what was proposed for Phase 1, but it isn't what was delivered for Phase 1. This may be what the point that's been raised about concerns, is a variant went in. As I say, this is all in core document AA81. A variant went in to the Phase 1 drainage strategy that replaced it with a single very large soakaway in Derryman's Field, which has been referred to on the ecological side, and Councillor Gawley also referred to it. Now, the reason that was given to make that change was, say, this responds to the requirement to have an offset of 5 metres from structures, NHBC, which I believe is the National House Building National House Building Council, and also ensures that surface water drainage system is appropriately managed and maintained, with the previously suggested system of numerous individual soakaways requiring management from numerous individual property owners. So basically, the developers of Phase 1 thought that this drainage strategy was unimplementable. It was unimplementable with a lower density of housing of 33 dwellings per hectare, as opposed to 39.9 dwellings per hectare, which is what is proposed for phases 3 and 4. And they couldn't do it for 2 reasons that they state. I mean, I trust what they say was truthful. They couldn't do it because there wasn't space between the buildings, and that would seem to be consistent with the outline plans. And they were concerned about them blocking up and not being individually maintained, and therefore, with more hard standing, achieving surface runover and runoff, and potentially going into this instability zone on the edge of the escarpment. So, I mean, that's the situation. I'm not quite sure how, having not been able to deliver it to Phase 1, they're going to be able to deliver it for Phases 3 and 4, which has a more dense housing numbers.
Thank you. Any response? I think the question is, can
you do it?
Can you do it? Yeah. Any response, Ms. Hurd?
I mean, the outline drainage strategy we've done at this stage is deemed appropriate and in keeping with what's needed to be done. It will be, it will be assessed again at detailed design stage and in line with various, or if any, planning conditions. The maintenance is always a thing with SUDs, that you need to maintain them, so an appropriate maintenance regime would need to be put in place to ensure that they are maintained and continue to operate.
I mean, has what's been put in at Phase 1, it sounds like there's a difference in what was proposed and what was delivered, and this variation took place. Do you know how that went about in terms of any discussion with relevant bodies, and is there any monitoring of what's been put in place to see, if it's working or not working?
My understanding that there was some discussion with the water company, but when it was very, very varied, but I mean, I haven't been involved in that beyond maybe knowledge of that discussion happening.
So I don't know if it'd be useful for my witness to refer to condition 6, draft condition 6, which considers these matters. Don't know if you have. I'm sure that can be passed up. Mindful that that's an agreed condition with the local authority.
Okay, yeah, so Condition 6 outlines that, any drainage strategy gets approved at each stage through discussions with various members. So if the soakaway option, we believe the soakaway across the soakaways across the site can be delivered, and so long as, at each stage, it comes down to the approval of variation. But the infiltration testing results suggest it's okay, and so we believe that it can be implemented.
Okay, thank you. Dr. Garnett, did you have any more questions on flood?
You'll be relieved to hear that's it, yes.
Any other questions for Ms. Hurt on flood risk or drainage matters? No? If not, thank you very much, Ms. Hurt, for your time. And that brings to a close all the consultants that the appellant was presenting this afternoon. So thank you for that, Mr. Tucker.
Thank you, sir, and thank you to the 4 witnesses.
Okay, we'll turn next then to, or start to hear from the first witness on transport matters. We'll obviously take a break before that. The programme indicates that Mr. Russell will give his evidence in chief this afternoon, and then we'll come back in the morning for cross-examination. Is that still the intention from everyone? It's your witness.
So I intend to stick to the 1 hour time that I've been given. So we may try and wrap it up sooner. I appreciate Mr. Russell's been given the doom shift, so to speak.
That's okay.
Everyone's had a long day, but yes.
And obviously, as you're aware, that once we start Mr. Russell's evidence, obviously there won't be any contact with him overnight.
Yeah. Yes, so I was going to ask about that. That is the sort of standard rule. Of course, it can be agreed by you, sir, and the counsel for the other parties if examination chief is finished, but cross-examination is start with your permission. I can still discuss with the expert overnight. I would like to do that, but I'd need both the consent of Mr. Tucker and your approval, sir.
Yes.
Under the new PIBA rules, I think things have
yes,
tightened up a bit.
Previously, talking to your witness before cross-examination was considered fine. I think now the rules have become a little bit tighter. Obviously, it depends on what Mr. Tucker thinks, maybe.
Yeah, I'm extraordinarily cautious about that. As the person who led on the amendment to the change of the rules, the reason why the rules were brought into line with what happens within the county court, within the Supreme Court, frankly any other litigation, is to avoid a witness being contaminated. So, for example, having given their evidence in chief, then reflecting upon their evidence in chief, having discussed the merits of the case, then thinking, aha, maybe I want to say a bit more about that point, or retract that, or revisit that point, which I fear I've certainly had experience of. I'm not saying deliberately, but certainly I've had experience. And the notion is that once a witness starts to give their evidence, it's their untrammeled expert evidence. So I'm extraordinarily nervous about the proposition that the witness would give his evidence in chief and then discuss the merits and substance of highway witness information overnight, and then potentially revisit some of the answers either in cross-examination or at the outset. I don't know, but that's the mischief that the change was directed towards. There may be exceptional circumstances. I'd certainly have no difficulty in Mr. Neil and Mr. Russell having dinner together and not discussing the case. I completely trust Mr. Neil, and I don't know him, but I'm sure I trust Mr. Russell in that regard, or Mr. Neil to shut him up if he did. So I've no difficulty with the two of them dining together, staying in the same hotel, sharing a car, because I trust my learned friend. But in terms of discussing the merits of the case, I struggle to see that that's a justifiable exception to the rule, sir.
Thank you, Mr. Tucker. I mean, obviously, I wanted to raise this now before we got going with the evidence in chief, because obviously once we've started, there's no going back. So, anything in response, Mr. Neil?
No, not at all. I'm entirely relaxed. I'm ready to go. It's just, I was just asking permission. If that's Mr. Tucker's position, it's entirely understandable. That's why I asked. He's entirely welcome to come to dinner with us as well.
I'm not sure whether you'll be taken up on that offer, but it's noted.
Yeah, thank you.
Obviously, So if we have a sort of 20-minute break and come back at 4 o'clock, is that enough time for you? And if Mr. Russell wants to maybe get himself set up on the witness table for starting at 4, then that would be great.
That should be fine. Thank you, sir.
Thank you. Anything else from anybody before we adjourn?
No, sir. Obviously, that will mean a finish with about a quarter of an hour to go, perhaps, or 5 minutes to go or so. But that's helpful to be able to set up next door. I assume that we'll be able to do that before we leave.
That's a good point. Oh, do we? What is the cut-off point?
I don't know what the cut-off. We think about 5:30, so.
And I did have a quick look at the room at lunchtime, and it looks size-wise it should be okay, but I think you need more tables. It's all and you'll see what I mean when you look at it. But thank you. If there's no other procedural points from anybody, we'll adjourn now till 4 o'clock. Thank you.
Thank you, sir.
First question, Mr. Neal, can you see your witness? And does that matter? And yeah, are you happy with that angle, I suppose?
Yes, that's fine, sir. I can see Mr. Russell clearly.
Yes. That's
as
fine.
long as-
If that's
As
if
long
you're
as
happy
Mr.
with
Russell can see me, I think that's probably more important.
Yes, that's fine. I just suddenly realised that the angle would be.
If I could perhaps ask for some of these microphones to be out of the way so that I'm not talking to a series of... That's very helpful.
Fine. Thank you. And Mr. Russell, are you all set up and ready to go?
I am, yes, sir. Thank you.
Mr. Neal, in terms of any key documents we should have to hand from Mr. Russell, obviously the proofs of evidence for both the appellant and the Rule 6 party and the rebuttal and the two inquiry documents, the note and the extract. Is there anything else that we need to have to hand?
So yes, it may be helpful more for your benefit. I think Mr. Russell will have them to hand, but I could just run through a list of the documents that I'm anticipating Mr. Russell will be referring to. I'm assuming you're working electronically, so...
Predominantly, yes.
Yes, so would it help if I just gave you some references and then you could pull them up as and when? So the first one would be CDA 52, which is the transport assessment adduced as part of this application. Then core document G22, the transport assessment addendum dated December 2022. The next document is CDZ2, the second transport addendum. Then, depending how we get on, CDAA37, the Baines Highways response dated 29th September 2022.
Sorry, could I just have that again?
CDAA37. Those, just to be clear, so they're quite tricky to find because they're grouped according to month. So
yes,
I may have to give you some time to pull those up.
I noticed that, and I've created a whole folder for each year, so they run more. So I don't need to remember whether it was July or August or whatever.
I'll try and assist you.
As long as I know the year, that I should be able to find them fairly easily. Thank you.
I'm grateful. And then AA 71, 28th of May 2023, Highways response. Probably enough getting on with. You've already mentioned you have the various proofs of evidence, so I won't give you the references for those.
That's great. Thank you, Mr. Neal. So if you're ready, please begin with your first witness.
Good afternoon.
Good afternoon.
Good afternoon. Mr. Russell, I'm going to save time and sort of introduce yourself to the inquiry, please. I'm going to lead you through that. So your name is John Russell. You're a chartered transport planner, and you're a chartered member of the Institute of Logistics and Transport, and a member of the Chartered Institute in Highways and Transportation.
That's correct, yes.
And you have an honours degree in civil engineering, and you're a director of Motion Limited, a consultancy that specialises in transport planning, traffic engineering, and highway design.
That's
Is that
correct, yes.
Thank you. Now, Mr. Russell, you've submitted a proof of evidence to this inquiry. Do you have a copy of that in front of you?
I do, yes.
That runs to, I haven't got the total number of pages, but the main body of the proof is 30 pages. Now, you've identified on page 4 of that proof that the evidence which you've prepared and provided for this appeal is true to the best of your knowledge and belief, and has been prepared and given in accordance with the guidance of your professional institution, and you confirm that the opinions expressed are your true and professional opinions.
That's correct, yes.
Do you still stand by that?
I still stand by that, yes.
Thank you. Now, sir, as I think you may have indicated, if I may take Mr. Russell's evidence as read, but I was just going to run through a few points in his evidence in chief, obviously using the proof of evidence as a guide.
That's fine, thank you.
Thank you, sir. So, Mr. Russell, I'm just going to, by way of sort of warming up, so to speak, I'd just like to run through the network, the highways network in this area, because you're the first witness that's giving evidence on it. And I think it would be helpful, please, if you could familiarise the inspector and the inquiry with the injunctions that you're in particular going to refer to in your proof. And I think to assist, you've set out a figure of the highway network on page 24 of your proof. So that might be a useful starting point.
Yes, that's... sorry. After complaining myself that I couldn't hear. Yes, that's on, it's figure 13. It's on numbered page 24 of my proof. It's a copy from Mr. Pinto's evidence, plagiarised it. But it's a good way to start. If I perhaps start, as I'll stick to the key junctions. If I start at the bottom left-hand corner, on the Pink Road, there's a roundabout on the bottom left, which has an access into the park and ride. You've got that? Yeah, that's the Odd Down Park and Ride roundabout on the A367. If we follow that in a northeasterly direction up to its intersection with the next Pink Road, there's a blue circle around there. That's Froome Road, A367, which is that's it. So yeah.
So yes, is the next circle up to the northeast, or so we start
yeah.
off
So sorry, from the Odd Downs roundabout, I've gone straight over the first circle and onto the second circle going along there.
Is that the red line roundabout?
And that's, I was going to say, that's commonly referred to as the red line roundabout.
Okay, thank you.
From that position, if we turn right along the pink-coloured road, that's where you'll pass Sainsbury's. The red circle that I've added, that's the Sainsbury's roundabout. If we go past there, the road kinks round to the left, and there's another blue circle there. That is what I refer to as the double mini roundabout. It might also be referred to as the Esso roundabout. There's a petrol station on the corner there. Going beyond, for your information, going beyond those double mini roundabouts, following the pink line, that's Bradford Road, just for your orientation.
Thank you. Now, in terms of the chronology of the transport material and evidence that was submitted in support of the application, I think it would help if you could just briefly, in a chronological order, explain what transport assessment work, and in particular what modelling work, was carried out. Perhaps if we start with the 2017 Phase 1 application and then work our way through, I think that would be helpful.
So with the 2017 Phase 1 application, the development impacts were tested using a software called Vism, which is a network or a microsimulation model that can assess networks. So all the junctions are in the one model. The microsimulation element of it is that literally what it says, you see pictures of cars. It's not a really good analogy, but they look like maggots driving around the road network. So you can import the background mapping, and you can see the vehicles going around, manoeuvring, and so on. So that was the original planning application.
So that was the application in 2017. Now, in terms of Bain's response or highways from the highways team to the 2017 application, what response or what analysis did they give in terms of the impact on, let's just take the odd down park and ride for starters. It might be worth looking at CD AE7 if you don't have it open.
CD A7.
AE7, sorry. I should have given that as a reference to begin with.
Oh, sorry, I should have asked, sorry.
Do you have that? Could you just briefly, just so we get the chronology, so what was Bain's Highways response in May 2018?
So in May 2018, at the end of this, subject to the 106.278, they had no objection.
And in terms of the impact on odd down park and ride, perhaps if you could look at page 4.
Yeah, I mean, in terms of the odd down park and ride, the figures are predicting that there's going to be additional queues in excess of 38 vehicles. And the use of the 38 plus vehicles is because it's outside the modelled area. So it's modelled up to 38 and then it's outside the modelled area, so it's beyond 38.
The study area, effectively.
That's correct, yes.
Okay.
Yeah.
Now, if we jump fast forward, please, to 2022, when this application was submitted, can we just confirm what modelling was done, or what kind of modelling was done in the transport assessment that was used for this application?
So with this application, with the 2022 TA, the modelling approach was to use the Transport Research Laboratories Junctions software suite, and that looks at junctions in isolation.
And just so we're clear and so we can get our bearings for when we look at the appellant's modelling, could you just explain, please, the difference between junction modelling or standalone junction modelling and network modelling, just in broad conceptual terms?
So broadly, sir, with a standalone junction model, it looks, as it says on the tin, it will look at a junction in isolation. And one of the weaknesses of that is that it doesn't take into consideration queues. Basically, we talk about queues stacking vertically. Because it's mathematical, it just says this is the queue, and it doesn't consider any other part of the network or any obstructions. It just says this is what the queue is. Also, it could be very difficult to replicate platooning arrival rates. Platooning arrival rate. So if you've got a downstream junction and traffic is stuck there, it will all suddenly come to the next junction and potentially cause a problem. the key thing is that with the standalone, you've got to be 100% confident that there is no interaction with other junctions in the road network. In terms of network modelling, that would take into consideration queues, arrival profiles and so on at neighbouring junctions, and it will also take into consideration any constraints on the sections of road between the junctions as well.
Thank you. So that explains the difference between the two types of models. Now, in terms of when you would use a network model as opposed to a standalone model, could you assist the inspector on that question, please?
I mean, there'd be two reasons why you would use a network model. One would be if you're looking very broadly at big areas, for example, assessing a local plan impact, you'd be looking at big areas. In terms of development, it would be if you were concerned that there was interaction between the junctions, either directly or indirectly with traffic flow.
Now that's the difference between a standalone and a network model. Now briefly, there's reference in the transport assessment material to a VISIM model. Could you just assist, the inspector may be familiar with what VISIM is, but members of the public and other people attending the inquiry might not be. Could you just sort of in a nutshell explain what a VISIM model is? Is it a network model? Is it a standalone model? What is it?
Obviously, we can't do that because that would undermine our expertise and experience if we did it in a nutshell, but I'll try. The microsimulation model that would normally used on a network, and it models individual vehicles, and you get a visual interpretation of what those vehicles look like moving around the network. Particularly good uses are congested urban areas, where they're not just junctions, there'll be buses stopping, there's pedestrian crossings, there could be other road users that you'd model, and you would put all this data into the microsimulation model, of which VISIM is one bit of software. So VISIM is a proprietary software for a microsimulation model, and there are other softwares as well.
Thank you. Now, when Baines Highways responded initially to the 2022 application, in their initial response, are you aware of what their initial response is, and can you just, perhaps without getting into it in too much detail, could you summarise what that response was? Just so we get the chronology right.
I believe that's AA 37.
So just so I heard, AA 37, is that right?
I believe that's their response, yeah.
Yeah.
I did have it open.
Yes, that's their response, September 2022.
September AA, found it, yeah. So if you got open, so yeah, if I take you to page 4 of that response, and then 1, 2, 3, 4, take you to the 5th paragraph from the bottom of that page, and it starts capacity analysis. Yeah. And here the Highway Authority are saying that the analysis has been undertaken using standalone junction modelling software, but they had actually asked for it to be done using VISIM software. In particular, they recommend it should be used to understand properly the impact of the development and how the junctions interact.
And do we see that fourth, is it the 4th paragraph up from the bottom? Perhaps you could read the the final sentence of that response?
So the final sentence of, which bit, sorry?
On page 4.
On page 4.
Four paragraphs up from the bottom, final sentence.
1, 2, 3, 4. That it says there is no justification in the submission for its exclusion or why standalone capacity models have been chosen.
Thank you. So we then, taking things on, as I understand it, we then have in response to that, the TA addendum, and I'm going to lead you on this to save time. That's at core document G22. So December 22, we get the TA addendum, and just in a nutshell, what was Tetra Tech saying at that point in response to the Baines Highways observations made that you've just read out in September 2022?
Sorry. Is this G22?
Yes, the TA addendum, December 22.
Yeah, so if I were to take you to we'll get there, 93 pages. Right, so it would be PDF page 77, sir. Yep. And that section deals with junction modelling and VISM. Section 12, that's right, sir, yeah. And that goes through the explanation of why VISM's not being used. If we come down to 2.126, which is on 80, PDF page 80, the argument put forward is that the VISM model that was used for the 2017 application is out of date and so no longer useful.
Okay. And we'll come back to that in a moment. Just I think that's the chronology up until we then have up until December 2022. Now we then have a further response from Baines Highways in May 23, and just in a nutshell, just so we get the chronology right, what then happened in terms of Baines Highways position?
Yeah, so the highway decision turned round. I haven't got the core document reference for that.
I think it would help. Just AA81 is the Baines response, May 23. Is that the document we wanted to refer to?
Yeah, 26th of May 23.
Yeah.
And if you turn to page 6 of that.
Sorry, just the reference again,
AA81.
81 is the south of Bath Alliance.
Oh, sorry, that should, if that's, maybe giving you the wrong one.
71 perhaps?
71, do apologise if I've
okay.
made a wrong note.
So there's a heading there. Oh, sorry, PDF page 6, sir.
Okay, the last page.
Yes.
Apologies, yes, it's
6 or 6. Yeah. Traffic impact assessment heading.
Yeah.
It says there, HDM previously queried why the odd down VISM model had not been used. Goes on to say the applicant has provided justification within Appendix B of the submitted transport assessment addendum. That's the December 22 document. It goes on to say, citing age of the model, unrepresentative traffic flows and queue lengths, and unrealistic trip rates. HDM accept that the standalone modelling utilised in the assessment of the proposed development is acceptable.
Now, I'm not going to take you to the further second transport addendum and the further Baines response. and I'm going to lead you, but as I understand it, Baines Highway's position didn't change, just so we get the chronology right, didn't change fundamentally from the position set out there, is that right?
What, from May?
From May onwards.
From May 23 onwards, their position didn't change, and you see the similar text repeated in their responses.
Now, in terms of your work on this case, so could you just confirm when you were instructed by the parish councils?
I was instructed in September 2024.
Now, at the point of your instruction, could you describe what work, in terms of highways assessment, the parish councils had commissioned at that stage?
So at that stage, sir, the parish council had already commissioned a report which is referred to as the Alan Bales report, and that is Appendix C of my proof of evidence.
Now, again, in a nutshell, just so we have the documents in the right order, what did the Alan Bales report contain, and what was its ultimate conclusion?
So the Alan Bales report contained summaries of the drone footage and connections to it on YouTube for people to see. In terms of, and I'll be clear here, I've only looked at the modelling element of the Bales report because I don't pick up any of the other matters in my evidence. But the Bales report, it flags up errors in the standalone modelling. In particular, it flags up, based on the surveys, that the queues coming out of the standalone models, or that the models were predicting the base queues, weren't credible compared to what was being seen on the road.
The base queues that the model was predicting, or demonstrating, not the actual observed. Is that?
Well, the base models, to be credible, should replicate what's on the ground and what's observed on the ground as a starting point. Yeah. You then start forecasting and looking into the future. But the starting point is you have a base which is a model. It replicates what's there at the moment. And so the Bales report was concerned that, based on the survey evidence that SOBA had procured, the models weren't showing queues and delays as they were being recorded.
And what actual surveying work did Alan Bales carry out?
So the survey work was drone footage. So they had they surveyed 2 junctions, the odd down park and ride junction during the morning rush hour, and the red line during the evening rush hour. And they were surveyed by drones, looking both at the junction, so the cars entering and turning, and also at the queues and the approaches.
Now, just looking at the analysis, that the adequacy of the analysis that the appellant has carried out in terms of their modelling, so the adequacy of their modelling, let's just take odd down roundabout first of all. So just so we get our bearings, and it might be worth you just reading out paragraph, or having regard to paragraph 3.16 of your proof. At the odd down roundabout, what was the base model showing, or the appellant's base model showing in terms of queuing? 3.16 of your proof might be the most useful starting point.
Yeah, so from 3.16, and I've taken the results from the TA addendum 2, second addendum, at 8 a.m. The standalone model shows 1.1 vehicles queuing and an average delay of 5.4 seconds.
And when you, and I think that was the 5.5 seconds we actually heard earlier from Mr. Garnett, is that right? When he was giving a
Yes, well, he referred to my third bullet there, sir, 3.163, that the maximum queue across the peak hour, and this to be clear, sorry, this is on the approach from the south towards the roundabout, heading into Bath. Yes, sir. Was the maximum delay was 15.5 seconds.
Now, you also mentioned at 3.16 that the base models show the use of throughput rather than demand traffic flows. Now, it's late in the day, so I don't want to get everyone confused, but just taking it slowly, what do you mean by that? What's the difference between throughput rather than demand traffic flows?
If I start with demand, that's slightly easier. Demand is the total number of vehicles wanting to get through a junction in a specific time slice. So you might say 10 minutes, there are 100 cars want to get through that junction. The throughput is what actually can. So there might be 8 cars can get through the junction in that time period, and you end up with 2 queuing, or 2 can't do it. In terms of, if I try and explain how when you count, it's not rocket science, when you count cars at a junction, the standard count, so at a roundabout, it counts a car crossing the give-way line, entering the roundabout, and then records which exit it left at. So that's the throughput. So it's the number of cars that do actually get into the junction, who can actually get in the junction. Demand is the number of cars that would want to get through the junction in the same time period.
So in terms of that point then, so when you say the use of throughput, so you're saying the base models used throughput rather than demand?
Yeah, so it's the observation of the cars that are actually going through the roundabout. So by default, the model should say there are no queues, because this is the observed volume of traffic going through.
So we'll come back to that, but in terms of your reaction when you saw, just taking the odd line roundabouts, we're on it now, when you saw that, having been instructed in the case, and you saw the output modelling results in the TA, and those delays that we've seen, 15 seconds for odd down, and those length of queue lengths, what was your reaction when you saw that appearing in the
I was quite taken aback, actually, because I'd seen the site, I'd seen queuing traffic myself, I'd seen the YouTube videos of the recordings of the drone surveys, and the standalone junction model results just didn't seem to align with my own observation and the survey observation we had to a very high degree.
Now, in your evidence, you, at section 4, you have queried and I'm summarising, the use of standalone models in this case. Now, can you just please, in a nutshell, explain why, in your view, you don't think a standalone modelling approach is appropriate here? I mean, we could go through, I won't ask you to read all of your section 4.1 to 4.13, but in principle, why do you say here that is the wrong type of model to use?
The main reason why I think there should be a network model and a microsimulation model is because of the interaction of traffic between junctions. but also it's an urban area, it is a congested area. There are lots of things between the junctions as well, which cause problems with traffic. And a microsimulation network model would have been perfect to measure and record how the network currently works, rather than looking at each junction in isolation.
And could I just take you to your analysis at 4.7 of your proof, where you analysed the appellant's rationale for not using a VISIM model?
Could
you just briefly comment on what the appellant's rationale was and what your response is?
The rationale that the model's old is correct. It's on data, it's 2017 application. The rationale said it was based on 2014 traffic data, and that sounds absolutely right. Traffic conditions will have changed. However, my answer to that would be to build a new VISIM model.
And at 4.8 of your proof, you note one of the reasons put forward by the appellant is that standalone junction modelling is appropriate with all junctions operating priority control and significant travel distance between junctions. Could you just perhaps read out what you said at 4.9, please?
Basically, I've been unable to identify the analysis that the appellant has done to justify that the junctions are sufficiently far apart, that the queues don't interact. My on-site observation, and also the survey, is that there is traffic blocking back between queues. In terms of the distance, there's no defined distance beyond which the use of standalone models is appropriate. It comes down to a site-by-site basis. And in particular, the appellant appears to have looked at the queues coming out the models and said they're not interacting. Whereas it's the base, we can record what the queues look like, and we haven't presented it in evidence of what the queues look like. We can go out and look at them and see what the queues look like and see whether they interact.
So just before we leave the question of distance, there's reference to distances between 55 metres to 630 metres. I mean, what's your view on where is that distance of 55 metres, first of all, and is it significant in your view?
I measured these, so I'll trust them. The 55 metres is down near Sullis Manor. If I take you back to my figure 13, you can see the junctions that have been measured. So the blue rings are the junctions that have been assessed, and all I've done is I've measured the distances between these. So the 55, the shortest one, would be from South Downs, Odd Downs Park and Ride eastwards, and then the longest distance is between the junction just north of Odd Downs and up to the Red Line.
Thank you. Now I'm good. Moving beyond the question of network modelling as against standalone, just like to briefly touch on the issue of calibration of those models. Now there's been discussion in both proofs of evidence, yours and Mr. Pinto's, about calibration. But just firstly, taking things in stages, what do you mean by calibration? And it might be helpful if you could refer the inspector to your paragraph 3.3 of your proof, where you've referred to the tag guidance.
Traffic modelling isn't any different to any other modelling in this respect, sir. You establish a base model. You put it together, you then have to test it to make sure it replicates the existing conditions so that it has any kind of credibility. In terms of traffic, so the Arcady software that was used, and any of the traffic software, is standard software. Once you've built your model, whether it's standalone or network, you then have to make sure that the model is operating in a way that reflects the local conditions. So, for example, if you're approaching Odd Down roundabout from the south, if you just put the dimensions in of the lanes, it's a 2-lane approach, and you would put that into the model, but you then have to tell the model that actually 1 lane is right turn only. So the left-hand lane is straight ahead into Bath, and then the right-hand lane allows you to run. So that you would then have to tell the model, calibrate it locally for these features. Or it could be a poor radius, for example. So it's making sure you build your model and then you make sure that the geometries that you're putting into the model are giving you the results you would expect.
No, that's geometries. In terms of other things that you do, it might be to calibrate a model. Perhaps if you can look at 3.3 of your proof.
Yeah, so if I take you to 3.3.
And look at those 3 factors. I think you've referred to geometry, but what other things would you look at?
Yeah, how do you know? The question is, how do you know if it's operating how in accordance with local conditions? You would look at queues. Is the model predicting the queues that you see on site? You could look at journey times. Is the model predicting the journey times? So you would collect this data, compare them with the model outputs, and if they're widely different, you then go back to calibrating the model, putting in changes until you get the base model operating in accordance with the observed data.
Now, you mentioned observed data, and we know that the appellant in one of the disputes between you and Mr. Pinto is the extent to which there has been observed data provided in the assessments and the evidence. I mean, can you just explain how the appellant, or how you understand the appellant sought to calibrate its model, and whether or not that observed data is available and to this inquiry?
My understanding, sir, is that CCTV footage has been viewed, but it isn't before this inquiry.
Now, you mentioned that the appellant says it's reviewed the CCTV as part of that exercise. I mean, in principle, what's wrong with looking at CCTV when building up or when calibrating a model?
In principle, there's nothing wrong. The only challenge with it is that if it's not quantified and put in a format that's accessible, there's no third-party scrutiny of it.
And so, just in this, why you referred in your proof to the lack of quantified observed data. I mean, can we just be absolutely clear? Why is that important rather than just relying on an assertion that CCTV has been looked at?
Well, you have something written down that you can say, this is what the model says, and this is the observed. And, you know, they won't be identical, but you can take a view on whether they're within the accepted tolerances.
And to assist the inspector understand why observed quantified data is important, I think you've referred to your proof at the TRL specific modelling advice at 3.5 and 3.6, and you've produced an extract of that at Appendix A. Again, in a nutshell, I don't want to take up time going to it, but what does that say about calibration? And well, first of all, what is that TRL modelling advice, and what does it say about the use of that data?
So I refer to advice from TRL, who are the authors, and they maintain the software. In fact, did the original research that feeds into it. So I refer to that in my Appendix A, and it gives ideas on how you would use queues to calibrate your Arcady models.
And it might be worth, do you have 3.6 of your proof in front of you? It might be.
I do, yes.
Could you just perhaps read the first sentence of that, please?
Yeah. So the first sentence there's the primary metric that TRL guidance refers to in order to calibrate a model is through comparison of modelled and observed queue lengths.
Thank you. Now, so we've looked at I think the two main issues in dispute: use of network modelling, calibration. I'd just like to understand what your response is to the points raised in specific points raised in Mr. Pinto's rebuttal. Do you have that in front of you?
So I'm just finding it. Yes. Yep, got it. Yep.
Mr. Pinto, in his rebuttal, has looked at the Alan Bales, the drone survey, footage, and one of the points he's making is that, and I'm summarising here, that.
Where's this, Mr. Neil?
Sorry, this is Mr. Pinto's rebuttal.
So, yeah, just which page or paragraph? I think yes, one can see paragraph 2.33. It said that the information presented by motion transport proof of evidence is problematic and does not suggest queuing, but rather slow-moving traffic in the AM peak. Do you see that, Mr.
I do
Russell?
that, 233, yes.
And so do you have that reference now? Yeah. And then we have, without going through it all, he's looked at all of the drone footage. I think he's gone to he's also looked at some of the Sabre drone footage. Now, just first of all, before we even get to looking at what that drone footage says, in terms of just basic stuff, what is a queue, and what does Mr. Pinto understand as a queue? Are you and him in agreement on that, or is there a difference between you as to how you actually approach the question of what is a queue?
I think there might be, this might be the nub, sir. I think there might be a difference in opinion of what a queue is. So my definition of a queue is the same as the Junctions 9 definition of a queue, which Arcady forms part of Junctions 9. That's the Arcady, yeah. And that is that queues include slowly moving vehicles as well as stationary vehicles.
So where is this being read from?
This is the Junction 9
It's the user
marketing
manual.
software.
Where in the evidence is this being read from?
It's your client software modelling that
No,
both
where
parties
in the
have cited
evidence so that I can read it? I'm not a transport engineer. Where in the evidence is this being read from?
Well, perhaps if I can answer, it's the user manual that everybody using Arcady uses. It's
in the note that, or the
No,
extract.
it's not. It's not in evidence. It's the modelling, the software guide that the appellant's been using. So they'll be very familiar with it.
So anybody proficient in using the software knows
Okay.
that's the definition.
But Mr. Tucker's point is that that's not in the evidence before us.
Yeah, my point is a really simple one, that this is not about pulling rabbits out of hats. If the definition of a queue is being raised as an issue between my witness and this witness, which it now seems to be for the first time, then it is important that we know exactly what the definition is. For example, I don't know whether there's anything around this particular wording. My witness hasn't been given any notification, despite the fact the rebuttal's been in the public domain for 2 weeks, and also, no, 10 days, forgive me, and also we've had additional information submitted by this witness. So I would like to see the documentation that's being read from so that I can take instructions upon it before I ask questions about it. This is not an environment where you pull rabbits out of the hats with respect to my learner friend.
So if Mr. Tucker would like to reduce his own client software guide and that page and put that to Mr. Russell in cross-examination, I have absolutely no difficulty with that. It's a reference that Mr. Russell's made to the appellant software guide.
Mm-hmm.
They'll be very familiar with it. Absolutely no objection to Mr. Tucker putting that to Mr. Russell.
I'm not sure if Mr. Tucker wants to produce that evidence or whether he wants Mr. Neil.
Firstly, my client is not TRL. In fact, they have been in the past, but my client is actually the Hignett Family Trust, so it's not my client. Secondly, the guidance note that's been referred to is, I'm told, 230 pages long, but I'm entitled to be able to see documentation before it's been raised in chief about an issue which is now said to be an issue between the witnesses. It's as simple as that. If my learner friend's seeking to introduce this evidence, I would like to see the document on which it's based, or rather, at the very least, an extract from the documents.
Absolutely.
Hold on, I've not finished.
We'll provide
I've not
that.
finished.
We'll provide
You,
that
sir,
tonight.
asked the question at the start of this morning, are there any additional documents to be produced? You're now having one read into the inquiry, and that's not proper. So I'm not objecting to this being led in, but I would like to see the document,
Absolutely.
and I would like to take instructions upon it, and I would like to know if there are any more rabbits coming.
Well, Mr. Neil, I think it probably would be fair for the Rule 6 party to indicate where this reference comes from in that software guidance.
Yeah, perhaps Mr. Russell, it's his evidence, so perhaps he could,
if he's able
if he's
to,
got that reference, and we can provide it.
Just to reinforce, it's not guidance, it is the user manual. It's how to switch the computer program on and use it, which anybody who uses Arcady knows.
For the benefits of, obviously, of everyone in the room, and do you have a reference to hand right now, or?
So, I mean, if it assists, there is a reference in, this is something that Mr. Pinto will be familiar with, because he's referred to the definition of queue within Junction 5 at 3.71 of his main proof. So this is not going to, that's why I didn't think there'd be any issue in Mr. Russell commenting on that definition. 3.71. Another matter is the definition of the queue within Junction 9s, which is a stationary vehicle and not a rolling queue. That's Mr. Pinto's main proof.
Obviously, just a précis of that. It's not
Indeed.
It's not the actual reference. So I think if that can be provided.
Absolutely.
Mr. Tucker.
And sir, that makes the point even more egregious, because if this is responding, and you can't just read that out of context, you need to read what follows on from it. If the point is meant to be a response to a proof of evidence that was submitted now 3 weeks ago, then it should have been put into a rebuttal if it's suggested that my witness has inaccurately assessed what a queue is. So I do repeat my point. If a part of a document is being relied upon by this witness to suggest that my witness has now got it wrong, then I would very much like to see it.
Obviously, now that Mr. Russell has started to give you his evidence, officially there's no communication, not even unofficially, there is no communication on this between you and him. So how's best to make sure that reference is provided? Is that something Mr. Russell can do?
Well, I'm sure Mr. Pinto will have access to it.
But is Mr. Pinto confident that he knows where that reference is?
Well, you asked a couple of moments ago and you weren't answered whereabouts in the document is it. So if we can know what whereabouts in the document it is, then maybe I can take instructions upon it.
Sorry. Let me just open it. I'm just trying to find my copy of it, sir. Hold on. Right, so that exact quote will be on PDF page 93. 93.
And to be fair, that's from the software manual.
That's right, yeah, from the user manual.
From the user manual.
Yeah.
Page 93.
It goes through definitions of the inputs into the Arcady model.
Does that help, Mr. Tucker?
I don't know, sir.
Okay, is that enough for now to be going on with?
The Junction 9 TRL Arcady Model User Manual, latest edition, page 93 of the PDF. I'll take instructions upon that overnight, sir.
The document reference is in the additional note that we put in this morning. Yes, I haven't got that open.
ID 1 or 2, I forget now.
Yeah, I don't have the reference for it, sorry, sir. But it's the one that the front cover is TRL Software Junction to 9 User Guide. ID 1, thank you.
Thank you, Mr. Russell, for explaining where the definition of queue is to be found in the Arcady software guide. Now,
but then I'll just clarify that is an industry standard.
Yeah. Now, when looking at what Tetra Tech has said or what Mr. Pinto has said about what the drone footage shows, and going back to his rebuttal now, I was at 233, he is saying that it doesn't suggest queuing.
Sorry, what's the reference from the rebuttal?
2.33 of the rebuttal.
Yep, sorry, I'm still there.
He suggests it doesn't suggest queuing, but rather slow-moving traffic. Now, this was appeared for the first time in his rebuttal document. What is your response to that conclusion that he's drawn in relation to the drone footage?
In all the years I've done junction modelling, slow-moving traffic is a queue. If queues were stationary, nobody would ever get anywhere and the roads would be clogged because permanently queues move. It's in the nature.
Now, you've put in some snapshots of the Red Lion roundabout in your technical note. Apologies, I don't have the ID reference. It's the ID. It was submitted this morning. ID 6. ID 2. I'm grateful. So ID 2. That's your technical note. And could you just briefly explain why you felt this would be helpful to adduce to the inspector, and what conclusions you draw from the images that you've exhibited or referred to in your technical note, please?
Well, the reason for it, sir, is at 2.33 onwards of Mr. Pinto's rebuttal, there's an implication here that these images show cars that are moving quite quickly. If I take you to 2.33 and the third bullet on PDF page 13, I think you're still there, of the rebuttal. Traffic will inevitably slow and group due to the speed limit change from 40 miles per hour to 30 miles per hour. I couldn't quite believe, and I may have misunderstood this, and I'm sure I'll be picked up on it if I have. Having watched the drone footage myself, been on site and seen the traffic, these cars are certainly not moving at that speed. I'd call it a queue on the left-hand lane. So all this was we took one snapshot, 2 seconds apart, to show that the cars were close and they weren't driving very fast.
Now, another point Mr. Pinto's made in his rebuttal, he says that you've referred to a 1980s source document called the traffic capacity of roundabouts. Do you see that that's at 2.17 of your of his rebuttal?
Yeah, just give me a moment. I wish I'd printed this off. 2.17, yes,
2.17.
Yeah.
He says Mr. Russell makes reference to the 1980 document traffic capacity of roundabouts, and then says in the next sentence, it's inappropriate to draw guidance from such an obviously dated document due to its reliance on traffic studies conducted prior to 1918. Have you any comment to make on that?
I mean, the
criticism made of you by
the
Mr.
1980 research was funded by the then Transport Research Laboratory that morphed into the TRL, who developed the junctions models, including Arcady. And the research, this 1980s research paper, was done by a gentleman, a team led by a gentleman called Kimber, and it continues to be used today to underpin the Arcady model. Was it ID1, the new documents we've put in?
Now,
I was going to say, if I could just take you to the it was ID, yeah. Yeah. We've given you the extract there, just so there's no doubt. This is more the theory of it rather than the user side of it, which is why we've included this and why we didn't include the queue definition, because that's really entry-level stuff. But here it's really clear here, if you read it, it says a fundamental feature of the Arcady model is the equation relating to entry capacity. For standard roundabouts, this is formulated in LR 942, which is Kimber 1980, and that's the document that I have I refer to in my evidence, and which in his rebuttal, I've lost it again. In his rebuttal at 217, Mr. Pinto makes strenuous efforts to say is no longer relevant, whereas in reality it underpins Arcady to this day.
Now, at paragraph 2.28, in Mr. Pinto's rebuttal, he says it's telling that no footage was provided for other time periods, suggesting there are no concerns during those times. So, in other words, times outside the peak periods. How relevant is the peak period analysis as compared to analysis in the rest of the day?
Well, my starting point would be that the reason why we've picked those peaks is because that's the peaks that were being assessed in the Transport Assessment, the Transport Assessment Addendum 1, the Transport Assessment Addendum 2, and also which are included in the Highways Proof of Evidence. These are the weekday peak periods. Now, in terms of transport assessments, we are always asked to assess the peak periods, and it's the peak hours that we assess, irrespective of what happens during the rest of the day. different types of land use. You'll appreciate the peak hours may not be 0800 to 0900 if you do a tourist application, for example. But in terms of residential, we are always asked to demonstrate the impacts or to understand the impacts during the weekday peak hour periods, which is why we've done the weekday peak hour periods.
Another criticism made of you is that, again, in the rebuttal, that's why I'm focusing on this, because it's appeared in the rebuttal evidence, it suggested that you haven't asked for the data, or that there was in some way a failure on your part to ask for the requisite data from Mr. Pinto in your discussions with him. I can give you the reference. Apologies, I haven't quite found it, but could you just, in a nutshell, explain what information you have sought from Mr. Pinto since you were being instructed in prior to the service of proofs of evidence?
So with the statement of common ground, I was trying to insert a paragraph that confirmed there was no quantification of Q data available. That paragraph was repeatedly deleted by Mr. Pinto, leading me to believe that there was some information there. There's thousands of pages, and hands up, I could have missed it. But it was just last week, 2 weeks ago, Mr. Pinto confirmed by email that no such tabulated or quantified data was available, but still deleted my suggestion in the statement of common ground that was an agreed position that that data wasn't available.
Yeah. And just to be clear, so I missed the reference. There's a suggestion at 2.58 of the reference I was trying to pick up is no request by have been made by motion to obtain these outputs, despite repeated efforts by Tetra Tech for meeting to discuss the appeal.
To be fair, that is I guess I've gone about it passively by asking for confirmation they don't exist, rather than asking for them, if you see what I mean. In the statement of common ground, I thought it would be common ground that this information doesn't exist.
Now, what are the...
Sorry, Mr. Neil, just conscious of the time. How are we doing on...
Sorry, we're nearly there.
Okay.
There was a little bit of a
threesome between me and Mr.
Tucker.
But if we're nearly there, then
I'm going to wrap it up.
That's the best answer to any journey, I think.
Okay. I've got nowhere to go tonight, so
Fine.
I'm
Okay.
Burder.
Thank you.
Yeah. Now, we heard in the opening submissions of Mr. Tucker that there was criticism of the parish council's position in terms of highways because, and I made a note, but I may have misquoted precisely, but there was a suggestion that 15 days worth of CCTV had been reviewed by AECOM. Do you recall that?
That was this morning,
reference?
yes.
Where?
I believe it was 14 days.
Or 14 days, sorry.
Which is what I said.
14 days. Where in the evidence or in your review of all the material have you seen that, or when was the first time that was ever suggested had been carried out?
I guess, just to clarify on it, that's the first I've heard of 14 days of AECOM data. And it simply isn't before us, sir.
And just finally, in terms of policy, you've set out at the back of your proof, and I'm not going to take you to it, where you say various conflicts with, I think, local and national policy occur, in your view, and I'm not going to ask you to repeat that, but if, on the hypothesis that the inspector considers that the modelling underpinning the transport assessment is inadequate, in policy terms and in compliance with national policy, what would be, in your view, the consequences of such a finding by the inspector?
Well, the policy 118 NPPF requires developments like this to have traffic modelling, transport assessments, in order to demonstrate what the likely impacts of it will be. The baseline traffic models underpins the rest of the assessment work, and that goes to the sustainable travel. For example, it could be that there are impacts on the road network, but the highway authority, the planning authority, is willing to accept those and put contributions into sustainable travel instead of building more road. However, it's still critical to understand what that level of impact is in order to understand the level of mitigation that's required. Be that cycling facilities, pedestrian facilities, public transport, or it could even be revisiting the land use mix, but that's not my area of expertise.
Thank you, Mr. Russell. I appreciate it's late in the day. Is there anything else you want to raise in your evidence in chief before we close for today?
No, I think we've covered everything in my notes. Thank you.
Thank you very much, sir. No further questions for Mr. Russell.
Thank you, Mr. Neal. Thank you, Mr. Russell. Thank you. So tomorrow we will resume with cross-examination of Mr. Russell, and we will. I think we've indicated we'll start that at 9:30. And obviously, yes, as you know, Mr. Russell, this evening you cannot have any discussions with your team. Okay, so obviously you understand. Thank you. In terms of any procedural points now, so obviously, well, just a quick run through for the documents that I'm expecting over the next day or so. There was in reverse order from chronologically, there was Ms. B's note, or version of Ms. B's note. There was the map showing the Tynings land. There was the map of the SNCI, the supplementary advice note from Natural England, and then right at the beginning of today was the note on the status of the comprehensive master plan in core document R10. And that's obviously, I think that's everything, unless I've missed something.
Yes, so I've also got Historic England's rejection of the listing for Sulis Manor.
I missed that.
And having checked it, sir, my understanding is that the status of the landscape plan R10 is now agreed between the council and my clients to be for determination now. That's what's set out in the schedule of conditions. But I'm sure that can be condensed to a note if you require additional note beyond that, sir.
Any discussion with Mr. Neal as well on that, or is that really a matter for the?
Oh, there has. Sorry.
Has the Rule 6 party been involved in any discussion on the status of the comprehensive master plan?
Not that I'm aware of, but I can take that up with.
After we finish today, maybe a quick word on that, and we can pick up again in the morning.
So could I just clarify what I misheard? The acoustics are very bad in here, so I can't hear.
This morning, obviously, I was asking about formal plans, and I wasn't sure whether the comprehensive master plan document R10, what the status of that document was, because it's not listed in the decision notice. Mr. Tucker has just indicated that the appellant and the council are content for that to be a formal document, formal plan.
Yes, sir. I just infer that from the schedule of conditions where both parties have said yes, that they are agreed to that being a determined plan for this stage. I don't know if there have been further discussions behind the scenes.
There's going to be a discussion this evening. Yeah. Thank you. Yeah.
I just wanted to make sure that the Rule 6 party at least had the opportunity to comment on that. So if that's something to discuss after we adjourn, then we can leave it there. Thank you. So, yes, that's everything there. No, any other documents we're expecting from anyone else? We have the reference now for the Arcadis software manual, user manual. So I don't think there's anything else. But any other procedural points before we adjourn? Anything else, Mr. Tucker, from the appellant?
Nothing as yet, sir.
Mr. Morgan? And Mr. Neil, anything else from the Rule 6?
No, sir.
No, thank you. Or anybody else in the room? If not, then I think we will, I think the idea is obviously people want to move their things now to the other room, beginning with K, that name escapes me. We can do that now for people who want to do that. And obviously the plan is to start there tomorrow morning at 9:30. And we'll be live streamed again, so I assume there'll be the IT set up and everything for then.
And thank you, sir. And looking at the programme, it's essentially transport tomorrow. Yeah.
If we have time, the programme indicates evidence in chief for Ms. Prescott. It will obviously be the same arrangement as today in terms of overlap overnight. But if we have time, then we can do that, but we can review as we go along tomorrow.
Yes, sir. I think that's realistic.
Okay. Anything else from anyone else on the programme or anything else? No. Okay, well, thank you all for today, and we'll adjourn until 9:30 tomorrow. Thank you.
Thank you, sir.